ಹಾ ಹಾ ಅಲ್ಲ ಅದಕ್ಕೆ ನಾನು ಹೇಳಿದೆ ಪಾಪ ಇವನ್ ತಲೆ ಮೇಲೆ ಗೂಬೆ ಕುಣಿಸಕ್ ನೋಡಿದ್ರು ಇವರು. ಆ ಅದಕ್ಕೆ ನಾನು ಹೇಳಿದೆ ನಿಮ್ ತಲೆ ಮೇಲೆ ಹಾಕಿದ್ರೆ ಬೇಡ, ಐ ವಿಲ್ ವಿಡ್ರಾ ದಟ್ ಅಂಡ್ ಗಿವ್ ಫ್ರೆಶ್ ಅಪ್ಲಿಕೇಶನ್ ಕೊಡಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಆ ಪ್ಯಾರ ಡೆಲಿಟ್ ಮಾಡ್ಕೊಡು ಅಂತ ಹೇಳಿದೆ. ಆಮೇಲೆ ಪಾಪ ಇವ್ರಿಗೆ ದಾಂಬೆಗೆ ಅವ್ರು ಆಯ್ತು ಅಂತ ಹೇಳಿದ್ರು. ಅವ್ರು
My lord, this honorable court has passed an order dated 28/25. In at para number 12, instead of counsel for petitioner, it is mentioned as counsel for respondent number 5. Hence, filing this memo for the modification of the order.
ವಾಯ್ಸ್ ಬರ್ತಾ ಇಲ್ಲ. ಏನು ವಾಯ್ಸ್ ಗೊತ್ತಿಲ್ಲ. ಎರಡನೇ ಕೇಸಿ
20? You still have time, isn't it? Let come on Monday. What difference does it make? Wait till till the Monday, 17th. 17th.
So, in the affidavit also it was stated that after obtaining the to construct the so now they are obtaining the road plan. So now they are
BBMP. Survey copy and found common and then. Yep. ಬರುತ್ತೆ ಯಾವಲೊಂದು ದಿನ ಕೊಡ್ತಾರೆ. ಯಾವ ವರ್ಷದ್ದು ಹಳೆ ಮ್ಯಾಟರ್ ತಗೊಳ್ತೀನಿ. I'll get it posted. ಎಲ್ಲಾ ಮ್ಯಾಟರ್ಸ್ ಲೈನ್ ಬರುತ್ತೆ ಕೊಟ್ಟು ಕೊಡಿ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರುತ್ತೆ.
One fresh matter next week anytime.
Because it's a permission to withdraw the reputation. I've requested reputation dismissals with the vertical. You didn't deposit the amount. That's why I don't grant interim orders. Next time I'll be careful. What do you want? Yavatge. It's serial number? And comes for the petitioner 6 permission to withdraw the application. As requested, petitioner dismissal.
For adjournments, page number 17, seal number 84 to 89.
89.3, my lord. 89.3, 4 and 5, my lord, appear per respond Praveen Raikote, my lord. Pray for 2 weeks time, my lord.
We inform them.
I am not informed.
They are barely regulated matter.
Please.
Serial number 71. Respondent counsel, mother-in-law has expired last week. Therefore, a week's time in.
Serial number 79. Lads ಇದು ಅವರು ಇದು ಕೊಡ್ಬೇಕು, ಸಿನಾಪ್ಸಿಸ್ ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು. ಸಿನಿಮಾ ಇವ್ರು ಅಲ್ಲ ಫೋನ್ ಮಾಡಿದ್ರು. ಅಯ್ಯೋ ಇವರು ಚರಾಟೆ ಅವರು ಕೊಡ್ತೀನಿ ಇವತ್ತು, ಒಂದು 24th ಡೇಟ್ ಕೊಟ್ಟಿದ್ದು. ಇವತ್ತು ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ 24th ಅಂತ ಇದೆ.
2 ಸಲ ಕೇಸ್ ಲಿಸ್ಟ್ ಆಗಿತ್ತು. ಕೇಸ್ ಕರೆದಾಗ ಯಾರು ಇರಲಿಲ್ಲ.
ಐ ಆಮ್ ಸಾರಿ ಮಲ, ಎಲ್ಡಪ್ ಆಗ್ಬಿಟ್ಟಿದ್ದು. 24th ಮಲ.
Your Lordship, serial number 77, Your Lordship. Seeking for a short accommodation, we are supposed to file an
appear.
Petitioner, Your Lordship. We are to file a counter to the affidavit filed by the state.
We inform them.
I will inform, Your Lordship.
If they oppose, then take it.
Yes, Your Lordship.
My lord, serial number 2. Serial number 2.
I appear for petition, my lordship.
What do you want?
3 days time.
Lordship, it is a covered by judgment. Last time also I had given the judgment before the sound itself. Just to issue Khata, my lordship.
Respondent number 2 and 3, my lord.
Wait, please wait.
Page number.
He has moved a
18,
matter in the
seal
morning,
number
my lord.
90.
My colleague has moved a matter in the morning. was posted for Monday, my lord. Your lordship had passed a judgment regarding this Gram Panchayat election of the member, my lord. 10 members have been kept captive in Kunigal for 2:30 PM today, right? Already moved the memo. It was given, date was given for 17th.
No, she said no complaints on the 21st.
21st, my lord, but 10 members have been kept captive.
Habeas
2:30, there's urgency.
The habeas corpus.
ಇಲ್ಲ habeas corpus ಅಲ್ಲ. Kindly 2:30.
ನೋಡ್ರಿ ಏನೋ captivity ಅಂತಾರೆ.
Copy is not served.
Give him a copy.
Yes, please, ma.
ಅದು ಹೊಸ ಗ್ರೌಂಡ್ ತಗೊಂಡ್ಬಿಡಿ.
Your Lordship,
2:30.
Your Lordship, serial number 77, I've just
Copy
informed.
good.
Alright.
Great.
For preliminary hearing, seal number 1.
Otherwise, you have to give a copy.
Last time, I had not friend that taken time to seek instructions, my lord. I had been given permission to sell Nandini milk products, my lord, since 1999. Before granting license, survey had been conducted, spot inspection had been conducted, sketch had been.
ಎಷ್ಟು ವರ್ಷ ಕೊಟ್ಟಿದ್ರು?
Every year it's renewable, my lords.
Only for 1 year it was granted.
1 year. Now.
Been there for 25 years.
Right, from 1999 to this year also I had made an application. But they said that it is on the footpath. Malas, it is not on the footpath. Malas.
Footpath in the sense, my lord, there's public. For 25 years there was no footpath. Recent ಆಗಿ public interest litigations ಅಲ್ಲಿ ಎಲ್ಲ footpath, everything has to. After a quarter of a century, you realize that 25 years in the ಇದೆಯೋ ಇಲ್ವೋ, my lord, I'm not very sure, but.
ಅಲ್ಲ 19ರಿಂದ ಕೊಟ್ಟಿರೋದು 25 years.
2019, my lord, the application, my lord, the temporary license has been produced in this petition. Next, you see, my lord, everything is page number 18.
Sketch prepared by.
Every year, my lord, the density of the population. Where is this? It's near Yeshwantpur railway station, a high density pedestrian zone, my lord. ತುಂಬಾ congested ಆಗಿದೆ ಅಲ್ವಾ?
ಇಲ್ಲಿ ಅವರೇ ಸ್ಕೆಚ್ ಮಾಡಿದ್ದಾರೆ annexure B1 ಮೆಕಂಡಿ.
This was before the railway station was improved, isn't it?
The sketch showing proposed place for rent basis for Nandini milk parlor
What
near
is if you not?
annexure A. Annexure A at the page, that is the final notice and order. Second paragraph, my kindly see minutes. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ page 11. ವಾರ್ಡ್ ನಂಬರ್ 37 ಯಶವಂತಪುರ ರೈಲ್ವೆ ನಿಲ್ದಾಣದ ಹತ್ತಿರ ಇರುವ ನಂದಿನಿ ಹಾಲಿನ ಕೇಂದ್ರವನ್ನು ಕೂಡಲೇ ತೆರವುಗೊಳಿಸುವ ಬಗ್ಗೆ ಅರ್ಜಿದಾರರ ಮನವಿ ಪತ್ರ ಅಂಡ್ ಕರೆಸ್ಪಾಂಡೆನ್ಸ್ ಮೇಲೆ ಉಲ್ಲೇಖ 2ರಲ್ಲಿ ಮಾನ್ಯ
25 years ಅಂತ ಅವರು ಹೇಳ್ತಿದ್ದಾರೆ.
ಅಲ್ಲ 19 ಇಂದ ಇರೋದು
2019 ಇಂದ my lord.
2019 ಇಂದ ನಾನು ರಿನ್ಯೂ ಮಾಡ್ಕೊಂಡ್ ಬಂದಿದ್ದಾರೆ. ಈ ಸರಿನು ರಿನ್ಯೂ ಮಾಡಕ್ ಅಪ್ಲಿಕೇಶನ್ ಕೊಟ್ಟಿದ್ದೆ.
2019 is different from. ಟೈಮ್ ಬೇಕಾ? ಟೈಮ್ ಕೊಟ್ಬಿಟ್ಟು ಕ್ಲೋಸ್ ಮಾಡ್ಲಾ?
2 years ಕೊಡಿ ಸರ್.
Every year the permission itself is every year, my lord. It's on a yearly undertaking that will vacate. I will accept it.
Yes.
Maybe a bit difficult, maybe for the reason, my lord, there is a public interest litigation where undertaking was given. That all encroachments, my lord, that is one thing. It's not an encroachment. This is not an encroachment, I do understand, but to facilitate the movement of the public, especially in high density zones, my lord, be it even for public toilets, my lord, we are facing difficulties. Nothing indicated on next area that, read second paragraph. My lord, it is not very visible. Copy ಕೊಟ್ಟಿಲ್ವಾ? ಅಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ, it is not very legible for me. ಉಲ್ಲೇಖ 2ರಲ್ಲಿ ಮಾನ್ಯ ಮುಖ್ಯ ಆಯುಕ್ತರ ಸುತ್ತೋಲೆಯ ಆದೇಶದಂತೆ ಸರ್ಕಾರದ ಪ್ರಕರಣದಲ್ಲಿ ನೀಡಿರುವ ಆದೇಶದ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಪಾದಚಾರಿ ಮಾರ್ಗಗಳಲ್ಲಿ ಪಾದಚಾರಿಗಳ ಚಲನವಲನಕ್ಕೆ ಅಡ್ಡಿ ಮಾಡುವ ರೀತಿಯಲ್ಲಿ ಯಾವುದೇ ಬೂತ್ಗಳನ್ನು ಅಂಗಡಿಗಳ ನಿರ್ಮಾಣಗಳನ್ನು ಮಾಡಬಾರದೆಂದು ಸ್ಪಷ್ಟವಾಗಿ ನಿರ್ದೇಶನ ನೀಡಲಾಗಿರುತ್ತದೆ. ಹಾಗೂ ಉಲ್ಲೇಖ 3 ಮುಖ್ಯ ಅಭಿಯಂತರು ಆರ್ ನಗರ ಅವರ ಸೂಚನೆ ಅನ್ವಯ ಅನುಮತಿಯನ್ನು ವಿಸ್ತರಿಸಲು ಸಾಧ್ಯವಿಲ್ಲವೆಂದು ತಿಳಿಸಲಾಗಿದೆ. ಹಾಗೂ ತಾತ್ಕಾಲಿಕ ಅನುಮತಿಯೊಂದಿಗೆ ತೆರೆದಿರುವ ನಂದಿನಿ ಹಾಲಿನ ಕೇಂದ್ರವನ್ನು ಈ ಕೂಡಲೇ ತೆರವುಗೊಳಿಸಲು. The undertakes I'll permit him to stay there for 2 years. This may be a bit difficult, my lord. No, this is not. This is general circular. This is a not specific to this particular place.
General circular.
This particular place, my lord, but circular, my lord, is in general for the whole of Bangalore where there is high density, my lord.
3924 ಅಲ್ಲಿ ಕೊಟ್ಟಿರೋದು.
For 1 year, my lord. In the meantime, let him seek for some alternative space wherever it is available, wherever it is
1 year
convenient.
ಮಾಡ್ಕೊಳ್ಳಿ. The petition is directed against a final notice issued to the petitioner, calling upon him to vacate and hand over possession of the place where ನೀವೇ ಮಾಡಿದ ಅದು?
ಹೌದು ಸರ್.
Where he has erected a Nandini milk booth parlor. On the ground that there was a circular of the chief commissioner to ensure that footpath, the movement of pedestrians on the footpath were not impeded by erection of any structures. Not counsel, the petitioner points out that the petitioner has been permitted to put up the structure and is running his business from 2019. That is for a period of for a period of more than 5 years. And if all of a sudden the petitioner is called upon to quit and deliver vacant possession, he would be severely prejudiced. In my view, in the light of this submission, it would be appropriate to grant the petitioner 1 year's time to quit and hand over vacant possession to the BBMP. The petitioner shall file an affidavit undertaking that he will voluntarily hand over the place where he would dismantle the milk booth and hand over the possession to the BBMP on or before 1st of April 2025. Next paragraph. The BBMP shall also consider whether any alternative place which does not cause any impediment could be considered for allotment to the petitioner. It put in the point disposed.
Time 1 year was
1 year,
first of April.
25, so 26.
Bill number 2, Shri K.S. Mallikarjuna.
Lordship, I appear for petitioner. Lordship, in this case, I am seeking mandamus to issue Khata. The covered by judgment last date of hearing I produced is available in the files from me. Writ petition 1318/24. This honorable court has already directed them to issue Khata in similar matter. Earlier owner has constructed the house under sanction plan. Khata was issued. Now I have purchased the house property by taking banking loan. Now they unnecessarily not issuing Khata in favor of me, my lordship.
We will take instruction from BBM.
Lordship, they have taken sufficient time.
My lord, 3 days only. 3
Well,
days.
ಕವರ್ ಬೈ ಜಡ್ಜ್ಮೆಂಟ್ ಸ್ವಾಮಿ ಕೊಟ್ಟಿದ್ದೀನಿ ಲಾಸ್ಟ್ ಟೈಮ್ ತಮಗೆ ಫೈಲಲ್ಲಿ ಇದೆ ಅದು ಜಡ್ಜ್ಮೆಂಟ್.
ಇಲ್ಲ, 1 ನಿಮಿಷ ಅವಕಾಶ ಕೊಡಿ, ನಾನು ಅವ್ರ ಹತ್ರ ಮಾತಾಡ್ತೀನಿ, ಆಮೇಲೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿರೋ. I'll issue a direction to
ಆಗ್ಬೋದು ಸರ್.
consider this application and pass an order within a period of a month.
ಆಗ್ಬೋದು ಸರ್.
Kindly pass over.
The prayer in this petition is to issue a direction to the second respondent to issue a Khata in favor of the petitioners as requested by him online on 31/8/2024 and as per another representation dated 10/9/2024. The case of the petitioner that he has purchased the property from one K.N. Mohan on 29/8/2022. And as a matter of fact, the Khata was registered in the name of his vendor, Shri K.N. Mohan. It is his further case that since he had purchased the property on registered sale deed, it was necessary that the Khata be transferred in his name. In my view, since the petitioner claims that his vendor, the vendor's name was registered as a Khatedar and he has purchased the property and registered sale deed, it would be appropriate to direct the external respondent,
2 and 3.
the respondents 2 and 3, to consider the request of the petitioner and pass necessary orders within a period of 1 month. The respondent should take into consideration the fact that the Khata was registered in the name of the vendor of the petitioner and he had purchased and registered sale deed.
Bill number 3, Shri.
Much obliged.
I was appearing for the petitioner in this matter, my lords. My lords, this matter pertains to, my lords, I'm seeking for quashing of Annexure A, my lords. Annexure A is a cancellation order, my lords, wherein I was given an order for disposal, transportation and procuring of animal waste in 7 wards in the city, my lords. Annexure D at page number 36 is my order, my lords. The relevant portion will be at page number 38, my lords. That is a translated copy of the order, my lords. I'm sorry, I do not read Kannada, my lords. So I put a translated copy, my lords. At page number 38, we will find the relevant portion, my lords. If I may be allowed to read, my lords.
For the, what is the period for?
My lords, there was no specific period where, my lords, it just said until the next tender. That is at page number 38. On the basis of this order, my lords, I had bought 14 auto tippers, and I had also given these auto tippers to the 7 different wards in Gandhinagar constituency, my lords. This order was dated 21/3/2024, 21/3/2024.
Laws, we have a BBMP. We'll secure instructions in this matter, Lords. This is the first time it's been coming up.
My lords,
So,
if I might take my
pay for
lordship's
time.
attention,
What is the impugned order now?
the impugned order is an annexure A, my lords, which is at page number 19, my lords, which is also a translated copy, my lords. The relevant portion is here, my lords. They say that a lot of loss will be caused to the corporation by outsourcing this task.
How much do they have to pay you?
My lords, they have to pay me for 3 months, my lord. April, May, and June. Each month comes up to around the entire amount is 25,92,702 rupees.
No, how much do they have to pay you every month for collecting?
8 lakhs, my lords.
8,64,000,
It's causing too
my
much of
lords.
a problem because they're not even supplying the required amount of metric ton, what has been tendered, given to them. As per that also, they're not fulfilling the same. So far, what instructions we have got as per that. So that's why 8 lakhs somewhere around month, we are paying them, my lords, and they're not even fulfilling the same. And on top of it, only in Gandhinagar, this particular thing is going on. No, in no other ward it is going on. Entire Bangalore, it is not there.
My lords,
And in
as per-
Majestic area, cow dung, my lords. There
My
are
lords,
no
as
cows
per-
But
to that extent
why
as well.
did you give such a?
Order in the first place.
My lords, there are certain materials that we need to produce.
Period prescribed?
No.
Period is not prescribed, but we have mentioned that whenever, as and when we are required, we will accommodate them, saying that we can call for the tippers, my lords. We have specifically mentioned as such. So that's
Because the reference relates to Uleka 1.
Yes.
Manya Sachivaru Arogya ಮತ್ತು ಕುಟುಂಬ ಕಲ್ಯಾಣ ಇಲಾಖೆ. Was it a reason of this minister's intervention or was it your decision?
Constituent, my lords will secure instructions on that aspect because I'm not clearly sure, so I don't want to make the
Witness.
mention. Much obliged, my lords.
Obliged.
Number 4.
But the endorsement, my lord, is called in question, annexure K, page number 125.
Karthikeyan.
My lords, the endorsement, my lords, at annexure K in page number 125, my lords.
Yes.
My lords, the last paragraph, if I may draw my lordship's kind attention. But there are 2 survey numbers in which 2 sites have been formed, my lords, of adjacent areas, my lords.
So what is this Manya Ayuktara Adeshadante?
My lords, that is what I am trying to secure, my lords. A week's accommodation, my lords. My lords,
That is not communicated to me, my lord. I could not get the copy of it either.
I'll get that
So what
copy
has
and
happened is,
distribute.
my lord, may I just explain this? There was a civil dispute, my lord, that was pending.
Without understanding the basis, realist.
21st. So number 5, Sri Srinivas V. My lord, we are seeking writ of mandamus, my lord, to issue direction for the respondent to consider our application for change of Khata, my lord.
Where is your representation? Annexure C.
It's in our annexure C, my lord.
Clear in this petition, you say issuance of a direction to the external respondent.
Respondent number
To the
1,
respondent
my lord.
to consider his application for change of Khata. It is the case of the petitioner that he had purchased the property on 23/4/2024 on registered sale deed, and hence he is entitled for the Khata to be registered in his name.
But again, for the respondent.
Review, since the petitioner is claiming transfer of Khata on the basis of a registered document, be appropriate to direct the respondent to consider the same In past approved production period of 1
Lord,
month.
the copies are not served us to my lord.
We'll give you a copy. Consider. Come on.
Number 6. Same, my lord. Serial number 6 also same.
Why can't you give him a copy?
I will serve, my lord. I will serve, my.
Date check once more. Date of sale.
Serial number 7.
Sought for writ of mandamus to directing the respondent, my lord, to consider representation made by the petitioners
Ready
to
or
change of Khata, my lord.
Mallikarjun ready? Serial number 7.
So ನಮ್ದೆಂತ ತೋರಿಸ್ತೀರಾ?
7.
Lords, maybe there is technical errors, my lords. We have not, name is not showing properly, I guess.
Yeah, case Mallikarjun.
Apologies, my lords. We have not, this- kindly pass over, my lords, or else, short date may be given.
List.
18.
Great for me.
Serial number 8. She. Chandranath Ariga.
The matter was heard yesterday that court made. Annexure D. Submission was that it is within the property of the petitioner. This
Date in English.
yes, court may civil suit.
The prayer in this petition is for a direction to be issued to the respondents to restrain themselves from digging and carrying out any work in their scheduled property, which is stated to be serial number 78/3, measuring 36 quintas, situate at Choknalli village, Yelanga Hobli, Bangalore. The petitioner contends that an attempt is being made to dig a trench for the purpose of laying a drain in his land bearing serial number 78/3. However, the BBMP contends that it is only relaying an existing drain and it is not in any way interfering with the position of the petitioner in respect of property being 78/3. In my view, since the petitioner, the BBMP disputes that the assertion that a drain is being put up in the land of the petitioner, it be appropriate to direct the petitioner to approach the civil court and seek for a determination as to whether the drain has been laid in his property and thereafter seek for appropriate reliefs. It petition upon disposed of, presents such.
So the appointment of a surveyor, if it is
Be open
required,
to the
that also.
petitioner to seek for appointment of a surveyor also and for demarcation of his property.
Please.
Serial number 9. Shri Raghavendra Shena.
My please, my lords. My lords, had given the representation to the respondent, my lords, of if an illegal construction done by my neighbor, my lords. That representation has not been considered, hence I filed a writ for mandamus, my lords, to consider my representation in accordance with law.
Urpur Gram Panchayat. Chandranath Chanadariga, will take notice for respondent. Ariga, mandamus dispose madla, but you should make that person who has put up an illegal construction also as a party.
My lords, this representation has been issued only to the,
But should he not be aware?
1 day's accommodation, I will get instruction. A copy of the petition will be.
17.
Please.
I'm grateful, my lords.
17. Serial number 10. Shri Suresh Ji Deshpande.
I appeal for petitioner. The annexure H is the order passed by the respond number 2. To effect the Khata in favor of respond number 3 in respect of site number 108. Earlier, my lord, he applied for Khata in respect of 109 before the respond number 1 Panchayat. As far as 109 is concerned, the Panchayat has ordered the change of Khata. Now, while making an application before the respond number 2, he sought for 108. Now, the respondent number 2 directed to effect the Khata in respect of 108 to the extent of 1,806.
What is your entitlement?
My lord, 108, my measurement is 40 by 30.
Your complaint is about an encroachment.
He has included my property in the application.
And what is you are a party here?
I am a party before the
What is the finding then?
finding is that the boundaries are different.
Now you have filed, read page 60.
Please, my lord.
ವಾದಿ ಮತ್ತು ಪ್ರತಿವಾದಿಗಳ
ವಾದಿ ಮತ್ತು ಪ್ರತಿವಾದಗಳು ಹಾಜರುಪಡಿಸಿರುವ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿದ್ದು ಹಾಗೂ ವಿಚಾರಣೆ ನಡೆಸಲಾಗಿದ್ದು ದಾಸಂಪುರ ಗ್ರಾಮ ಪಂಚಾಯತ್ ವ್ಯಾಪ್ತಿಯ ನಗರೂರು ಗ್ರಾಮದ ಸ್ವತ್ತು ಸಂಖ್ಯೆ 140/108, 147.
before the civil court.
I have filed the suit for injunction in respect of one
Amendment. Why should this be decided?
as far as 40 by 30, I am having a right. Your lordship may kindly see the
No, anything that is said here, anything is said here. If I were to say something, will either help you or be against you. So why do you want to take the risk? You are either in the civil court.
but as far
For amendment.
40 by 30 is concerned, my lord.
If I say that you are not entitled for 40-30, after I go through the records, then your suit will go.
In 1995, I got it, Miss Wonder.
The petitioner is aggrieved by an order by which the Khata is ordered to be registered in the name of the third respondent. It is the case of the petitioner that his property has also been included by the third respondent, and the third respondent has secured Khata illegally. The executive officer in his order has noticed that the petitioner was already before the civil court in OS 467/2023, and it was at the stage of recording of evidence. The inquiry officer has also observed that the Khata cannot be registered in favor of the petitioner since he only had a GPA.
GPA.
In my view, the question as to whether the petitioner is entitled to the property or not can only be decided by the civil court. And this claim cannot be adjudicated in a proceeding for registration of Khata. So therefore, reserving liberty to approach to the petitioner to either file a fresh suit seeking for declaration or for amending the suit seeking for his entitlement over the property. The petition is dismissed.
Till then, my lord, my interest may be protected, my lord.
It is needless to state that if the petitioner were to file a declaratory suit or obtains a declaratory decree, the authorities will be bound by the same and register the Khata in accordance with the decree.
Only one submission, my lords, with respect to serial number 3. Can it be taken upon 20th, my lords? I have informed the other side. Sorry, Thursday, my lords. I have informed the other side.
When you make a submission in the middle like this,
Sorry, my lords, my
you have to
apologies.
wait till the list is over, then
Yes,
make
my
a
lords.
submission.
Okay, my lords. Sorry, my lords, my apologies.
Serial number 11, Srimati Sumati.
For the petitioner in this case, Milords, the petitioners have challenged the endorsement issued by the respondent vide annexure A, Milords. The water connection was provided by the respondent to the petitioner's house, but the apparatus was installed in the vacant site belonging to the very same petitioner, Milords. Abruptly, they have disconnected it, saying that we have availed the the
Take out
water.
notice, ma'am, let us. Who appears, Ms. Devraj should take notice for respondents.
I've sought an interim order not to disconnect the old supply, Milords, which is already in force.
It says ನಿಮ್ಮ ಮನವಿಯಂತೆ ಪರಿಶೀಲಿಸಲಾಗಿ ನೀವು ಕೋರಿರುವಂತೆ ನಿಮ್ಮ ಸ್ವತ್ತು ಖಾಲಿ ನಿವೇಶನವಾಗಿದ್ದು ಜಲಜೀವನ್ ಮಿಷನ್ ಯೋಜನೆ ಅಡಿಯಲ್ಲಿ ಸಂಪರ್ಕವನ್ನು ವಾಸವಿರುವ ಮನೆಗಳಿಗೆ ಮಾತ್ರ ನೀಡಿದ್ದು ನೀವು ಖಾಲಿ ನಿವೇಶನದಲ್ಲಿ ಮನೆ ನಿರ್ಮಿಸಿಕೊಂಡರೆ ನಲ್ಲಿ ಸಂಪರ್ಕ ನೀಡಲಾಗುವುದೆಂದು ಈ ಮೂಲಕ ಹಿಂಬಲ ನೀಡಿದೆ.
Yes, the connection is
Request is to provide water supply. And they are
the
saying,
house which is situated adjacent, Milords, the vacant site and the house of the petitioner are situated adjacent to each
what
other.
is your request? that
Milords,
you are-
I have produced at annexure G, Milords, the representation saying that the last 5 numbers, the Eastwattu number, my lords, last 5 numbers, there is a change. One is the house connection is provided to the house constructed in Eastwattu number 200003. Whereas it was in the passage is only about 4 feet. Therefore, we have installed it in the vacant site belonging to the petitioner.
Please read under representation.
ಸ್ವಾಧೀನ ಗ್ರಾಮ ಸತ್ತಿನ ಸಂಖ್ಯೆ so and so
ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಈ ಮೂಲಕ ತಮ್ಮ
ನೀರಿನ ಪ್ರವೇಶಕ್ಕೆ ಅಳವಡಿಸಿ ನೀರಿನ ಕೊಳಾಯಿಯನ್ನು ನಾನು ಇಲ್ಲದ ಸಮಯದಲ್ಲಿ
ಜೀತಾನೆ.
Yes, my lords.
The first paragraph, please read the first paragraph. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ
ಅರ್ಜಿ ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಈ ತಮ್ಮಲ್ಲಿ ತಿಳಿಸುವುದೇನೆಂದರೆ ಬೆಂಗಳೂರು ಹೊಸಕೋಟೆ ನಂದು ತಾವು ವ್ಯಾಪ್ತಿಗೆ ಒಳಪಟ್ಟಿರುವ ತಾವರೆಕೆರೆ ಗ್ರಾಮಕ್ಕೆ ಸೇರಿರುವ ನನ್ನ ಮಾಲೀಕತ್ವದ ನನ್ನ ಸ್ವತ್ತು ಸ್ವಾಧೀನ ಗ್ರಾಮ ಈ ಸ್ವತ್ತು ಸಂಖ್ಯೆ ಸೋ ಅಂಡ್ ಸೋ ಪಂಚಾಯಿತಿ ದಾಖಲೆ ಪ್ರಕಾರ ಸೋ ಅಂಡ್ ಸೋ ನಂಬರ್ ಅಲ್ಲಿ ಖಾಲಿ ನಿವೇಶನದಲ್ಲಿ ನನ್ನ ಮನೆಗೆ ಇಟ್ ಇಸ್ ಖಾಲಿ ನಿವೇಶನದಲ್ಲಿ ನನ್ನ ಮನೆಗೆ ಕೇಂದ್ರ ಸರ್ಕಾರ ಜಲಜೀವನ್ ಮಿಷನ್ ಯೋಜನೆ ಅಡಿಯಲ್ಲಿ ಕುಡಿಯುವ ನೀರಿನ ಪ್ರವೇಶಕ್ಕೆ ಅಳವಡಿಸಲಾಗಿದೆ. ನೀರಿನ ಕೊಳಾಯಿಯನ್ನು ನಾನು ಇಲ್ಲದ ಸಮಯದಲ್ಲಿ ಮತ್ತು ನನಗೆ ಯಾವುದೇ ತರಹದ ಮಾಹಿತಿ ನೀಡದೆ ತೆರವು ಮಾಡಿರುವುದು ನಿಮ್ಮ ಕ್ರಮ ಬಗ್ಗೆ ಮಾಹಿತಿ ನೀಡಬೇಕು.
So how can I ask him to restore? I'll hear them and then pass them out.
Please, any date may be fixed, my lords. I'll serve the copy.
Number 12, please Sachin here.
I appear for the petitioner. But mandamus, my lords, wherein my neighboring site, my lords, belongs to a government. Lords, illegal encroachment, my lords, is happening because felling of coconut trees, and now lords, bricks are coming into place and petty shops are now being built. Lords, I filed a mandamus representation, my lords, to see to that effect that no illegal construction is happening.
Presentation was just given 2 days back. Immediately they filed the writ petition. We'll look
Lords,
into it
because
and consider.
day
as
to day, my lords, the activities are being happening. Lords, my
And
immediate.
he has not made, ಯಾರು ಎನ್ಕ್ರೋಚ್ ಮಾಡಿದ್ದಾರೆ
ಮನೆ ಪಕ್ಕ ಅದು ರೋಡ್ ಮಾರ್ಜಿನ್ ತಾನೇ ಅದು.
My lords, that spot, my lords, at that very spot, my lords, place is being built. Petty shops, my lords. Small concrete blocks.
In anticipating.
No, my lords, already activity has taken place, my lords. That is why, my lords, we made it soon enough, my lords, to file this writ petition. If it is there, my lords, it is there. If it is not there, my lord, it is not there.
Where in this writ petition? KGA to accept notice for respondent. Where in this writ petition is to direct respondent to consider representation submitted by the petitioner vide annexure A. In the said writ petition, the petitioner has requested the respondent to ensure that there is no encroachment upon the government property which is situated adjacent to his property. In my view, since the petitioner contends that the common property adjacent to his property is being encroached upon, we appropriately direct the deputy commissioner to consider the said requisition fast within a period of 2 months.
Lords, 1 month, my lords.
ನೀವು ಬಂದಿರೋದು 2 ದಿನದಲ್ಲಿ ಬಂದಿದ್ದೀರಾ, ಅವ್ರಿಗಿನ್ನೂ DC ಟೇಬಲ್ಗೆ ಹೋಗೋಕೆ ಅದು 1 ತಿಂಗಳು ಬೇಕಾಗುತ್ತೆ.
Lords, until then, my lords, even if there is any activity, my lords, that is also being built.
ಇನ್ಫಾರ್ಮ್ ಮಾಡ್ತೀನಿ.
This for time for the petitioner. The petitioner is challenging the annexure D. I have challenged the order of E Sottu affected in respect to the adjacent site number 38, my lord. I am the owner of the site number 37, and without conducting the proper survey, they have affected the E Sottu in respect to the adjacent site. It is encroaching my property also, my lord, without conducting the proper survey and physical possession of the.
Our Khata, was it existing in the name of the third respondent's vendor?
Please, my lord, fourth respondent. Khata is fourth. In this, kindly see the annexure D, my lord, order in annexure D, my lord. In the page number 23, in last parameter, ಅದರಂತೆ 3ನೇ ಎದುರುದಾರ ನನ್ನ ಅರ್ಜಿ ಸ್ವೀಕರಿಸಿದ ನಂತರ 1 ಮತ್ತು 2ನೇ ಅರ್ಜಿ ಎದುರುದಾರರ ಸಂಬಂಧ 22ರಲ್ಲಿ ಮತ್ತು 23ರಲ್ಲಿ ಬೇರೆ ಬೇರೆ ನಡವಳಿಕೆಗಳಾಗಿದ್ದು 1ನೇ ಎದುರುದಾರರ ಹೆಸರಿಗೆ ಈ ಖಾತಾ ಮಾಡಿದ್ದು ನಂತರದಲ್ಲಿ 2ನೇ ಎದುರುದಾರ ಹೆಸರಿಗೆ ಮಾರಾಟವಾಗಿದೆ ಎಂದು ತಿಳಿಸಿದ ಮೂರನೇ ಎದುರುದಾರರು ಒಂದನೇ ಮತ್ತು ಎರಡನೇ ಎದುರುದಾರರ ಅರ್ಜಿಯಂತೆ ವಿಸ್ತೀರ್ಣವನ್ನು ನಮೂದಿಸಿರುವುದರಿಂದ ಹಾಲಿ ಮೇಲ್ಮನವಿದಾರರಿಗೆ 13x130 ಅಡಿ ವಿಸ್ತೀರ್ಣದ ಜಾಗ ಲಭ್ಯವಿಲ್ಲವೆಂದು, ಅದು ಕುಂಸಿ ಹಾರ್ನಳ್ಳಿ ರಸ್ತೆಗೆ ಹೋಗಿದೆ ಎಂದು ಮೌಖಿಕವಾಗಿ.
You file a civil suit. This gentleman can't decide.
No, my
You
lord.
have invited yourself for this order. He has given a finding. That you have
No.
filed.
Herein.
Finding is ಮೂರನೇ ಎದುರುದಾರರು ನಿಯಮಾನುಸಾರ ಮೋಜಣಿ ಇಲಾಖೆಯ ವರದಿ ಆಧರಿಸಿ 1 ಮತ್ತು 2ನೇ ಎದುರಿಗೆ ಈ ಸ್ವತ್ತು ನೀಡಿರುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಅದ್ರ ಮೇಲೆ ರಂತೆ ಮಹಜರ್ ಸಮಯದಲ್ಲಿ ಮೋಜಣಿ ಇಲಾಖೆಯವರು ಮಾಡಲಾದ ಅಳತೆಯನ್ನು ಒಪ್ಪಿ ಖುದ್ದು ಮೇಲ್ಮನವಿದಾರರು
ಅಲ್ಲ,
ಮಹಜರ್ ವರದಿಗೆ ಸಹಿ ಮಾಡಿ.
ನನ್ನ ಅಪ್ಲಿಕೇಶನ್ ಮೇಲೆ they have not conducted the survey. They have not.
He has given a finding that you have signed that participated, accepted the survey.
No, my lord. Kindly see the annexer. I have produced that copy
Go to
also.
the civil court. What is the point in fighting with him?
Herein, they have not conducting the survey on my property.
For the change of Khata, they don't have to conduct a survey. If the Khata's name of X, the property is sold in favor of Y, Khata is bound to be changed.
Please, my lord. But
Claim is that the
my property is not conducting the survey. I have submitted the application for conducting the survey. To that effect, my lord.
ನಿಮ್ ಸರ್ವೆ ಮಾಡೋದಕ್ಕೂ ಖಾತಾ ಮಾಡೋಕ್ಕೂ ಸಂಬಂಧ ಇಲ್ಲ.
ಅಲ್ಲ, ನನ್ನ ಪ್ರಾಪರ್ಟಿನ ಅವ್ರು ಓವರ್ಲ್ಯಾಪ್ ಮಾಡಿ ಸರ್ವೆ ಮಾಡಿಕೊಟ್ಟಿದ್ದಾರೆ. ನನ್ನ ಪ್ರಾಪರ್ಟಿನ ಫಿಸಿಕಲ್ ಪೊಸಿಷನ್
ಅದು
annexer ಸಿ my lord.
how can the executive officer determine that question? Why do you
Annexer,
take the risk?
at least they have to conduct the survey up on my application.
They don't have to conduct. ನಾನು ನೀವ್ ಹೇಳಿದೆಲ್ಲ ಮಾಡಿಸ್ಬಿಟ್ರೆ ಇವರು ಸಿವಿಲ್ ಕೋರ್ಟ್ ಮುಚ್ಚೋಗ್ಬಿಡುತ್ತೆ.
ಅಲ್ಲ, ಸಿವಿಲ್ ಈಗ ಪಕ್ಕದ ಸೈಟ್ ನ ಸರ್ವೆ ಮಾಡ್ತಾರೆ. ಅದರಲ್ಲೂ ದೇ ಹ್ಯಾವ್ ಇಶ್ಯೂಡ್ ದಿ ಫಸ್ಟ್ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಸ್ಟೇಟಿಂಗ್ ದಟ್ ದೇರ್ ಪ್ರಾಪರ್ಟಿ ಆಲ್ಸೋ ಇನ್.
Can the inquiry officer determine that?
The
Competent.
my lord, for a moment, your lordship may kindly see the annexer G for a moment. It is the first endorsement given to the adjacent owner, my lord. Annexer G. Thereafter, annexer F, they have affected the Khata, my lord.
Your request for effecting Khata was rejected.
No, they have not rejected my application also. They have orally stated that my property is in the Kumsi road. In respect to them also, they have issued the very same endorsement on page number 29, my lord. Initially, they have issued the very same endorsement.
File a civil suit.
Endorsement. Kindly issue the notice, my lord. Otherwise, adjacent owner, it may be overlapping. ಇದು ಮಾಡ್ಕೊಂಡು ಮಾಡ್ಬೋದು.
ಏನ್ ನೀವು ದಾವ ಹಾಕಿ ನಾನು
ಅಲ್ಲ, ದಾವ ಹಾಕಿ it will take more than 5 to 6 years.
I'm telling you, you're going to waste at least a couple of years' time here.
No, kindly issue the notice, my lord. Issue the notice. Let them appear and the adjacent owner also, if they have agreed.
How will they agree?
They are only overlapping 2 feet land, my lord. That's the only they're happening, my lord.
I'm repeat telling you, you will waste at least minimum of 2 to 3 years here.
No, my lord, kindly issue the notice. I hope that matter will be settled amicably.
I hope that you don't waste your time. Civil court ಹಾಕೊಂಡು ಮುಗಿಸೋದು ಇತ್ಯರ್ಥನೇ ಆಗ್ಬಿಡುತ್ತೆ.
ಅಲ್ಲ, ಇಲ್ಲ ಆಗಿಲ್ಲ ಅಂದ್ರೆ let us see, my lord. Kindly issue the notice, my lord, at least.
Notice.
See number 14. Naikella.
Serial number 14, my lord.
Yes.
This case, my lord, we at page number 22, my lord. The notification restricted 29 and 30 clause, my lord, restricted those who are having license to participate in auction sale. Your
Election
lordship
ನಡೆದಿಲ್ವಾ?
granted the
Auction
stay
ನಡೆದಿಲ್ಲ ತಾನೇ?
order and it was adjourned, my lord.
ಮತ್ತೆ ಬಿಡಿ ಇನ್ನೇನಾಯ್ತು ಹಂಗಾರೆ?
ಆ ರಿಟ್ ಪಿಟಿಷನ್ ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಡ್ರು. ಯಾಕಂದ್ರೆ he is a one of the corporator, therefore he has withdrawn this.
One more writ petition have disposed of, saying that you can give a representation.
Yes.
Asking them to reconsider the conditions imposed.
Please, my lord.
Before the issue of fresh notification, they will consider that and pass an order.
Please, my lord, kindly may be passed.
Okay.
66 shops are going to auction.
The petitioner is challenging an auction notification dated 13/12/2024 insofar as it relates to imposition of 2 conditions, that is condition number 29 and 30. The auction was proposed to be conducted on 2nd of January 2025. The overlearned counsel for the petitioner submits that by virtue of an interim order granted by this court in another writ petition, the auction was not conducted. It is therefore obvious that the present auction notification has spent itself and the respondents would have to necessarily effect a fresh notification. So, in regard to the contentions raised by the petitioner, in my view, be appropriate to permit the petitioner to make a representation to the respondents questioning the imposition of condition number 29 and 30 and requesting them not to impose on these conditions in the notification that may be published in future. If such a representation is made by the petitioner, the same shall be considered by the respondents and appropriate orders be passed on the said request, subject to the petitioner is disposed of in the manner necessary.
Please, ma'am.
Now then auction will be number 29 and 30.
Seal number 50, Shri K.K. Vasant.
But this is the petition 248-3 dated 3/8/2023 passed to demolish the construction.
What is the violation?
Violation, they say that all this, the four side setback is in violation.
ಸರಿ ಮಾಡಕ್ಕಾಗಲ್ಲ ಹಂಗಾರೆ.
ಅದು ಆಗುತ್ತೆ, ಅದು ಬೇಕಂದ್ರೆ ಪ್ರಾಪರ್ ಇದಾಗಿಲ್ಲ, ನೋಟಿಸ್ಗಳೇ ಸರ್ವಾಗಿಲ್ಲ. At least they could have given some explanation there.
The east 100%.
ಎಲ್ಲ ಹೇಳ್ಬಿಟ್ಟಿದ್ದಾರೆ ಪೂರ್ತಿ.
Floors extra ಇದೆಯಾ?
Floor most probably one small the room in the third floor. That is roof.
Built-up area is 100% more than what is permissible. Height is 40% different. In what is the point? ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ?
But put the explanation because they have not given any notice to me. Notice ಯಾರಿಗೋ ಸರ್ವ್ ಮಾಡಿದೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ. Here I have got one these thing. All the three notices and the orders are based on the same day. ವಾಚ್ಮನಿ ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತಾರೆ ಒಂದ್ ಕಡೆ, ಮೇಸ್ತ್ರಿ ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತಾರೆ ಒಂದ್ ಕಡೆ.
Appeal ಏನಾಯ್ತು?
Appeal also dismissed on 2/12/2023.
ನೋಟಿಸ್ ಬಗ್ಗೆ ಏನಂತ ಹೇಳ್ತಾರೆ ಅಪೀಲ್ ಅಲ್ಲಿ?
ನೋಟಿಸ್ ಬಗ್ಗೆ ನೋಟಿಸ್ ಸರ್ವ್ ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ. And though in the appeal they refer to the division bench ruling, how the guidelines given by this honorable court in writ petitions, they have not followed that the guidelines also.
Reconsider, let him file his objections. I don't think there's any point only postponing the evil day ಅಷ್ಟೇ.
That may be.
The petitioner is aggrieved by the order of confirmation that has been passed against him, in which the provisional order which indicated deviation from the sanction is stated to have been established. Said order has also been confirmed in appeal. It is over the condition of the petitioner's counsel that the petitioner was not served with the provisional order and he was not therefore permitted to file objections. The order of confirmation merely indicates that the petitioner had not furnished his explanation and it is silent as to whether the provisional order was served on the petitioner. The appellate authority has also mechanically accepted the confirmation order and has dismissed the appeal. In my view, since the petitioner has not filed his objections to the provisional order and there is no finding regarding service of notice on the petitioner, it will be appropriate to set aside the order of the appellate authority as well as the order of the confirmation and permit the petitioner to file objections within a period of 2 weeks from today. On such objections being filed, the jurisdictional authority shall consider the same and pass appropriate orders afresh. The plea is according to won't come out to accept notice.
Number 16.
The both annexure G and H may be questioned.
ಇಲ್ಲ ಮಾಡಿದ್ನು appellate authority order and confirmatory order.
ಅದು ಎರಡು ಕೊಡು.
Number 16.
That is pertaining to ground rent. Annexure, yes, similar order.
Number 17. Srimati Kavita.
17. Lord, we have not the letter communication. Let's pass on the. Sir. Please, put. In so far as Lord, the fire department is concerned, Lord, there is a letter communication. And the second is, Lord, that is with respect to health department. And the third is, Lord, the PWD.
Lord, PWD communication may please be seen, my lord.
This is not an NOC. It says if you pay the money, we will provide the fire force services at the spot. What is it that you asked?
Lord, that is the NOC, Lord.
Then is it an NOC? Read the letter, the first letter.
Please, Lord. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖ 1ರನ್ವಯ ನಮ್ಮ ಪತ್ರದಲ್ಲಿ ಶ್ರೀ ಸಕಲೇಶ್ಪುರ ಸ್ವಾಮಿ ಜಾತ್ರೆ ವಸ್ತು ಪ್ರದರ್ಶನದ ಅಂಗವಾಗಿ ದಿನಾಂಕ 12/25 27/2/25 ನಡೆಯುವ 67ನೇ ಜಾತ್ರಾ ವಸ್ತು ಪ್ರದರ್ಶನದ ಅಂಗವಾಗಿ ಯಾವುದೇ ಬೆಂಕಿ ಅವಘಡಗಳು ಸಂಭವಿಸುವಂತೆ ಸೂಕ್ತ ಭದ್ರತೆ ಹಾಗೂ ರಕ್ಷಣಾ ವ್ಯವಸ್ಥೆ ಕೋರಿದ್ದು ಮುಂದುವರೆದ ಉಲ್ಲೇಖ 2ರನ್ವಯ ವಸ್ತು ಪ್ರದರ್ಶನ ಜಾತ್ರೆಗಳು ಇತರ ಲಾಭಕ್ಕಾಗಿ ನಿಯೋಜಿಸಿದ ಕೂಟಗಳಿಗೆ ಸರ್ಕಾರ ನಿಗದಿಪಡಿಸಿದ ಶುಲ್ಕ ಇಲಾಖೆಗೆ ಬರೆಸಿದ್ದಲ್ಲಿ ಇಲಾಖಾ ನಿಯಮಾನುಸಾರ ಬೆಂಕಿ ಅವಘಡಗಳು ಸಂಬಂಧಿಸಿದ ಸೂಕ್ತ ಭದ್ರತೆ ಜಲವಾಹನ ನಿಯೋಜಿಸಲು ಕ್ರಮ ಕೈಗೊಳ್ಳಲಾಗುತ್ತದೆ.
This is not an NOC.
Not in fact, Lord, now, Lord, I put it in this way, my Lord. Now Jatra has commenced, Lord. Lord, there is some, my Lord, some mistakes on our part. Lord, kindly, my Lord, appreciate this. Lord, 11/2/2025, my Lord, the Jatra has commenced. Almost, my Lord, 3 days, my Lord, it's been going on. And my Lord, we have taken all the precautions as far as, my Lord, the safety of the, my Lord, the public is concerned. Lord.
And why did you impose this condition?
That is a mistake, my Lord, that they have, now, my Lord, if at all, the Sound Court stays, my Lord, the work order, then, my Lord, huge inconvenience and loss to them, my Lord, the authority.
ಜಾತ್ರೆ ನಿಲ್ಸಕ್ಕೆ
ಅಲ್ಲ ಅಮ್ಯೂಸ್ಮೆಂಟ್ ಏನಾಗಿದೆ ಮಿಲಾಡ್ ಇನ್ಫ್ಯಾಕ್ಟ್ ಮಿಲಾಡ್ ದಿ ಬಿಡ್ ಇಸ್
amusement park.
ಮೇಡಮ್ 1 minute ಮಿಲಾಡ್ ಬಿಡ್ ಇಸ್ ಫಾರ್ ಮಿಲಾಡ್ 45 lakhs. He has already deposited the ಮಿಲಾಡ್ the bid amount and he has also placed ಮಿಲಾಡ್ the materials with regard to sports activities, cultural activities. He has installed 85 stalls and erected ಮಿಲಾಡ್ the all amusement things ಮಿಲಾಡ್. So therefore, in case ಮಿಲಾಡ್ stays the ಮಿಲಾಡ್ if lordship stays the ಮಿಲಾಡ್ the work order ಮಿಲಾಡ್ he'll have to ಮಿಲಾಡ್ stop the entire ಮಿಲಾಡ್ the activities thereafter. Then ಮಿಲಾಡ್ the huge loss as well as the ಮಿಲಾಡ್ the inconvenience would
This
cost.
is your mistake, isn't it?
Therefore, my Lord, I would request my Lordship, my Lord, if my Lordship, my Lord, have 3 days time is given, my Lord, that will ask the my Lord Chief Officer is present. I clearly instructed my Lord.
How did he give such a representation? How did he give such a kind of conditional permission?
Lord, since my Lord, in the my Lord, the e-procurement notification, my Lordship kindly peruse. Lord, that is why my Lord, we have stated so.
ಏನ್ ಮೇಡಮ್ ತಕರಾರು?
My lord, ತಕರಾರು ಇರೋದು ಪಬ್ಲಿಕ್ ಅಮ್ಯೂಸ್ಮೆಂಟ್ ಇನ್ಸ್ಟಾಲೇಷನ್ಸ್ ಏನಿದೆ ಅದು ತುಂಬಾ ಅನ್ಸೇಫ್ ಇದೆ. ನದಿ ಪಕ್ಕದಲ್ಲಿ ಗದ್ದೆನಲ್ಲಿ ಇದು ಮಣ್ಣು ತುಂಬಿಟ್ಟು ಮಾಡಿರೋದು ಸಾಯಿಲ್ ಟೆಸ್ಟಿಂಗ್ ರಿಪೋರ್ಟ್ ಬಂದಿದೆ. ಮೈ ಲಾರ್ಡ್ ಮೇ ಕೈಂಡ್ಲಿ ಸಿ ದ ಥರ್ಡ್ ಕಮ್ಯುನಿಕೇಶನ್ ವಿಚ್ ದೇ ಆರ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್. ದ 12/2/2025 issued by the executive engineer of PWD department, my lord. They themselves have produced along with their memo today, my lord. The 12/2/25 ಅದರಲ್ಲಿ serial number 3 ನಲ್ಲಿ PWD ಅವರು ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ.
This is Crawford General Hospital.
ಸೀರಿಯಲ್ ನಂಬರ್ 3 ನೋಡ್ಬೋದು. ಒಂದು ದಿನಾಂಕ 10/2/2025 ಸ್ಥಳ ಪರಿಶೀಲನೆ ಮಾಡಿದಾಗ ಕಂಡು ಬಂದ ನ್ಯೂನ್ಯತೆಗಳನ್ನು ಪಟ್ಟಿ ಮಾಡಿದ್ದು ಈ ಕೆಳಗಿನಂತಿದೆ. ಸದರಿ ಜಾಗದಲ್ಲಿ ಮಣ್ಣನ್ನು ತುಂಬಿದ್ದು ಸರಿಯಾದ ರೀತಿಯಲ್ಲಿ ದಟ್ಟಣೆ ಮಾಡಿರುವುದು ಕಂಡು ಬಂದಿರುವುದಿಲ್ಲ. ಹಾಗೂ ಮಲೆನಾಡು ತಾಂತ್ರಿಕ ಸಂಸ್ಥೆಯಿಂದ ಪಡೆದುಕೊಂಡಿರುವ ಮಣ್ಣಿನ ಗುಣಮಟ್ಟದ ವರದಿಯಲ್ಲಿ ಸದರಿ ಜಾಗವು ತುಂಬಿರುವ ಮಣ್ಣಿನಿಂದ ಫಿಲ್ಡ್ ಅಪ್ ಸಾಯಿಲ್ ಕೂಡಿದೆ ಎಂದು ನಮೂದಿಸಲಾಗಿದೆ. ತಾಂತ್ರಿಕ ಸಂಸ್ಥೆಯಿಂದ ನೀಡಿರುವ ವರದಿಯಲ್ಲಿ ಮಣ್ಣಿನ ದಟ್ಟಣೆ ಫಲಿತಾಂಶ ಮಾತ್ರ ನಮೂದಿಸಲಾಗಿದೆ. ಸದರಿ ಜಾಗದ ಫಿಟ್ನೆಸ್ ಸರ್ಟಿಫಿಕೇಟ್ ಪ್ರಮಾಣ ಪತ್ರ ನೀಡಲು ಮಣ್ಣಿನ SBC ಪರೀಕ್ಷೆಯ ಫಲಿತಾಂಶ ಅವಶ್ಯಕವಾಗಿರುತ್ತದೆ. ಸದರಿ ಜಾಗದಲ್ಲಿ ಅಳವಡಿಸಿರುವ ಜಯಂಟ್ ವೀಲ್, ಟೋರಾ, ಕೊಲಂಬಸ್ ಇತ್ಯಾದಿಗಳನ್ನು ಪರೀಕ್ಷಿಸಿದ್ದು ಸರಿಯಾದ ರೀತಿಯಲ್ಲಿ ಅಳವಡಿಸದೆ ಸಣ್ಣ ಪುಟ್ಟ ಮರದ ತುಂಡುಗಳನ್ನು ಬಾಟಮ್ ಸಪೋರ್ಟ್ಗಾಗಿ ಜೋಡಿಸಿಟ್ಟಿರುವುದು ಅವೈಜ್ಞಾನಿಕವಾಗಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ಸದರಿ ಜಾಗದಲ್ಲಿ ಅಗಲವಾದ ಮತ್ತು ವಿಶಾಲವಾದ ಗಟ್ಟಿಮುಟ್ಟಾದ ಮರ ಅಥವಾ ಕಬ್ಬಿಣದ ವಸ್ತುವನ್ನು ಪೂರ್ಣ ಜಾಗದಲ್ಲಿ ಜೋಡಿಸಿ ಅಲುಗಾಡದಂತೆ ಕಟ್ಟಿ ಅಕ್ಕಪಕ್ಕದಲ್ಲಿ ಜೋಡಿಸಲು ಕೋರಿದೆ. ಸದರಿ ಜಾಗದಲ್ಲಿ ಮಳೆ ಬಂದಲ್ಲಿ ನೀರು ಹರಿಯಲು ಜಾಗದ ಸುತ್ತಲೂ ಯಾವುದೇ ಚರಂಡಿ ವ್ಯವಸ್ಥೆ ಕಲ್ಪಿಸಿರುವುದು ಕಂಡು ಬಂದಿರುವುದಿಲ್ಲ. ಜಯಂಟ್ ವೀಲ್, ಟೋರಾ, ಕೊಲಂಬಸ್ ಇತ್ಯಾದಿಗಳನ್ನು ಆಗಾಗ್ಗೆ ಪರಿಶೀಲಿಸಿ ಕಾರ್ಯನಿರ್ವಹಿಸುವುದನ್ನು ಸೂಕ್ತ ಪರಿಣಿತರಿಂದ ಖಚಿತಪಡಿಸಿಕೊಳ್ಳುವುದು.
Then stop only that giant wheel, Tora and Columbus.
It's highly
We have taken all the, my lord, after the report, my lord, we have taken the precautions.
This is on 12 to, what have you done?
Allah, 12 to, Allah, we have instructed, my lord, the person who has not installed all that things, my lord, to take all the precautions in so far as that, my lord.
Until you get a certificate from this PW department, if you undertake that you will not conduct this giant wheel, Tora and Columbus.
ಅಲ್ಲ ನಾವು ಅದು ಅವ್ರು ಹೇಳಿದ್ದಾರೆ ದಪ್ಪದ ಮರಗಳನ್ನ ಪೀಸ್ಗಳನ್ನ ಇಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
One more statement from PWD saying that it is now safe. It's on your conscience. If something happens.
ಅಲ್ಲ ಹೌದು lord. Lord, that is true, my lord. My lord,
Giving entertainment.
object is to not say public safety is my lord utmost important.
So give them entertainment, you will give them misery. If something goes wrong.
Lord, in fact, my lord,
Better to be safe rather than sorry, isn't it?
please, I'm actually, my lord, that is true, my lord. My lord, in fact, my lord, there is a report of my lord, the engineer. Just pass on that, my lord.
No, luckily for you, she is not against the Jatra. Let the Jatra go on, but these three activities we restrain till you get the letter from PWD. It's in your own interest. Why are you?
My lord, may kindly see one more submission, my lord. It falls within the jurisdiction of Gram Panchayat, my lord. It has been wrongly issued by the municipality. It couldn't have been issued.
But madam, higher body than ever. They are higher body, so.
Higher bodies, Swami, adre
Lord, what will the
Gram
chief
Panchayati
officer is
ವ್ಯಾಪ್ತಿ
saying,
ಒಳಗೆ
Lord?
ಬರುತ್ತೆ.
They have taken all the precautions, all the frames have been fixed, my lord, therein, my lord.
Let him get a certificate from the PWD officer saying that now he has inspected this, he is found to be suitable.
Kindly pass it over, my lord, I'll kindly
Until
pass.
then, you will not ensure, you will not allow these three activities.
Please, Columbus, my lord, and
Tora, Columbus.
3 activities.
Nearly 1,000 people visit that
But in
Jatra
fact,
every
more
day.
than, my lord, 10,000 people are some thronging there, my lord.
All the more reason for you to be safe.
Lord, I do agree, my lord, with my lordship, my lord, observation, my lord.
And in all this, children will be involved.
Please, my lord,
And if
all
a
the
tragedy
children, my
occurs-
lord, adults, everybody, my lord, involved.
If a tragedy occurs, then blame game will start.
My lord,
This court also will be blamed by permitting you to continue despite this being brought to our notice.
please pass it over, my lord, I'll.
These three activities.
Please,
will stop.
please pass it over.
Number 18, Shri Ramesh KR.
Paying for the petition dismantlement, for the writ of mandamus, Lord, annexion. On 3/12/2022, my lord, the petitioner submit an application seeking single plat layout plan approval.
To accept notice for R1. OPS or the Developer Planning Authority. Yogesh need to take notice for R2. We must.
My lord, one date may be given.
Bill number 19.
For petition, not order is passed without issuing notice and not by the zonal commissioner, lord, as contemplated under the act.
What is the construction you put up?
Lord, the construction I have put up is stilt, ground, first, second, and lord, terrace.
Third floor is completely illegal.
Lord, what according to the permission, lord, the tank, staircase tank, they are all provided. Lord, what has been now only 50% would be, lord, illegal. Lord, I will not be doing it, lord, using it for that purpose.
Read page number 28.
28, lord. And lord, stilt floor, it is all entire open, lord.
And I'll ignore all that. Come back to the last portion, terrace.
Terrace, lord, it shows 100%, lord.
Then?
Out of which, lord, what they now, the plan approved
Was
provides.
23 square meters.
Please.
And you have put up 123. The whole thing you've utilized. Same, all the floors, it is 123 square meters.
Yes.
So you have put up a third floor completely illegal.
Not terrace, not complete, not illegal. Not. What happens is it provides for tank and staircase
100
and
square-
lift.
100 square meters is extra.
Yes. Not that I'll not use it. Not and not one.
You undertake to demolish that third floor?
Not what has happened. Not now. Not this Greater Bangalore Governance Bill 2024 is is on the verge of being now published. Not where not there they permit me to regularize 50%. Not that permission is given till then.
50% ಆಗಲ್ವಲ್ಲ?
ಅಲ್ಲ ಇದು 50% ಅಷ್ಟೇ ಆಗುತ್ತೆ. ಇನ್ನು ಮಿಕ್ಕಿದ 50% ನಂದು ಪರ್ಮಿಷನ್ ಇದೆ. ಅದನ್ನ ಸ್ಟೇರ್ ಕೇಸ್ ಎಲ್ಲ ವಾಟರ್
ಇಲ್ಲ 23 square meters.
ಹೌದು.
It's 3 times. Entire third floor is a problem.
Yes. Lord, till that bill comes, Lord, may protect me, Lord, at least then. And no notice is served, Lord. They say 100%
No,
well.
there must be a consequence both for you and for the engineers who permitted this to go on. ಇಲ್ಲ misplaced sympathy ಆಗ್ಬಿಡುತ್ತೆ, ಅಯ್ಯೋ ಪಾಪ ಅಂತ.
Yes, they don't even.
The argument of I lock it up is not something which impresses me. You demolish the third floor and reconstruct, then you will.
But
What is the extent of the site?
Lord, the extent of the site is 50,500 square feet.
Why should it be? Where is the property situated?
Not property is BTM.
Like ಎಲ್ಲಿ? Which area?
Not Bharat HBCS Kuempu layout.
What does the appellate authority say?
Lord, appellate authority says, Lord, doesn't consider any of my contentions. Lord, at para 10, Lord, at page 21. There's the only discussion. Lord, I was not given an opportunity. No notice was served on me. All this, Lord, after the confirmation order was passed, Lord, after that, Lord, when they come for demolition, only then the advocate goes, Lord, gets to know it on after 1 month. Lord, that is then, Lord, no
Do you have
opportunity.
any photographs? What is the stage of construction?
Lord, I don't have. I'll check out.
Get it on Monday, let us.
Please.
Ask your client to demolish the third floor by that time.
The first ground and second, Lord, are for.
Third floor demolish ಮಾಡಕ್ಕೆ ಹೇಳಿ, then
Please. I'll
I
check
will
it.
also make the engineer pay for this. The concerned engineer who permitted the construction, he will bear 50% of the cost, you will bear 50% of the cost of demolition.
Seek instruction.
Then I'll remand it back to the jurisdictional engineer. There must be some way that we have to stop this, isn't it?
Yes.
Since he allowed you to go through and put this construction, you obviously are taken care of him. That's why he allowed this. So he will pay 50% of the cost of demolition. You will bear 50% of the cost of demolition.
He is not taken care of by the, what is an.
Number 20.
Monday.
I'm advocate already. He is not taken care of anybody. He said, but may I request?
Monday.
It looks like, sorry. Madam.
20.
Petition is a counsel, is an advocate.
He is out. Sorry.
This is the present stage.
No, it is 15, 20, before the order.
ನೀವು ವಕಾಲತ್ ಆಗ್ತೀರಾ?
Yes, my lordship.
Accepts notice for respondents. Objections if any in 2 weeks. There is an interim stay of demolition. Or the petitioner shall not proceed further with the construction till the next date of hearing.
Please.
Number 20.
Luckily, he has not spent too much. Ask him to demolish the third floor and remand it.
Please.
Number 20. Okay. Venkatesh Samaredi.
Wait, please, please. Appeal for petitioner's counsel. Not the prayer for issuing Khata based on the registered document, my lords. The Khata has to be issued by respondent number
Accepts notice for R1,
2.
R1, R3 and R4. OPS for TMC Saklesh.
The same, the same, municipal, 17, my lord, same municipal council, my lords. Same municipal, in fact, I am informed.
Pradeep also.
Oh.
Same Pradeep to accept notice for R1.
My lord, earlier Jatra was being conducted in our property without acquisition for 20-30 years. And this honorable court, my lord, said you conduct acquisition.
Something is wrong in Sakleshpur.
Acquisition ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ರು, acquisition ಇನ್ನೂ ಮಾಡಿಲ್ಲ. Now they have shifting the premises to something else is what's happening, my lords. And
You have set up Kavita to.
no, it's my property. What happened is, my lords, property is mine. Now it was in the name of my sister. Sister died executing a registered document in gift deed in my favor. There are 3 properties. Other 2 properties are agriculture properties already mutated. This property they are withholding because I have made a claim against them for acquisition or for damages. They have not mutated this land, my lords. Writ is allowed, my lords, directing them to.
Only, no.
Would your lordship be pleased to pass over or?
No, we should notice, let him take notice, secure instructions. It will be relisted again.
May humbly pray for any date, my lords. As my lord, grateful.
7. Please. Number 21. Shri Ramesh Care.
Here for petition is madam, writ of mandamus for change of land in concern. Petition, change of land. And 26/2024,
Notice for R1. I accept notice for R2 and R.
date may be given.
Relist.
Please.
Number 22. Orders.
My lord, it is under process. That e-Khata madak try ಮಾಡ್ತಾ ಇದ್ದಾರೆ. So for the e-Khata, my lord, there are some formalities which they are trying to do. ಅದೇನೋ ಆಧಾರ್ ಕಾರ್ಡ್ ಸಿಕ್ಕಿಲ್ವಂತ. I've informed my learned friend also. He said he will be sending it today. I've also asked the officers to be present. If they're there today in 10 minutes, my lord, I'll tell them to meet the council and get it done.
I'm telling you again, don't invite an order.
Illa, I'm trying my best to get it done, my lord. In week's time, my lord, I will not.
31st.
Much obliged.
Which date you will?
21st.
Number 23. Shri Patil Jagdish Gaud.
Third responsibility is Taluka Panchayat. They are seeking this a correct address.
You told the Somajara. Vijay Somaji accepts notice for.
Only, you're seeking only mandamus idrane.
Paper note kodi avarge.
Yes, please. Well, fix the date, please. Date,
Number 24. Shri
date, please.
Saravana S.
Please, please.
My lord, I was the court commissioner who was appointed. I have inspected the property on the Saturday, my lord. I would request a 2-3 days time to file my report. A detailed report I want to file. It may be posted on Monday or Tuesday as per the convenience, my lord.
18th.
Much obliged, my lord.
Number 25. Shri Veerbhadra Swami.
My lord, for the municipality, on the last date, my friend submitted that we had offered to give him 12, but we found someone else raising objections that morning, saying that he has a sale deed in his favor. We have looked further into it. May I be permitted to pass on? It is amply clear from this that there was no sale deed with regard to 12. That there is no sale deed, that it has all been manipulated. And it's not the municipality that is manipulated, it seems to be the registering officer who has manipulated. My lord, I have flagged the relevant portions. There is a letter supposedly of 1992 of the then commissioner. Sale deed is registered in 2024. The signature of the commissioner on that is not the commissioner's signature. The name of the commissioner in the sale deed is given as the sub-registrar says he has satisfied himself that Shri Commissioner has executed the document. We have looked further, we find Khata is prior to the, and there's no such thing in our record, but he has an Khata prior to 2024. He has paid tax for 10 years in a row from 2008 onwards, all on the same day, self-assessment and all these things he has done. Therefore, 12, my lord, is definitely available, but we will have to sort this out. Now, if my lord were to permit, I would like to officially bring it to the notice of the court that the police would take it a lot more seriously if the court were to direct them to investigate.
Rahul, who is that person who's got a sale deed?
One Aslam Pasha, but if I may point out, it is not just him, my lord. There seems to be,
Since there is a sale deed in his favor,
yes,
now that will have to be set aside, isn't it?
it will have to be separate. Except for one thing, that sale deed is not executed by the municipality.
That I can't pass an order without hearing them.
Yes, my lord. May the court direct, since the matter was sub judice, we have not yet filed a police complaint, but since you're bringing it to the notice of the court, if the court were to direct registration of an FIR.
No, I'll get that inspector here and then ask him to.
Very,
You give a complaint, then I'll ask him to take action.
very well. But it may be noted, my lord, that we are given liberty to make a complaint since the matter is before the court. I advise them to wait for 2 more days.
21/1/2025. This court
Kolar.
notice that an order of allotment was made as per Annexure D on 18/2/1993 in favor of the petitioner, but the property was not conveyed to the petitioner. Taking note of the further fact that the allotment made in 1983 in favor of the petitioner was in the form of an alternative site allotment. This court observed that the respondents were acting in a very arbitrary manner and therefore directed the Commissioner of Municipal Corporation to be personally present to explain as to why no action was taken to conclude the allotment in favor of the petitioners. Pursuant to the said order, the Commissioner was present on 28/1/2025 and he sought for 10 days time to make his stand clear. The matter was thereafter ordered to be relisted on 7th of February 2025. On 7th of 2025, the Honorable Counsel, the petitioner pointed out that the process of conveying the property was at an advanced stage, but where is that sale deed that you showed on the last occasion?
It is good.
But yeah.
We have flagged it.
No, you had shown it to me last time.
Yes, that's the same thing. Same thing, madam.
But at that stage,
Ide pass ಮಾಡಿ.
a claim was made
ಅದೇ.
by one Aslam Pasha, contending claim was made by Aslam Pasha to the effect that the very property that was sought to be conveyed to the petitioner was in fact conveyed to him under registered sale deed dated 9/5/2024. The request was therefore made for grant of a week's time to respond to this claim and make further submissions. Today, the Honorable Counsel, the petitioner submits that on an inquiry being conducted, the Commissioner is satisfied that the sale deed that is registered in favor of Aslam Pasha is a concocted document. It is the Land Council submits that the Commissioners of the view that the signature found on the sale deed produced by Aslam Pasha is not of the Commissioner, isn't it?
It's not of
The
the
Commissioner. And the Commissioner has also noticed that even before the sale deed had been executed, Khata had been made out in favor of Aslam Pasha And property taxes were also collected.
Paid, collected. Tax was paid under SAS, which was.
It is also stated that taxes in respect of this site were paid by Aslam Pasha through SAS. And the entire transaction, entire claim by Aslam Pasha was fraudulent. Now, consider the petition submits that the commissioner intends to initiate criminal proceedings, initiate a criminal complaint against Aslam Pasha. In the light of the said submission, in my view, the jurisdictional police officer is directed to accept the complaint and investigate the matter and report the result of the investigation by the next date of hearing. So, since the property in question was allotted to the petitioner way back in the year 1983, and the matter was at the stage of conveying the property to him, it would also be appropriate to implead Aslam Pasha, son of late Abdul Subhan, residing near Eidgah Shahi, First Main Road, Shenshaw Nagar, Kolar. The learned counsel for the officials of the Municipal Council Kolar are permitted to serve a copy of the writ petition in annexures with said Aslam Pasha and inform him that the matter will be taken up on so-and-so. Relist on so-and-so for further hearing.
My lord, may I point out two things? One is, it's a counsel for respondent two, not the counsel for petitioner who has pointed out, because he has no knowledge of it.
Respondent number 2 on.
The second thing, my lord, the allotment of 92, that alleged allotment and the Burley, that allotment itself, it's, when we look at it, it's clear even that is also a forged.
User.
15,792, not his.
I'm only
Aslam
concerned
Pasha.
about his. You have said that the sale itself is concocted, isn't it?
Yes,
So then let us see.
yes.
Ask him to be personally present on the next date of hearing. And serve a copy of the writ petition and annexures on that Aslam Pasha.
Aslam Pasha.
Sarded may be
When
given.
the cost rate.
It was in petition is bedridden, sarded may be given.
Now, our police, you,
ಆಯ್ತಾಯ್ತು ಅದಕ್ಕೊಂದು ಸಾರ್ಡೆಟ್ ತಮ್ಮ ಮುಂದೆನೆ ಆಗ್ಲಿ.
ನಾನು further consideration ಅನುಮೋದನೆ ಬರುತ್ತೆ.
ಹಾ ಸರಿ.
Number 26, M. Umashankar.
What are it?
Third mark.
May it be on fourth instead of third, my lord. and first.
Which? Four.
ಕಾಪಿ ಕೊಟ್ಬಿಡಿ ಅವ್ರಿಗೆ.
ನಂಗೊಂದು ಕಾಪಿ ಕೊಡ್ತೀನಿ.
ಪಿಟಿಷನ್ ಕಾಪಿ ಪೂರ್ತಿ ಅವ್ರಿಗೊಂದು ಕೊಡಿ, ಅವ್ರಿಗೊಂದು ಕೊಡಿ.
ಅದೇ ಇವ್ರು ಕಾಮೆಂಟ್ ಕೊಡ್ತೀನಿ. ನಂಗೊಂದು ಕಾಪಿ ಕೊಡಿ. ಇದು ಬೇಡ.
The petitioners.
In this matter, demolition order was passed. In the meantime, they have approached the civil court and there is an injunction pending, because of which demolition could not be executed.
Who has taken an injunction?
I responded number 4, my lordship.
Vishnuwardhan Reddy.
Vishnuwardhan Reddy.
He'll service ಆಗಿಲ್ವಾ?
No, my lord, service is not.
Taken steps, my lord.
They stated that note of confirmation was passed by the corporation, but the fourth respondent has approached the civil court in OS number
8291 of 23.
23
23.
and has secured an interim order. In the light of the above, petitioner's counsel is permitted to take out notice on the counsel who represents the fourth respondent in OS 8264 of 2023 and inform him that the matter will be taken up for final disposal on so-and-so. What is the steps that you have taken for vacating?
And that's what I will ascertain, my lords. Next date is on 19/6, my lords. It is for plenty of evidence now.
Get it preponed, don't force me to pass.
I will ask them to file I-8 for vacating.
Third. Much of it. Number 27, Shri. Pradeep M. Respondent 7 to 13, man. 7 to 12.
Report is, I have to furnish a report, please, my lords.
The engineers are there, we pray for 1 week's time, lots. Now what transpires is the
Yes.
concerned engineer was not keeping little well. That's it. Now, communication has been transmitted to him. So we've secured, my lords, 2 other subdivision engineers, my lord. They will go to the spot. I need about 4 or 5 days time, my lords. We will furnish it.
Which zone commissioner had come?
Please, my lords.
This was the
Please,
case.
please, my lords. The concerned engineers, my lords, from other divisions, we have got them. I've requested the other divisions, they will go there, my lords, and they will complete the exercise.
Completed all of them? Have they been impleted here?
No, my lords, I have only been directed to furnish a report here. No, not implementing, lords, because what happens that one person is not well. The other 2 subdivisions, the engineers karsi, report nan kodisbiduttanu.
Or are the jurisdiction engineers, they will pay the cost of demolition?
Lords, lords, what transpires is there is no demolition as such, my lord. This is more than what meets the eye. I will produce all those documents. Now, what transpires here is, they have taken the permission, please, my lords, and out of his own cost, it appears he has built it. We have no loss to us, to the state also. So he has built it out of his own cost. The entire material, my lords, I will ascertain, my lords, and we will make a.
Zonal commissioner said on the last occasion that he has passed orders of demolition.
My lord, I am for 7 to 12. May I submit, my lord? Earlier, order for demolition.
This was the case with zonal.
Not that, my lord, that is one another case.
Yes.
Here, my lord, 7 to 12, I appear for 7 to 12, my lord. Earlier, I had, order was passed to remove the culvert. I had preferred a writ petition. I failed in writ petition. In writ appeal, liberty was granted me to approach the civil court. I filed a civil suit. In civil suit, there was an order of status quo. During interregnum, I applied for a sanction of permission, which they have given me. Based on the permission sanction, my lord, at my own cost, I have demolished the culvert existing, and as per the sketch and plan and permission provided by them, I have constructed the culvert. My lord.
Where is the permission granted?
My lord, along with the impleading application, they themselves have produced, my lord.
Along with the?
Impleading amendment application, my lord.
No, that I produced, your lordship. During the pendency of the interim stay, they have obtained illegal license and plan, which again illegal, your lordship. That very grant of permission and license is challenged before this honorable court after the culvert demolition. Because there is a discharging lake, your lordship.
Is that permission granted?
My lord, 23/2/2024, my lord. Page number 14, my lord.
You withdrawn the suit?
Yes, my lord. After withdrawing the suit only, I have demolished the culvert which was existing earlier.
What is there to show that you demolished that culvert?
My lord, before the trial court, I have placed all the materials, my lord.
Court, have you produced anything?
Yes, my lord. I'll place it on record, my lord. That I have demolished and constructed as per the plan, my lord, at my cost, my lord.
What is the prayer in this writ petition?
Earlier writ petition was prayer is to demolish the culvert existing. I have already demolished.
That culvert is illegal, your lordship. Without plan and license. During the interim stay as well as the petition, they obtained another license and permission. Pendency of the writ petition, your
Why
lordship.
do you say that they can't grant permission?
Your lordship.
Why do you say that they can't grant permission?
Because there is a discharging lake and huge water is passing through, your lordship. That is one point. Another aspect is there is already culvert existed next to not more than 100 feet, your lordship.
No, but if
So
they were
this obstruct my this passing of huge water. Next.
ಅದ್ರ ಪಕ್ಕದಲ್ಲಿ ಇನ್ನೊಂದು ಕಲ್ವರ್ಟ್ ಇದೆಯಾ?
Yes, it is been
So
existed.
one ಕಲ್ವರ್ಟ್ ಇದೆ, ಇನ್ನೊಂದು ಕಲ್ವರ್ಟ್ ಅವ್ರ ಆಸ್ತಿಗೆ ನಾವು ಮಾಡ್ಕೊಂಡ್ರೆ
Please.
how are you aggrieved?
So I agreed because the passing of water will distract your lordship.
The other culvert not cause the same problem to you?
That's what my because there is a discharging lake, your lordship. Hudi lake is there. Apart from that, there is a huge water passing. ಒಂದು ಕೆರೆಯಿಂದ discharge ಆಗುತ್ತೆ. ಇನ್ನೊಂದು ಹುಡಿ village ಕಡೆಯಿಂದನೂ huge water ಬರುತ್ತೆ ಸ್ವಾಮಿ. So this culvert is constructed next to within 100 feet. ಅಲ್ಲಿ 100 feet ಅಲ್ಲಿ ಈ ಕಡೆಯಿಂದನೂ ಬಂದು ರಾಜಕಾಲುವೆಯಿಂದ ನೀರು ಸೇರುತ್ತೆ, ಮೇಲ್ಗಡೆಯಿಂದನೂ ಬಂದು ರಾಜಕಾಲುವೆ ನೀರು ಸೇರುತ್ತೆ. All of a sudden they struck your lordship. On that place, the official has to inspect the place and that culvert need not to be exist, your lordship.
I am under the impression that Annexure K
Please.
was issued after doing all that exercise.
Yes, my lord.
Yeah,
So if the engineers are satisfied that the construction culvert
please.
will not impede the movement of water, why should I take the statement of a citizen and say that these experts are
I'm not a
your right?
citizen. I'm next to the adjacent owner, your lordship. Into
You are
this,
not an expert.
that
If you are not the expert, I will listen to the expert.
please.
If they have granted permission, then that is good enough. If the culvert was illegal, then what you say is correct.
That's what senior counsel Kantraj is likely to argue on the matter. Let them furnish the documents all the connected with this. I am agree with that, your lordship, but that culvert itself is illegal and cannot be granted on that place, your lordship, because
what
there is
basis?
already one more culvert is existed and
ಬೇರೆ dispute ಇದೆ ನಿಮ್ಗೂ ಅವ್ರಿಗೇನೋ ಬೇರೆ
never your lordship, never ಇಲ್ಲ ಸ್ವಾಮಿ ನಮ್ಗೂ ಅವ್ರಿಗೂ ಏನು disputes ಏನಿಲ್ಲ. It is their say to their convenient because it.
What have you said in your petitions? Who are you?
I am the next owner of the survey number 73/3, your lordship. The
You are
reason is
against this,
the file is with the
My lord,
senior
he is
counsel,
an
your lordship.
RTA activist, my lord.
You are agreed by the JDA.
Not JDA, your lordship.
Then
I made a representation to the concerned official.
interest.
I'm
What have
the,
you said is your interest?
I'm the owner of the adjacent property, your lordship.
It's there to show that you are one of the adjacent property.
I have furnished the RTC in the first date of hearing, your lordship. 73/3 is 1 acre 3 guntas is my interest, your lordship, adjacent to this property. And by raising of this culvert, your lordship, in the last raining occasion, we are faced many problem. For that itself, we filed a
Next year, Monesh.
representation, your lordship.
C1.
Please,
This was the earlier illegal culvert.
please, your lordship.
Yes, my lord. Yes, my lord.
Now
This was the earlier illegal culvert.
Demolished.
That is demolition.
That is,
Demolished. That is demolished
and again rebuilt over the in very same place, your lordship, with the permission of the BBMP, that do during this interim order, without doing any spot inspection.
That's why I said you are not the expert.
Please, your lordship, I am agree for that, but the
And I will-
proceedings
Lord,
held up
concerned engineer
is
also
all
there.
acts and deeds are during the pendency of the interim stay and without conducting the spot inspection, because as per their BBMP notice, your lordship, there is a 3 guntas of
You deposit 5 lakhs. I'll
Please.
direct some expert engineer to
Please.
inspect the spot, submit a report.
Please.
As to whether the culvert that is now constructed is technically sound. You deposit 5 lakhs tomorrow, I'll ask a concerned engineer to
Anyhow.
make an inspection.
Please, I am no objection for that, your lordship, but kindly have it on 18th because
first you
senior
deposit-
counsel.
First you deposit 5 lakhs tomorrow.
Otherwise, I will ask any engineer to
No, no, I
guide.
don't want your engineer.
Please,
I'll appoint some independent engineer,
Hmm.
high quality engineer, because your problem is high quality.
please,
So we'll appoint a high quality engineer. We'll ask him to correct 5 lakhs and then may submit a report as whether the culvert that is now constructed
Please.
is technically correct or incorrect.
kindly pass it over, your lordship. I just take instruction.
If you're not prepared to deposit 5 lakhs,
No,
I'll dismiss the petition with costs.
no, I am ready. Just I will take instructions, your lordship. Kindly pass it over.
Number 28.
My lord, serial number 28 and 29, kindly pass away.
You are for,
Last time.
whom do you appear for?
Sam could
Respond. My senior.
ಏನ್ ರೆಡ್ಡಿ ಅವರೇ?
directed to Millard,
ನಾ ಪಾಸ್ ಬರ್ಬೇಕಂತ.
pass or
28 and 29.
ಏನ್ ರಿಪೋರ್ಟ್ ಏನಿಲ್ಲ ಪಾಸ್ ಅವ್ರ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೊಂಡೆ
ರಿಯಲಿಸ್ಟ್
ಎಂಟ್ರಿ ಮಾರನಿದೆ.
ನೋಡಿ 29.
29.
Did you,
29 is also, sir. 28 and 29.
now did you furnish that list of email addresses?
My se- My senior is engaged in another course. Arguing another.
Other day,
Case where the zonal commissioner had come last time.
Zonal Commissioner had given a report.
Pass
For that, I have made my reply also. And I have produced all the documents.
out.
Please, ma'am.
Pass out.
Number 30.
Respond.
ಏನ್ ಮಾತಾಡಂಗಿಲ್ಲ ಸರ್. ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ರೆ ಏನ್ ಮಾಡಿ
Yes.
I am supposed to file the objection to the report which has been filed by the BBMP, my lord. I'm serving the copy on the other side. Maybe received on record, my lord.
What are you challenging? Revised NOC.
Revised NOC as well as the modified sanction plan I am challenging, my lord. Very good.
Yes.
Yes, ma'am. My lord, during the year 2014, for the one particular portion of the building, that is the residential building, my lord, NOC was issued by the fire department. That is for putting up a residential
When was the
building.
first plan sanction?
The first plan was sanctioned, my lord, on 12/1/2015, my lord,
12/1.
2015.
That was only for your block.
It is only for my block and it is a residential building only, my lord.
How many floors?
My lord, ground plus 11 floors.
And for this OC was granted.
OC has been granted.
When?
The OC has been granted on 7/1/2019, my lord. Then, my lord, the NOC, fire NOC was issued on 19/4/2014.
2014.
Yes, my lord,
This prior to the grant.
prior to the sanction plan. 19/4/2014, my lord.
Yes.
My lord, then in the year 2023, we came to know that, my lord, the modified sanction plan has been issued and they are proposing to connect the commercial block with that of our residential block.
And that was sanctioned
Yes, my lord.
was only with respect to the property where your apartment complex was
Yes, ma'am.
constructed.
Yes, ma'am.
The commercial property was not related.
It is not reflected. It is not mentioned also. There is nothing mentioned about the commercial block, my lord. Then, my lord, we came to know that they are connecting the proposed commercial block with that of our residential block.
When did they make an application for modified plan?
They submitted application in the year 2000, August 2021, they submitted, my lord. Then modified building sanction plan was issued on 31st August 2021.
When was it granted?
The 31st August 2021.
So your plan was modified. The first plan was modified.
Yes, my lord. First plan was modified.
And what was permitted?
The interconnecting between the commercial block with that of our existing residential.
Permitted the construction of the commercial complex.
Commercial complex. Lord, the reason why they want to connect is that, my lord.
And also connect the residential portion.
Yes, my lord, with the residential portion. The reason why they want to connect is that, my lord, they want to claim the FAR area, which is with respect of the residential area, so that they can claim the residential area with respect of the commercial block as well as the other property. They have, they are attempting to connect it, my lord. my submission is that, my lord, first submission is that once the occupancy certificate is issued and when we are occupying it, meddling with the property which has already put up, which has complete in all respect, the question of connecting with that particular block does not arise, my lord. This is my submission. Then, my lord, we came to know about this. Immediately, we approached the fire department as well as the BBMP, my lord, raising our concern. Then, my lord, we came to know that the fire department has not issued any revised NOC with respect of the commercial block, with respect of the entire block, my lord. Then, my lord, immediately on 13/6/2023, on 13/6/2023, revised NOC was issued, my lord.
Revised NOC.
Revised NOC
By the fire,
by the fire department. That is respondent number 4. Then, my lord, this particular modified sanction plan, which was issued on 31st August 2021, it expired after 2 years. That expired on 30th August 2023.
that is if they don't start construction. If
Yes,
they
my lord.
start
If they
construction,
don't, yes, my lord, I understand. But today, that particular plan has expired. 2 years period.
they started construction,
They have initially they started putting up the construction.
but it won't expire.
Then if the commencement certificate is issued and pursuant to the commencement certificate, if they have put up the construction, my lord, then they can take the shelter saying that we have already constructed and all those things. In this case, my lord, my submission is that even today the commencement certificate has not been issued.
Yes.
Then, my lord, this particular petition came to be filed, my lord, challenging this particular sanction plan as well as revised NOC.
In 2024.
Yes, my lord, in 2024. On 24 January 2024, this writ petition came to be filed.
Challenging the modified plan.
Challenging the revised NOC as well as the modified sanction plan.
Yes.
Then, my lord, this honorable court issued a direction to the BBMP to submit its explanation with respect of its order, with respect of certain questions posed by this honorable court, my lord. And then, my lord, by virtue of that particular order, an affidavit came to be filed.
What is
by-
the order? What is the order?
Yes, my lord. Lord, the order dated 5th March 2024, my lord.
5th March.
Yes, ma'am. My lord, the para number 4 would be the tentative observation made by this honorable court, my lord. The observation reads like this, my lord. Prima facie, court could opine that the outcome of the petitioner grievance turn amongst others on whether the third respondent is proposing the commercial building as a standalone building or as a cluster of building for which the provisions were made even while obtaining the sanction plan on 12/1/2015. And further, this court would therefore opine that it would be incumbent upon the Joint Director of Town Planning, South Zone BBMP, to place on record the following clarification by way of an affidavit. The FAR is permitted while granting the first sanction on 12/1/2015, considering the number of car parking sanction for the use of the apartment owners and the provisions of the additional FAR for commercial construction. Then number of car parking, my lord, then the calculation of FAR, then whether the second respondent has considered while granting the sanction at the first instance on 12/1/2015 or at the time of permitting modification on 31/8/2021, regulation 3.6 of the building zoning regulation, which requires a distance of 50% of height of the tallest building between the two properties, even in a cluster.
Yes. What is the affidavit filed?
The affidavit came to be filed, my lord, on 26th March 2024, my lord.
The 6th of March.
Yes, my lord. The respondent number 2, the joint director filed the affidavit, my lord. Para number 3, my lord, he he starts giving his clarification.
Govindaraju BG.
Yes, my lord. Joint director, my lord. He is the respondent number 2 here. Hearing. I state that para 3 I am reading, my lord. I state that as on 12/1/2015, the license plan was issued for residential building having 2 blocks consisting of 2 basement floor plus ground floor plus 11 upper floors, in all consisting of 329 units. As per the zoning regulation, the required number of car parks are 362 as per table number 23 of the zoning regulation. As per the license plan sanction, 367 car parks are made available. As on the date of sanction of the original license plan dated 12/1/2015, commercial building is not sanctioned, only residential cluster units are sanctioned. Para number 4, my lord. I state that as regards second query sought by this honorable court, being number of car parks required for 140 units, that is the petitioner's apartment building, the occupancy certificate is issued for 140 residential units and number of car parks so provided are 162 totally. In lower basement, 48 car parkings, upper basement, 48 car parking slots, and on the surface area, 66 number of car parking slots are earmarked. This 66 car parking falls within the area, which is now they are putting up the construction. In that area, they are putting up the construction. Now, para number 5, my lord. I state that thereafter, the builder has approached the BBMP.
Where does he say that it is now the 66 numbers?
Yes, my lord.
This is the surface area.
This is the surface area. That
Has he said that here in the affidavit?
in those words, he won't mention, my lord. If the plan is looked into, my lord, if the plan is compared, that particular car parking area is shown in that particular portion.
This is on the surface area.
Yes, ma'am. And number is 66 numbers.
Yes.
My lord, para number 5. I state that thereafter builder has approached the BBMP and filed for remodified plan sanction by proposing new commercial block in the front of the wing 1, that is the petitioner's residential apartment blocks. The same was sanctioned by considering the remodified plan as a single cluster building. Additional commercial block and modified commercial block, the total car park slots required was 176 as per the prevailing zonal regulation. The builder has made provisions for 230 car park slots situated in 2 basement floors in the residential block and 1 basement floor in the commercial block. The sanction plan, that is remodified sanction plan dated 31st August 2021, is produced along with this affidavit. FAR is calculated by considering.
Come back to para 4.
Yes,
for the residential unit, the required number of car parking is 162.
Yes, my lord.
Then he says 230 was made available for the residential blocks in the original plan itself.
No, my lord.
What is the meaning? Here he says.
Yes, ma'am. The builder has made provision for 230 car park slots situated in 2 basement floors in the residential block. There are 2 blocks are there, my lord. Now,
Floor
and one in the commercial block. So commercial block was not contemplated in the original plan, my lord. So providing
the sum total both for residential and commercial.
Yes, my lord.
Now the number of parking slots are adequate.
My lord, the car parking is one attempt to understand whether in the surface area which is earlier earmarked, which is being eaten out by the builder for the putting up the commercial building.
Correct.
Yes, my lord.
Now in that parking lot area.
Yes, my lord.
66 parking lots.
Yes, my lord.
Was that an undivided share granted to you in that also?
Yes, my lord. That is the area, that surface area, that particular 66 car parking, which annuled to my benefit, my lord. And now that particular 66 park. My lord, I will just complete it, my lord. No, my lord, let me complete, my lord.
I have to clear my doubt.
Yes, sir.
The 66 surface parking area that was granted to him, that was also the subject.
That was for the residential apartment.
No. Was undivided shares. You are not for the builder, correct?
No, I'm not for the builder. I'm for only the.
You are for the builder.
Yes.
The 66 car parking area referred to in para 4.
Yes.
Was an undivided share in this particular land also conveyed to the apartment owners?
Entire land al kottirodu idralli antalla.
Initially he told me that the commercial block was not part of the plan.
Illa, it was not part of the plan, but it was part of the brochure and they were intimated all that. That I'll point out. Initially, my lord, when we came up with the brochure for sale, They were all notified about it. I'll point out all. Brochure has it.
Yes.
And the entries, my lord, from this to both all the car parking places. I'll point out.
Yes.
Yes, my lord. The para number 5, my lord, the middle portion, my lord. The builder has made provisions for 230 car park slots situated in 2 basement floor in residential block and 1 basement floor in the commercial block. The sanction plan, that is the remodified sanction plan dated 31st August 2021, is produced along with this affidavit. FAR is calculated by considering FAR utilized for occupancy certificate issued building, including the petitioner's occupied building. So whatever the FAR which is available with respect of my property, that has been taken into consideration for issuance of a modified sanction plan.
Consider the entire plot
Yes,
as one now.
yes, my lord. Then they have issued it. And that is the reason why they want to connect with my building, my lord. Then, my lord, para number 6. I state that in a cluster of building, the regulation 3.6 of the building zoning regulation will not apply since the entire commercial and residential blocks is sanctioned as a single cluster building. In fact, at the stage of issuance of remodified plan, the BBMP should have sought the consent NOC from the petitioner society of apartment owners. The same is inadvertently missed out. In fact, builders has virtually played tricks upon the BBMP by initially taking license plan sanctioned for residential units, submitting remodified plan, including for commercial space, applying for the occupancy certificate for residential block, considering the entire built-up area as a single cluster. So he admits that, my lord, before issuance of the modified sanction plan, meddling with my particular building, there was no consent. My lord, there is one particular Supreme Court judgment, my lord, recent Supreme Court judgment. Sorry, para number 7. I state that builder is no longer the owner of the residential apartment sold in favor of the members of the petitioner society for which occupancy certificate is issued. Hence, the question of clubbing the proposed commercial building without the consent of the petitioner society is impermissible. Notice is also issued in this regard to the builder to apply for fresh remodified plan after securing the consent of petitioner society. In the event the consent is not secured from the petitioner society, half of the height of the tallest building or minimum 16 meters between the 2 blocks should be maintained as per the zoning regulation 3.6, my lord. So
Have they withdrawn the sanction plan?
this is the statement, the para number since this is the statement.
Have they withdrawn the sanction
My
plan?
lord, I am not aware of that, my lord, and they have made a statement.
Please, that I not assert on, my lord, but what we have stated is, we should have secured these lots, the NOC.
No, if your statement is to be accepted as correct,
Please, my lord.
then the sanction that you are now granted for the modified plan is incorrect.
But we should have secured this plot with permission from the petitioner.
So you have not secured even according to the.
They have not given us the permission.
So therefore, the sanction of this particular modified plan
We have insisted this thing. That is what we have stated in para number 7.
that is incorrect.
But what we have stated in para number 7 is, we have to insist now at this stage, that they will have to secure this,
No, I don't understand this, Munesh. You're always, you are stating that a trick was played on you.
Paid on us.
And you have granted a modified sanction plan, even though there was no permission of the association.
Please.
You admit that their consent was required. So the consequence of these two is that the modified plan that you now granted to them is incorrect.
Is incorrect as regards to not securing
So
the NOC.
until they get consent, this plan can't be enforced, can't be implemented.
Please.
If this can't be implemented, then 3.6 comes into play. They'll have to maintain a minimum distance of 16 meters.
16 meters.
Have you communicated this to the builder saying that you cannot act upon this remodified plan because of these defects?
That I will assert, and my engineers will have stated as such. I will assert in that aspect. That has come out of the.
Then what is the report that you filed on the last occasion?
So the entire report is not, I was directed not to go and inspect. And the fire furnaces not is there. In the sketch also they produced. Last part is the sketch. It is measured in the sketches.
Now, this is the, what was the report directed? When was this report ordered?
There's one more affidavit filed by this very gentleman.
Where is that?
If your lordship, my lord, on 23/4, he files another affidavit. ಯಾವುದು ಅಂತ ತಾವು ನೋಡ್ಬೇಕಾಗುತ್ತೆ. 23/4/2024 ಅಲ್ಲಿ ಸೇಮ್ ಬೆಟರ್ ಅಫಿಡವಿಟ್ ಅಂತ ಏನೋ ಹಾಕಿದ್ದಾರೆ ನೋಡಿ.
There's only one affidavit.
ಇಲ್ಲ, ಇನ್ನೊಂದು ಆಗಿದೆ. ನಮಗೆ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
Does it say anything contrary in that?
Yes, yes, yes. ಅದೇ ಅದಕ್ಕೆ ಹೇಳಿದ. That affidavit has been filed, my lord. There is some of the portion which I read out, my lord, particularly para number 5 and 6. Those portion have been omitted.
23-4.
Yes, my lord. 23/4/2024. The paragraph number 5 and 6. Those portion have been omitted, and the earlier affidavit remains as it is. It is on record.
He is referring to an affidavit 5/3/24. ಯಾವ್ದು? The second affidavit. Where is this 5/3/2024? Para 2.
There are two, my lord.
What is that affidavit?
My lord, that is the affidavit dated 26/3/2024, my lord. That is the affidavit. What he refers to. The order he refers to, and the order dated 5/3/2024, my lord. He refers to that order. There is a typographical mistake, my lord. What he refers to is the order. The order is passed on 5/3/2024 by this honorable court.
Which of the two affidavits should I take now? No, no. He does not disown the earlier affidavit.
He don't disown, but
So,
what they are saying is.
That portion of the affidavit,
Yes, my lord.
which says that the modified plan was incorrect because it did not have the consent of the
Consent.
society.
Please.
Should I accept that to be correct or incorrect?
But it should be correct only, because for this, may I submit, please, not. Now, what happens is, this has been considered as a single cluster. The new plan and the earlier existing structure has been considered as single cluster. That way of the fact, not that we are saying, not that we clarified, not that 3.6 of the building zoning discussion would not.
No, you will please come back to the earlier affidavit. That is not what is stated there. Please come back to the earlier affidavit.
Please, what we have stated is.
Please read para.
Para 7, please, notes. May I read, please, notes?
Yes.
I state that the builder is no longer the owner of the residential
No,
apartment.
read from para 6 again.
6. I state that in a cluster of building, regulation 3.6 of the building zoning regulation does not apply, since the entire commercial and residential block is sanctioned as a single cluster building. In fact, at the stage of issuance of remodified plan, DPP should have sought the consent NOC from the petitioner society of apartment owners. The same is inadvertently missed out. In fact, the builder has played virtually tricks upon the DPP by initially taking license plan sanction for residential units, submitting remodified plan including for commercial space, applying for occupancy certificate for residential blocks, considering the entire built-up area as a single cluster.
This is his affidavit.
Please, this is our affidavit.
Therefore, when he granted the plan earlier, it was only for one single residential building.
Yes,
Now he therefore states that he is trying to convert this into a single cluster building.
single cluster.
And he says that is a mistake
That is the mistake.
because the builder has submitted without getting the consent of
Consent of
the members.
petitioner society.
So if this is correct,
Please,
if this portion of the affidavit is correct,
please.
then the modified plan is illegal.
That's modified plan is illegal to the extent that they have not secured, please, my lord, the consent of the petitioner society.
If there is no consent, what is the effect?
But that is what, please, my lord, that I will have to ascertain whether the record it or not. That one aspect I will ascertain. What will be the remedy that will follow? Recourse to us. Mistake agide. But we have accepted in the FF. We should have taken, because it is considered as a single cluster.
If there's a mistake, what have you produced to show that you informed him that you have obtained the modified plan by misrepresentation or by not stating?
No, not by misrepresentation. It is without the consent, please, my lords, of the petitioner society.
So you should at least say, we granted permission inadvertently without noticing. We do not have the permission of the association. Secure and tender communication madidira.
Then I like to ascertain.
Have you got any notice?
No. In fact, I must also tell your lordships, they filed a suit. Suit ali bere, I'll point out all that.
No, but now that this affidavit is.
Even
not
that
recorded-
affidavit, my lord, whether, my lord, that affidavit is correct or not is what your lordships will have to look at. Because ultimately, my lord, your lordships will look at the law and then decide, my lord. Yeah, affidavit ಮೇಲೆ ಮಾಡ್ಲಿಕ್ಕಾಗಲ್ಲ.
No, is there a provision for you to?
ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ?
Transfer. He said himself, they'll file a better affidavit file is not incorrect. That is why this affidavit is filed. Because bylaws does not
My
say.
learned friend says, ಆ ಹಿಂದಿದ್ ಸರಿ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ನಾನು ಇನ್ನೊಂದು affidavit
No, there's not one single averment in the second affidavit saying that I made a mistake in my first affidavit.
ಎಲ್ಲಿದೆ? See, what my learned lord is, my, if you see here, where he said that earlier affidavit is wrong.
Conveniently
ಅದೇ
skips.
correct. What your lordship said, ಅದ್ರಲ್ಲಿ ಬರಬೇಕಲ್ಲ.
When the issue was raised, see, the zoning regulations are any other regulations of BBMP will not say the permission of the society, other apartment owners is required. That is not mandate of zoning regulation.
said-
All these issues were raised, my lord, at the time when the
I had
affidavit
wrong
is filed.
stated, I had wrongly stated in an earlier affidavit that permission was required. According, the zone regulations don't require that permission.
ಅಂತ ಅವ್ರು ಹೇಳಿಲ್ಲ.
Clarify ಮಾಡಿದ್ರೆ,
Correct, correct.
that is one thing. It does not disown this affidavit.
No, my lord, they say, I state that certain clarification was
You
sought.
can't explain the affidavit.
In the affidavit, no, my lord, in the affidavit they have stated.
Situation here is not, they have now sorted as a single cluster, my lords, for whatever be the reason. If they had sorted for a single cluster, please, my lord, then the mandate, please, my lord, for the permission of the petitioner society is a requirement. That is inadvertently slipped. That is the fault on our part. That is what
Then
they
your
did.
plan is,
My lord, that would be a question which your lordships will have to decide, whether, my lord, NOC is needed or not. That,
show me from the regulations that NOC is not required.
my lord, NOC required ಅಂತ ಹೇಳಕ್ ಬೇಕಲ್ಲ. It's
Sir,
not,
show me
not
the-
the negative. It's the positive, my lord, which they'll have to
The
prove.
zonal regulations, when do you seek for modification of the sanction plan?
My lord, please, can I request your lords to look at, my lord, the suit filed by them, and before that, please look at the brochure. I'll come to you.
I'll come to that. I'm only concerned with the statutory requirement.
Huh.
There was a sanction for residential building.
Correct, only, my lord, with regard to, my
Common
lord,
sense understanding of a modification is that plan is modified.
no,
If
that,
you
my
want-
lord, what has happened is they have added now. It is, my lord, modified in the sense, my lord, that earlier plan is not,
So what is the regulation which relates to addition of an existing building under the regulations?
I do not ಹೇಳ್ತೀನಿ ತಮ್ಮ. Let me not waste your lordship's time. ಬಿಲ್ಡಿಂಗ್ ಬೈಲಾದಲ್ಲಿ ಏನಿದೆ ಅಂತ ಹೇಳಿ ನಾನು ನೋಡಿ ಹೇಳ್ತೀನಿ, ಬಿಕಾಸ್ ಐ ವಾಸ್ ಇನ್ಫಾರ್ಮ್, ಅವ್ರೇನೋ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಆಗ್ತಾರೆ, ಅದು ನೋಡ್ಕೊಂಡು ನಾನು ಹೇಳ್ಬೇಕು ಅಂತ ಹೇಳಿ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಇನ್ನಂತ ಗೊತ್ತೆ. Your lords may have it, my lord, tomorrow day after, any time convenient, your lords, I'll be Monday to assist your lords. But need be on Tuesday, my lord, because Monday ಅಲ್ಲಿ third court ಒಂದು ಹಾಕೊಂಡಿದ್ದಾರೆ. Not inconvenient to my lords, Monday.
The objections filed with the petitioner to the report is taken on record. Keep that joint director present.
Please, my lords.
He files an affidavit and walks away.
No, it is not like this, my lords. We have accepted, please, not that the requirement, it was missed out.
Manish, if you accept a mistake, if you don't take any consequential action,
Consequences, that I'll ascertain, but that has to follow, has to follow. The consequences will have to follow.
then I note that is irresponsible,
Irresponsible.
telling that fact before this court, that there's a mistake and not taking corrective measures.
Please, my lords.
He's a joint director.
Joint director. He is a joint director. But I'll ascertain, please, my lords, and we'll keep the responsible officer present.
No, that very joint director who has filed the affidavit.
Retired. The appears he is retired. I'll give the next available officer, my lords, was.
Keep the successive,
Please, I'll do that. That we have, with fairness, my lord, said that, we have not.
not in fairness, then where is the need for the second affidavit?
Not filed a better affidavit.
Who asked you to file a better affidavit? That better affidavit is creating a problem now.
When the discussion came up, lords, before the court, I was directed, please, not that the better affidavit we filed, I filed a better affidavit also. In the earlier instance, not some decision came. That is the reason.
31.
The plans are not, my lords, in violation of the zoning regulation. But only thing is, my lord, they have not sought, my lords, the permission of the petitioner.
I think you should be very careful when you file affidavit, especially for John Director.
ಇದು ಮಾತ್ರ ಅಲ್ಲ, before the court, my lord. Forget your-
John Director ಆಗಿ ಅವರು.
Anyway. Right. Amendment, in fact, we have filed the petition by the inadvertence. 3 parties for,
Amended petition. Amended cost petition itself is filed. Therefore, office objections are overruled.
Lord, writ of mandamus was sought against respondent number 1 and 2 initially. Lord,
Lord, we have engaged senior counsel, my lord. Kindly let the cost to be amended, my lord. We'll argue the matter.
ನೀವು neighbor
Alla neighbor alla, I am the purchaser.
this is the joint family property in respect of which I am filed a suit for partition. There certain illegal constructions come up and an application.
ಏನಾಗಿದೆ suit ಏನಾಗಿದೆ?
The suit
Suit
is
is still
pending.
pending
Suit is
consultation,
pending. An application filed in the suit for, restraining these people was
ನಿಮ್ಗವ್ರಿಗೆ ಏನ್ ಸಂಬಂಧ?
ಏನಿಲ್ಲ. They are third parties,
They are the
unconnected with
purchaser,
the
they are the
family.
sellers, my lord. I am the
Unconnected
purchaser.
with the family.
They are the seller and I am the purchaser.
1 second. Then in an MFA before this honorable court, which is also pending, a statement was made by these private respondents. If at all these structures are constructing without taking any sanction plan with the local authority, then the petitioner will be free to initiate action. Thereafterwards, I filed a representation to the, Mysore.
ಸೂಟ್ ಸೆಟಲ್ ಮಾಡ್ಸಕ್ ಟ್ರೈ ಮಾಡ್ತಿದ್ರೆ.
ಇಲ್ಲ, ಸೂಟ್ ಸೆಟ್ಲ್ ಅಂತಲ್ಲ. ಇಲ್ಲಿ ಏನಂತಾರೆ, ಇವ್ರಿಗೆ ಯಾವುದೇ ರೀತಿ now the thing is, my lord, who is to build the cat? Likewise, I have implemented.
ಹೊಡೆದಾಕಿದ್ರೆ ನಿಮ್ಗೆ ಏನ್ ಸಿಗಲ್ಲ ಅಲ್ವಾ ಬಿಲ್ಡಿಂಗ್?
No. See, I am this is the giant family agricultural property.
ಅಲ್ಲ, ನೀವು ಸೂಟ್ ಡಿಗ್ರಿ ಆದ್ರೆ you will not get the benefit of the
And this,
construction.
under the Urban Land Ceiling Act, my lord, we have our family has got the property and
Is not ready.
number 32.
Much obliged.
Lord, anything is
ಈ ಗ್ರೂಪ್ ಬರುತ್ತೆ, ಈ ಗ್ರೂಪ್.
number 32.
Petitioner, my lord. Tax paid ಮಾಡಿದ್ದಾರೆ, my lord.
ಏನ್ dismiss?
For the respondent, my lord, this writ petition has become the infractuous. Tax is already paid, my lord. We filed a memo.
Respondent.
Kindly dismiss this case.
Respondent has filed a memo stating that petitioner has paid the tax arrears on 26/11/2024 and hence the petition is infractuous. In the light of the memo filed by the respondents, the petition is dismissed and become infractuous.
Obliged.
Number 33.
Appearing for
Respondent
respondent.
corporation.
Kindly 1 week time may be granted to take the steps against the.
ಎರಡರಲ್ಲೂ ಅದೇನಾ, ಅವರೇ ಸೇಮ್ petitioner?
No, my lord. Dealing that matter, my lord. Dealing that matter.
Because though the subject matter is same, the petitioner and the land in dispute is also different lordships.
Subject matter same.
A Khata, B Khata ಏನೋ challenge ಮಾಡಿದ್ದಾರೆ.
Same village, my lords.
No,
Same
village is different.
Village is different.
Village is different. Is
Better to.
my lord, dealing this matter because this is a first petition, my lord, is pertaining to Pattangere. That is Gididakonenalli village. Hobli is Yashwantpura Hobli.
It's totally different.
Hobli is
Totally different.
Properties are too different.
B Khata ತಾನೆ problem.
Also, but yeah,
They can grant
In this matter, the allegation of the first petition, my lord, is allegation is that this is the bogus Khatas, first matter, serial number 33, 8760 of 24. Allegation of the petitioner is that created bogus Khatas. We obtained RTA, they have issued RTA, all Khata certificate. Now this honorable court directed to file a report. The report had to file by the BBMP, whether the Khatas are issued or not.
the interim report, my lords, has been filed along with a memo on 24.
what is your report?
My lords, ಖಾತಾ ಕೊಟ್ಟಿರೋದು correct ಅಂತ.
They are saying that
They are not
interim
bogus.
report. They are saying that the Khata is correct, but they have issued an endorsement that the Khata is bogus to me when I applied for the through RTA, my lord.
First matter.
Now they are
What
saying
is
that
your
Khata is.
Further inquiry that you have said is required?
My lords, it is only placed before the zonal commissioner for his approval last time, my lords.
Because of this petition, we are suffering, my lord. We purchased the properties, individual sites are, holders are there.
We'll have to withdraw the endorsement that was issued to the petitioner, and the khatas that has issued are correct. They are not bogus, my lords.
Shall I record your statement and close the proceedings?
I'll file an affidavit, my lords, so we will let it be a judicial order.
List, WP 25964 by 2024, we dealing.
The submission may be not.
Alla,
The urgency, my
let
lord,
it be
we
a-
are site holders suffering from long because of unnecessary. Yes.
Stuck anta ಅವರು
One date at least, my request, my lord. On 8 next week.
21st.
Yes.
33.1 on 4/12, this honorable court may not directed them to
ಏನಾಯ್ತು ಕಾರ್ತಿಕೆ?
My lord,
ಅವ್ರು
as
report
regards,
ಹಾಕ್ಬೇಕು.
ಅದನ್ನ ಹಾಕ್ತೀನಿ ಸೊಮ್ಮೆ, with respect to them.
Karthikeyan seeks for a week's time to file a report as ordered earlier. Realist on.
And dealing, my lord, my request to dealing the both.
ಆಗಿದೆ.
Great.
List not, date for 21st. 21st.
Say number 34. Lords, the lordships may kindly take IA number 1 of 24 minutes that I filed for.
Please, the lordships. This have been engaged yesterday, my lord. I'm not fully ready, my lord. Could your lordship give me a short date, my lord?
Lords,
Anytime during next week also, my lord, other than 20th.
ಗೃಹ ಪ್ರವೇಶಕ್ಕೆ ರೆಡಿ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಮನೇನ. If
Lord,
if at all
nothing will
somebody.
be done,
if-
nothing will be done. Your lordship. And in the meantime, if my land friend is willing, my lord, after their neighbors, they can sit across the table and sort out also mediation. because
100% deviation, FAR.
ಅವರು ಏನಾದ್ರು ನೀವು ವಿಡ್ರಾ ಮಾಡ್ಕೊಳ್ತೀರಾ ಅಂತ ಕೇಳ್ತಿದಾರೆ ಅಷ್ಟೇ. ಏನಾದ್ರು
Sit
ಡಿಮ್ಯಾಂಡ್
across the after neighbors, they can think of that also because in our ಮೇಲೆ ನಾವು ಕೇಸ್ ಹಾಕೋದು.
It is not permissible in law, my lord.
ಆಯ್ತು ಕಣ್ರಿ, ಕಾನೂನು ಸರಿ. ನೀವು ಅವರು ಚೆನ್ನಾಗಿದ್ರೆ ವಿಡ್ರಾ ಮಾಡ್ಕೊಳ್ತೀರಾ ಅಂತ ಕೇಳ್ತಿರೋದು. ಇಷ್ಟ ಇದ್ರೆ ವಿಡ್ರಾ ಮಾಡ್ಕೊಳ್ಳಿ, ಇಲ್ಲ ಅಂದ್ರೆ
Anytime Saturday or Monday mediation ಹಾಕೊಂಡು ಬೇಕಾರೆ.
ಮಿಡಿಯೇಷನ್ ಬೇಡ ಬಿಡಿ ಅವ್ರೇನು.
Yes, let him think over the options, my lord. And
ನಿಮ್ಮನೆಲ್ಲ ಕರೆಕ್ಟ್ ಆಗಿದೆ ತಾನೆ?
ನಮಗೂ ಇವಾಗ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅದಕ್ಕೆ ಹೇಳಿದ್ದು, that's what it is.
ಅದಕ್ಕೆ ಹೇಳಿದ್ದೇನೆ, ಸರಿ ಮಾಡ್ಕೊಳ್ಳಿ ನಿಮ್ಮಷ್ಟು ನೀವೇ. Don't allow it to come to the court. I have limited options for your house and for his house.
ನಂದು 15 ವರ್ಷ ಮುಂಚೆ ಕಟ್ಟಿದೀವಿ, ಇವಾಗ
ಅಲ್ಲ,
notice ಕೊಟ್ಟಿದ್ದಾರೆ.
ನೀವು ರಿಸ್ಕ್ ತಗೊಳ್ಳಿ, ನಮ್ಗೇನ್ ತೊಂದ್ರೆ ಇಲ್ಲ. ಆಯ್ರುಗಳು ಜೀವನ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ. ಬಟ್ ಬಿ ಕೇರ್ಫುಲ್.
Lordship have it on next Friday, my lord.
21st.
Great.
Say number 35, PGS Prasanna Kumar.
For the petitioner, my lords, I pray for 2 weeks' time to issue.
Who are the respondents? Now there is a to take notice for respondents. Respondent. Copies will be furnished to him immediately.
Say number 36, H.S. Santosh.
Lords, 36, I am appearing for the petitions council in this matter, my lords.
Yes.
Lords, in respect of properties subject matter of a partition, 2-3 items of properties, they have already registered Khata. And your lordships are directed on the last occasion, my lords, the endorsement which is under challenge at Annexure A, in the juxtaposition with Annexures E and F, how it was issued, my lords, your lordships wanted the BBMP to make a statement. Annexures E and F, same properties. Your lordships were to see Annexure E, my lords.
Annexure?
Annexure E. It's at page number 76. 76 and 77, my lords.
This is in respect of which property?
Lords, the very same property, my lords, which is the neighboring property allotted to the share of another person, another family member.
May I take my lordship's kind attention to Annexure F, my lords, at serial number 5. Lords, on ಚೂರು ಹಿಂದೆ ಮುಂದೆ ಹೋಗ್ಬೇಕಾಗತ್ತೆ my lords ಈ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ. ಏನಕ್ಕೆ ಅಂತಂದ್ರೆ my lords, this is 5,200 square feet, my lords. At serial number 5, my lords, Annexure F, serial number 5 ಅಲ್ಲಿ, at tabular column ಅಲ್ಲಿ, my lords. 5,200 square feet. The ಏಕನಿವೇಶನ ಸ್ವತ್ತು, my lords. For ಏಕನಿವೇಶನ, for this 5,200 square feet, my lords, conversion was taken, Khata was issued. My lords, that is at ink page number 37, my lords. ಆ ಪಾರ್ಟಿಷನ್ ಡೀಡ್ ಅಲ್ಲಿ ಆ 5,200 ಸ್ಕ್ವೇರ್ ಫೀಟ್ ಕಂಪ್ಲೀಟ್ ಖಾತಾ ಇಶ್ಯೂ ಆಗಿದೆ.
37
ಇಂಕ್ ಪೇಜ್ ನಂಬರ್ 37. ಐಟಮ್ ನಂಬರ್ 5, ಪೂರ್ವ ಪಶ್ಚಿಮ 65 ಅಡಿ, ಉತ್ತರ ದಕ್ಷಿಣ
On the
5,200 square feet. My lords, now if I may draw my lordship's kind attention, you my lords, at
this
page number
5,200
74.
5,200 was allotted to Jayalakshmi.
Yes.
The partition deed.
Under page number 5, yes, my lords. That is the sister,
What has
one
happened?
of the
Jayalakshmi
family
has
members.
divided their property.
Yes, my lords. My lords, at page number 74, if I may draw my lordship's kind attention. If my lordships were to see the schedule A property, out of the 500, 2,000 square feet, more site ಮಾಡ್ತಾರೆ ಸ್ವಾಮಿ, without taking the conversion. This is 1,200 square feet, 30-40 site. For this, there is no conversion. For this, there is no development plan for which annexure A endorsement has been issued, my lords. Without 5,200 square feet is of the family member. ಏಕನಿವೇಶನ ಸ್ವತ್ತಿಗೆ conversion ಮಾಡ್ಕೊಂಡು ಬರ್ತಾರೆ, ಅದಕ್ಕೆ ನಾವು ಖಾತಾ ಕೊಡ್ತೀವಿ, my lords. For this particular property, my lords, they have subdivided that 5,200 square feet, which is at item number 7, ink page number 28, my lords, if I may draw my lordship's kind attention.
Page number
28, my lords. 28 5,200 square feet, my lords. This is the entire extent. ಅದರಲ್ಲಿ ಇವರು 3 ಸೈಟ್ ಮಾಡ್ತಾರೆ ಸ್ವಾಮಿ, 3-4 ಸೈಟ್ ಮಾಡ್ತಾರೆ, my lords.
When was this partition did?
2006, my lords.
Next year?
B, in page 10.
Page number 10, my lords, 29/3/2006.
2002.
2006, my lords.
2006, my lords.
And the sale is?
Sale it is recent, my lords.
2023, my lord. The sale is of 2023.
This is on 2023, my lords. March 23, my lords.
Their condition is that the property has been divided into 3.
My lords, the entirety of the property forms subject matter of 2 sale deeds. This 4,200 square feet.
The property was 5,200 square
My lords,
feet.
the statement which was made saying that 5,200 square feet has not been converted, has been converted as not a correct statement. This is a khata which has been standing in the same status. There is no conversion pertaining to annexure E and annexure F. Even if your lordships were to see annexure E.
That's not what he's saying. What he's saying is the khata was registered in respect of a plot bearing 5,000, measuring 5,200 square feet.
Yes.
So the person who was allotted that particular property under the partition deed.
Lords, his contention is that it was converted, it's not converted. Endorsement issued is that there is no conversion, number 1, and there is no vibhajane.
Vibhajane ಹೇಳಿ ಸಾಕು, conversion ಆಮೇಲೆ ನೋಡೋಣ.
Lords, so far as vibhajane is concerned, my lords, the khata was earlier standing, and these 2 sale deeds, there is one more repetition. Those 2 sale deeds, my lords, if your lordships were to see, 1,450 square feet, and the other sale deed, my lords, is again.
Now, can you divide a bigger plot into 3 plots without the approval of the planning authority?
Lords, the request is only to make the khata, my lords.
There's a provision under section 17(2)(a) and the concept, which bars them from making out the khata unless the division of the plots.
Lords, this is only 1,000 plot. So 5,200 has been divided into 3 plots and has been sold to 3 different purchasers for which there was already a khata.
No, if suppose for the other 2 sites they had made out the khata, then I would have directed them.
Yes.
But if they have not accepted the division list of the other 2, I can't ask them to accept division.
Lords, the same state of affairs is existing even as on today, because so far as 5,200 and 5,200, 5,200 is concerned, there is no division of property in terms of section 17. 17A applies not equally in respect of section 5,200 square feet or a lesser extent in 5,200 square feet. They have already made out khata.
So under a 46 state of BDA, you can divide it into 4 portions and build 4 separate buildings.
Lords, these transactions have happened, Lords, in respect of these 30-40 sites. Yes.
Are they legally permissible?
Lords, it is permissible. I can sell half the site, Lords. It is permissible for me to sell half the site out of the property which I own. Lords, I am the absolute owner. There is any question of prohibiting, because if I purchase a 30-40 site, Lords, there are instances where 15 by 20, 15 by 30 feet or 15 by 40 feet, they have sold it.
You're insisting on the khata. Khata means you will have to pay tax. Don't pay tax. Jayalakshmi will pay tax. Why do you want khata from them?
Lords, I wanted to start with the development of the property, Lords. Now that I have purchased, it's a residential site.
Once you want to develop that particular plot, there are certain requirements.
Lords, that's true, Lords, but the whole area is already developed. There is nothing which needs to be done. The entire area is already developed. They are already made out khata in respect of the entire layout.
If you can give me a citation which says if the property is developed, I can issue a direction to register the Khata. I'll gladly probably allow 1,000 writ petitions.
I understand, my lords.
There's a
Lords,
difficulty. I don't think.
Lords, so far as, my lords, now they are only basing it on the basis of the circular which has been issued, my lords. That is the endorsement issued.
Maybe it's not for me to advise you, but maybe you should consider challenging that circular.
Circular. I
And see if
understand.
you can do.
I get it, my lords. I shall do that. Lords, let them put it on the on affidavit, my lords, or by objection, so that I can respond to it and
Most in group objections if any.
lordships.
Number 37, B. Ramesh.
Lords, after obtaining necessary approvals and permissions from the competent authority, my lords, after obtaining conversion, my lords, I have formed a layout.
Yes, Yogesh.
Was 2 times the layout has been approved by planning authority.
Let him objections hakidara.
Illa, this is the judgment, my lords, which is covered by the coordinate.
Let him come. Let him.
Yes, my lords.
So,
Number 38, Sri Chandrasekhar B. Appeal for petitions. 2 weeks time may be granted.
2 weeks to complete the also.
Number 39, Sri V. Sidramaya.
2 weeks time may be granted, man.
Weeks time.
Sri number 40, Sri Bhaskara M.
I appeal for the petitioner. The notice is served on R2 also, master question.
It's for respondent number 1 and 2, my lords.
Ready, not ready?
Please.
Yes.
Before commencing.
Annexure K.
Before commencing.
What is Annexure K?
Annexure K is the order passed by the R1 your lords. That is under challenge.
ಇದೇನು ಈ ತರ ಇದೆಯಾ ಒತ್ತುವರಿಗಳನ್ನು ತೆರವುಗೊಳಿಸುವ ಪ್ರಾಧಿಕಾರಿ ಆತರ ಇದೆಯಾ ಒಂದು ಅಥಾರಿಟಿ
ಲೇಟೆಸ್ಟ್ ಇದು ಸರ್ವೆ ರಿಪೋರ್ಟ್
ಕರ್ನಾಟಕ ಪಂಚಾಯತ್ ತೆರವುಗೊಳಿಸುವ ನಿಯಮಗಳು.
Lordships may kindly see, I kindly ask your lordship to turn to Annexure D. It is the representation given by the petitioner herein for change of Khata, for e-Khata.
What is Annexure K? You are asking for quashing of.
That's what. When I given for e-Khata.
What is Annexure K? First?
Annexure K is, my Khata was cancelled and they got the Khata into their name.
Their name and your name.
Our R1, Panchayati ಹೆಸರು ಖಾತೆ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟು.
What is reason for cancelling the Khata?
That's what. Annexure D ಅಲ್ಲಿ ನಾನು ಈ ಖಾತಾಗೆ ಹಾಕಿದಾಗ from 65 I am in possession.
First Annexure K ಅಲ್ಲಿ ಕಾರಣ ಹೇಳಿ ನನಗೆ.
Annexure K ಅದನ್ನೇ ಸ್ವಾಮಿ ನಾನು ಹೇಳ್ತಾ ಇರೋದು 4/8/28 ಅಲ್ಲಿ Annexure D ಗೆ ನಾನು ಈ ಖಾತಾಗೆ ಹಾಕಿದಾಗ ನನ್ನ ಖಾತಾ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿ ಅಂತ ಪೊಲೀಸ್ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ರು. Thereafter they sumoto held the proceedings and passed this order.
What is the reason given for them to cancel? ಅದನ್ನ ಹೇಳಿ sir.
You are only in illegal possession ಅಂತ ಹೇಳ್ತಾರೆ ಅಷ್ಟೇ. That is the only reason given by them. Janger number ಅಲ್ಲಿ ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ. I have produced the at Annexure B, I have also produced my Khata standing from the 88-89 till 21-22 my name was standing. Annexure B. Page number 48. With regard to petitioner, it comes at, starts from para number 14, page number 40. Annexure K.
So you have no documents to show that, how the land was granted to you, purchased by you? ನಿಮ್ಮ ಹತ್ರ ಏನಿಲ್ಲ.
I am in long standing possession from 1965 onwards, Khata standing in my name as per their.
ಲಾಂಗ್ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಅಂದ್ರೆ ಯಾವ ಆಧಾರದ ಮೇಲೆ?
Khata ಇದೆ, 89 ಇಂದ Khata ಇದೆ ನನ್ನ ಹೆಸರಲ್ಲಿ. No registered, no registered document is available.
They are doubting the Khata. How did you acquire the property?
I'm in possession from.
ಆಯ್ತು. How did you acquire it?
Acquisition ಇನ್ ಬಗ್ಗೆ ಎಲ್ಲೂ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇಲ್ಲ.
then
Khata ಇದೆ. But
Then it is according
ಅಲ್ಲ,
to
ಲೇಟೆಸ್ಟ್ ಇದು ನಾನು ಇವತ್ತು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡೋದ್ರಲ್ಲಿ ಇವತ್ತಿಗೂ ಅದು 7 ಎಕರೆ 30 ಗುಂಟೆ ಅಂತಾನೆ ತೋರಿಸ್ತಾ ಇದ್ದಾರೆ. ಲೇಟೆಸ್ಟ್ ಆಫ್ಟರ್ ದಿಸ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ದಿ ಲೇಟೆಸ್ಟ್ ಸರ್ವೆ 6/9/23 ಅಲ್ಲಿ ತೋರಿಸಿದಾಗ 7 ಎಕರೆ 30 ಗುಂಟೆ ಅನ್ಸಂತಾನೆ ಅವರು ಸರ್ವೆ ಮಾಡಿದ್ದಾರೆ. ತಾಲೂಕಾ ಸರ್ವೆ ಅವರು ತಮ್ಮ ಹೆಸರು ಖಾತೆ ಮಾಡ್ಕೋತಾರೆ. ಇದೇ ಸೇಮ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ ದಿ ಅದರ್ ಪರ್ಸನ್ ಹ್ಯಾಸ್ ಬಿನ್ ಸಕ್ರಮ ಅಂತ ಹೇಳ್ತಾರೆ. He has also no document to show that only on the some partition deed, but the entire 7 acre 30 guntas is the say land is government land. The other person has been given sakrama anta avrige certificate ಕೊಟ್ಟು ನಂದು ಅಕ್ರಮ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ನನ್ನ ಖಾತೆ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿದ್ದಾರೆ. ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದು ಹಳೆ 2006 sketch, but latest sketch I produced today that it is conducted on 6/9/23. ಅದು ಅಗ್ರಿಕಲ್ಚರ್ ಅಂತಾನೆ ಇದ್ ಮಾಡಿದಾರೆ ಅವರು.
If I were to give a finding here that you have no right over the property, your case will come to an end. There's an appeal provided against this sort. Would you prefer an appeal? There's an appeal provided under Rule 5 to the Chief Executive Officer of the Zilla Panchayat. ನೀವು ಸುಮ್ಮನೆ ಅಪೀಲ್ ಹಾಕೊಳ್ಳೋದು ವಾಸಿ.
ಅಲ್ಲ ಅಲ್ಲಿವರೆಗೆ ಕಟ್ತಾರೆ, ಅಲ್ಲ ಅಲ್ಲಿವರೆಗೆ ಬಿಲ್ಡಿಂಗ್ ಕಟ್ತಾರೆ.
ಇಲ್ಲ ಖಾತಾ ಇಲ್ಲ ನೀವು ಫಸ್ಟ್ ತಕ್ಷಣ ಅಪೀಲ್ ಹಾಕೊಡಿ. There is no record in your favor. You do not state as to how you acquired the property. The assessment list extracts that you rely upon are not clear. They appear to be doubtful. So if I were to say that the order is correct,
No, they
then
themselves have given a sketch also to
you
me.
want, I will examine it, but if I take a view, then matter will come to an end. You please prefer an appeal. It is noticed that the order impugned is an order passed as provided under the Karnataka Panchayat Raj bracket, removal of obstructions and encroachments, close the bracket rules, 2011.
So
Rule
till
5
then,
of the
possession-
said rules provides for an appeal to the chief executive officer of the respective Zilla Panchayat within 30 days. In the light of the above, in my view, it not be appropriate to entertain this petition. And the petitioner will have to relegate it to the appellate committee.
Till then, the
Provided
possession may be
under the-
stayed here, his possession.
My
may be
lord,
stayed.
we have taken a possession and constructions are going
Hello,
on. They are in
construction is only on
they are
portion
not
of-
in possession.
You have an
It is 16
intermodal here.
Huh?
No, my
What
lord.
is what?
No, my lord.
Till then I can file ಮಾಡಿದಾಗ they are going on with construction day in and day out. That's
The
all.
petitioner is permitted to prefer an appeal within a period of 3 weeks from today and seek for appropriate interim orders. An application is made for grant of an interim order. The same should be considered expeditiously by the appellate authority and approved orders be passed.
Bill number 41.
Petitioner in this case, my lord. Or the petitioner here is challenging the annexure L and N, my lord. L is order passed by the Taluk Panchayat CEO, and the annexure L at page number 40, my lord.
What is annexure L?
My lord.
What is annexure L?
Annexure L is order passed by the CEO of Taluk Panchayat, whereas the annexure N is the order endorsement issued by the Jilla Panchayat, my lord, CEO of Jilla Panchayat. My lord, here is the brief facts of the case, my lord. The petitioner
You're already before the civil court, isn't it?
Yes, my lord.
Then-
That is pending, my lord. And then what has happened, my lord? The respondent number 3 and 4 have obtained the Khata in respect of the petition schedule property, whereas the petitioner during his lifetime of his father, he was in possession and enjoyment of the total extent 18 to 24 guntas of land. Then he has restricted to only the house which he has put up during 1985, and your Rashma kindly see at annexure E also.
ನಿಮ್ ತಂದೆ ಹೆಸರು ಖಾತಾ ಇತ್ತಾ?
ಖಾತೆ ಇಲ್ಲ. They are filed the suit for declaration and for injunction,
ನಿಮ್ ತಂದೆ ಹೆಸರು
claiming a dose possession, my lord.
ನಿಮ್ ತಂದೆ ಹೆಸರು ಖಾತಾ ಇದ್ದು ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿದ್ರೆ that is one thing. Your ಖಾತಾ was never in the name of your father.
No, my lord, but in the RTC was stood in his name, my lord, earlier.
What stood?
RTC.
RTC ಗೂ ಖಾತಾ
That is depend, my lord, but
I will say that
my lord, by virtue of by getting the Khata, my lord, they are sending the persons to the suit schedule, petition schedule property, and they may sell the property at any time, my lord. And
ಇದೆಯಲ್ಲ ದಾವಾಲ್ ಕೇಳಿ ಎಂಟ್ರಿ ಮಾಡೋರು ನಾನಂದ್ರೆ ಯಾಕೆ ಕೇಳ್ತೀರಾ?
I have challenged the order passed by both the Taluk Panchayat as well as the Jilla Panchayat, my lord. And
Appeal
at least
by
in
the
some protection may be granted.
That is in OS 107/19.
But my lord, what has happened, you will also kindly appreciate,
By
whereas
dismissal
one
of-
submission, my lord. Whereas very recently, when 2 days back, I filed another writ petition, whereas by your, in view of the Khata, based on the Khata, they have given the complaint to the Chescom. And Chescom has, without giving any notice, and they disconnected.
ಅದ್ರಲ್ಲಿ ಕನ್ಸಿಡರ್ ಮಾಡ್ತೀನಿ. ಇದ್ರ ನೀವು ದಾವಾಲ್ ಡಿಸೈಡ್ ಮಾಡ್ಕೊಳ್ಳಿ.
In the meanwhile, my lord, till the disposal of the suit, my lord, any protection may be.
ಕೊಟ್ಟಿದ್ದು ನಾನು ಇಲ್ಲಿ ಕೊಡ್ಲಾ?
All entry is with regard to the restoration of the electricity.
No, when that petition comes, I'll consider it. I can't grant you an interim order here.
At least my humble submission is that till the disposal of the suit, my lord, OS number 107/2019, my lord, some protection may be granted.
The petitioner preferred an appeal against registration of Khata in favor of respondents 2 and 3 before the appellate authority. The appellate authority has refused to entertain the appeal on the ground that the petitioner was already before the civil court in OS 107/2019. And therefore, he could not entertain the claim of the petitioner. In my view, the reasoning of the executive officer in refusing to entertain the appeal of the petitioner cannot be found fault with. Appeal is therefore dismissed. It is needless to state that in the event the petitioner obtains a declaratory decree in OS 107/2019, obviously the authorities would be bound by the decree and will have to make the entries accordingly.
My lord, one request, my lord.
If you have not got an interim order in the trial court, can I grant you an interim order here?
What, my lord, kindly direct.
ಇಲ್ಲ ನಿಮ್ಗೆ 2019 ಇಂದ ತಾವೇ
ಹೌದು.
ಮತ್ತೆ ನಾನು ಇವಾಗ ಫಸ್ಟ್ ಟೈಮ್ ಕೊಡ್ಲಾ?
At least, my lord, the petitioner had liberty to
ಏನು?
file a necessary application that may be considered by
I
the.
already said subsequent result.
That is there, my lord.
If the petitioner needs any interim protection, it is open for him to seek for the same in the pending OS 107/2019.
Much.
Number 42, Shri Shom Shekhara K.
I appear for the proposed respondents in this case, my lords. On 7/2/2025, we have moved a fresh no confidence against the Adhyaksha.
We give another one requisition, Lordship, on 7/2 it's.
ಮೀಟಿಂಗ್ ಕನ್ವೀನ್ ಮಾಡಿದಾರಾ?
Meeting.
ಮೀಟಿಂಗ್ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದು that to be challenged before the Zonal report.
ಮಾಡಿ. ಮಾಡಿದಾರಾ ಮಾಡಿಲ್ವಾ?
ಮಾಡ್ಬೇಕು.
ಮಾಡಿ.
ನೋಟಿಸ್ ಆ ತರ ನೋಟಿಸ್ ಕೊಟ್ಟಿದೆ.
28
28 ಕೊಟ್ಟಿದ್ದಾರೆ.
2 is the meeting notice, meeting date is.
ಅದ್ರಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ? Dishonorable directed to hold a meeting ಅಂತ ಹೇಳಿದ್ದಾರೆ. Dishonorable not directed them to
ಎಲ್ಲಿದ್ದಾರೆ?
ನೋಟಿಸ್ ಇದೆ ಲಾರ್ಡ್ಶಿಪ್ಗಳಲ್ಲಿ ಸದಸ್ಯರು ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಪ್ರಕರಣ ಸಂಖ್ಯೆ ಸೋಮವಾರ ದಿನಾಂಕ ಸೋಮವಾರ ವಿಚಾರಣೆ ಎಂದು ನೀಡಿರುವ ನಿರ್ದೇಶನದಂತೆ ನಿರ್ದೇಶನ ಏನಿಲ್ಲ. ಅಂಡ್ ಮೋರೋವರ್ ಸೇಮ್ ಡೇ ಇವನ
ಆಗು ಅಂತ ಬರೆದಿದಾರಲ್ಲ.
ಅಲ್ಲ 7/2 ಕೇಸ್ ಇದ್ದಿದ್ದು 7/2 ನೋಟಿಸ್ ತಗೊಂಡು ಕೊಟ್ಟಿದ್ದಾರೆ. 15 ನೋಟಿಸ್ ಇಲ್ಲ. ಐ ವಿಲ್ ಹ್ಯಾವ್ ಟು ಚಾಲೆಂಜ್ ದಿಸ್ ನೋಟಿಸ್.
ರಿಯಲಿಸ್ಟ್.
ಖಂಡಿತ. I will have to file another writ petition challenging this notice.
3rd March.
Because once again they made a mistake.
Once again they moved a motion of no confidence against. What can you do?
Correct, sir. But they must issue notice to me. 15 days notice must be given. That has not been given.
Now you have a copy of the notice.
Yes, man. Directly they have fixed a meeting, notice meeting. ಈ ತರದ್ದು ಇವರು
ನಂಗೂ ಕೊಟ್ರು ಅವರು, ಮೇಡಮ್ ಕೊಟ್ರು.
ಅದ್ರಲ್ಲಿ ಇದೆ ನೋಡಿ. ಡೈರೆಕ್ಟ್ 28ಗೆ ಫಿಕ್ಸ್ ಮಾಡಿದ್ದಾರೆ. ನನಗೆ ನೋಟಿಸ್ ಕೊಟ್ಟಿಲ್ಲ. 15 ನೋಟಿಸ್ ಮಸ್ಟ್ ಬಿ ಗಿವನ್.
That is.
ಇಲ್ಲ ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಕೊಟ್ಟಿಲ್ವಂತೆ ನೋಡಿ.
ಅಲ್ಲ ದಟ್ಸ್ ಮ್ಯಾಂಡೇಟರಿ ರಿಕ್ವೈರ್ಮೆಂಟ್. 3+2. ಆಮೇಲೆ 7 days ನೋಡಿ ಇರ್ಬೇಕು ಅವ್ರಿಗೆ ಟು ಥಿಂಕ್ ಓವರ್ ಇಟ್.
ಹೆಂಗಿದ್ರು AC ನಿಮ್ ಪರ ಇದಾರೆ.
AC ಇಲ್ಲ ಇದ್ದಿದ್ರೆ ನಮ್ಮ ಪರವಾಗಿ ಈ ಪರಿಸ್ಥಿತಿ ಬರ್ತಾ ಇರಲಿಲ್ಲ.
ಈ ತರ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಕೊಡ್ತಿರ್ಲಿಲ್ಲ ಅವ. ಫಸ್ಟ್ ಬೇಕಂತ 3 ದಿನದಲ್ಲಿ ಅವ್ನು ಮೀಟಿಂಗ್ ಕಂಡಕ್ಟ್ ಮಾಡ್ಲಿಲ್ಲ. ಈಗ ಈ ತರ ಸೆಕೆಂಡ್ ಮೋಷನ್ ಕೊಟ್ರ ಅದಕ್ಕೋಸ್ಕರ ನಾನು ಐ ಸೆಡ್ ಗಿವ್ ಅನದರ್ ಮೋಷನ್ ಲೆಟ್ ಅಸ್ ಸಿ ಅಂತ. ಇಟ್ ಇಸ್ ಆಬ್ವಿಯಸ್ ದಟ್ he wants you as the ಅಧ್ಯಕ್ಷ.
ಆ ಥರದ್ದು ಏನಿಲ್ಲ. ದಟ್ ಟು ಶಿ ಇಸ್ ವೆರಿ ಅಲ್ಲಿ ಏನಾಗಿದೆ ಬುದ್ಧಿವಂತರು ಯಾರು ಮಾಡಕ್ ಕೆಲಸ ಮಾಡಕ್ ಬಿಡಲ್ಲ. ಡಬಲ್ ಗ್ರಾಜುಯೇಟ್
ಅಷ್ಟೇ ಅಲ್ಲ,
ಆ ಕೆಲಸ ಬಿಟ್ಬಿಟ್ಟು ಬಂದು ಯಮುನಾ ಚೇರ್ಮನ್ ಆಗಿ ಡೈಲಿ ಇವ್ರು ಸುತ್ತೋಡೆದಾಗಿದೆ ಪಾಪ. ಶಿ ಇಸ್ MA B.Ed ಡಬಲ್ ಗ್ರಾಜುಯೇಟ್. ಇಲ್ಲಿ ಬಂದು ಇವ್ರು ಸುತ್ತು ಹೊಡ್ಕೊಂಡಿದ್ದಾರೆ ಪಾಪ.
It is noticed that despite the order dated 29/1/2025, the office objections are not complied with. Kept in order, the petition is dismissed, not prosecution.
Serial number 44, Shri Harish Shenna. Harish Shenna.
State of hearing, respondent advocate may undertake to file memo. Say, matter pertaining to formation of road. property tax pay matter.
I've sent it for signature. In some time I will get it. Kindly pass or have it on Monday also. If file.
ಏನಂತ ಮಾಡಿದ್ರೆ ಈಗ?
In the memo, we have written, my lord,
Budget year ಅಲ್ಲಿ ಅವ್ರು-
that we have taken that road formation work in the program of works of this year. So subject to the budget for 25-26, the road can be formed, relist.
Short date,
21st.
Monday.
Bill number 45. Wish to file the affidavit?
I appear on behalf of the respondent number 4. On the last date of hearing, your lordship directed me to place on the page number 11 may be seen, Manoj. Page number 11, annexure R3 minutes. The contention of the petitioner is that the representation given by the petitioner was not considered. It is the very same representation that is produced at annexure H in the petition. At page number 13, a reply was given to the petitioner stating that there is no work undertaken by the corporation to the effect of putting up the stormwater drain, Manoj. And one more contention of the petitioner is that there is a person who's not a party to this writ petition. They say that to benefit that person, there is a deviation of the Rajkalve.
Record the statement
We've
that
also,
they've already informed you that they don't intend to put up any drain.
Lords, but they started the construction, my lords. The stormwater drain, they have been already constructed. And on the original stormwater drain, there is one building by name AS Palace that is blocking the drain. So to deviate that, they're bringing construction before the petitioner's property.
I can't say that this is wrong.
Manoj, to that effect, page number 9 may be seen. Against that person, AS Palace, we've issued notice to remove the encroachment on the stormwater Rajkalve.
Lords, but this is done on 31st of January, my lords.
You have succeeded, isn't it?
I'll seek instructions, my lords, because a corporation commissioner was present on 31st of December, and he was also like inspecting the area where the petitioner's property is there. When they are not putting up any construction, why is he there?
Direct him to implement the notice that he has given in accordance with law. So that should take care of your grievance.
Lords, I'll seek instructions, my lord. Seniors also not there.
I'll pass an order. They have committed themselves now by virtue of annexure R1. I'll direct them to take this to its logical conclusion.
But I received it today, my lords. I need some time.
Realist.
In fact, Manoj, there is a deviation even by the petitioner.
Petitioners take on record. You're exposing yourself. ಗೌರವಾಗ ನಾನು ಸುಮ್ಮನೆ ಆರ್ಡರ್ ಮಾಡಿ ಆಗ್ತಿತ್ತು ನೀವಾಗ ನೀವು ಅವರು ಇನ್ನೊಂದು ಹೊಸದಾಗಿ ತೆಗಿತಾರೆ ನಿಮ್ದು ಏನೋ ಡಿವಿಯೇಷನ್ ಇದೆ ಅಂತ. ವೈ ಡು ಯು ವಾಂಟ್ ಟು ಅಟ್ರಾಕ್ಟ್ ಅಟೆನ್ಷನ್ ಟು ಯುವರ್ ಸೆಲ್ಫ್? ಯು ಹ್ಯಾವ್ ಸಕ್ಸೀಡೆಡ್.
Number 46.
That's date. First week of March, my lord. Seniors.
The matter is reserved, ground rent matter, my lord.
Ground rent matter.
WP 23086.
Both matters are ground rent matters.
Ground rent.
Number 47.
Oblation.
47, my lord. Covers, my lord.
Appear for the respondent number 31.
Annexure H, my lord.
Now, there's an amendment which is made, my lord, to Municipalities Act. Unlike Municipal Corporation Act, my lord, there was no provision to issue B khatas per se, my lord. Now, by virtue of this amendment, what they've introduced, my lord, to Municipalities Act section 106, 1B, may kindly read, my lord.
Requested to issue E khata, not B khata, my lord.
What is annexure E?
My lord, endorsement issued by us saying that we
Endorsement, my
can't
lord.
issue E khata to the petitioner, my lord. This layout in which the site is formed is without any sanction, my lord. 106, my lord, 1B, the second page, page number 2. Illi this one. The 1A, that is subclause 123 says that without a sanction plan from a competent authority, no e-khata can be issued. However, they've carved out an exception here. May I read, my lord? The municipalities may levy and collect the property tax from every building and vacant land or both, including a building constructed in violation of the provision of the building bylaws or in any unauthorized layout or in any revenue land or from a building occupied without issuance of occupancy certificate or completion certificate, only for the property created prior to the date of inception of this provision, except for the building constructed illegally in the government land, land belonging to any local body, statutory body or organization owned and controlled by the government. The property tax levied for such building or vacant site shall be double the tax payable for the first year, and only for the only the property tax shall be levied for the subsequent years, which shall be maintained in a separate register. So with this, my lord, see these illegal layouts, my lord, the sites of petitioner can be registered under this one. They'll not receive.
Prospective effect, my lord. That's my.
No, no.
Prospective effect is first ಮಾಡ್ಲೇಬಾರದು ಅಂತ.
My lord,
The provisos 1B says, before this act came into force, if there's any unauthorized building, they will enter your name
In a
in
separate
a separate register.
my lord, B Khata, my lord, for the purpose of registration transfer, now the E Khata is required, my lord. B Khata, by holding B Khata, we cannot sell the property, my lord. My submission,
The provision ಇದ್ದಾಗ ಏನ್ ಮಾಡ್ಬೇಕು ನಾವು?
my lord, that is the reference, the only the prospective nature, my lord.
Yes,
This honorable court, lordship kindly see annexure H, my lord.
My lord, this-
Earlier, my lord,
Was this act considered in the judgment?
plus judgment, my lord,
This act from September 2024 says,
that law was not there at the time of the judgment passed by this.
therefore that judgment is not a precedent now.
No, my lord, that law was not there, my lord, at the time of the judgment. My submission is, my lord, my vendor got the Khata, my lord, earlier in the 2016, my lord. They are relying upon the circulars issued thereafterwards, my lord. Hence, this honorable court held that, my lord, the circulars, they are relying upon.
He has a point. If there was a Khata existing,
Yes,
and if there is a transfer, the regular provision will apply. This talks about a new property ID.
No, my lord.
Yes.
My
Read
lord,
1A, 1A. It
No,
talks about a new Khata, isn't it?
notwithstanding anything contained in this act, prior approval of for the layout plan by the jurisdictional planning authority shall be obtained by the commissioner or chief officer or municipality or any officer authorized by commissioner, chief officer to issue new PID or Khata. That is for 1A, 1B, that 1, 2, 3, my lord.
Correct.
This is so far as the existing sites, my lord, which there is no sanction plan.
This 1B refers to a new PID that you give. So suppose for the existing building, you're not issuing a new
My lord,
PID.
my
The
lord.
PID is already there.
Earlier, my lord, they used to have assessment number or Janjar number, my lord. PID is,
That is
yes,
either
yes,
Khata
yes,
number or PID
yes,
number. So
yes,
if there's an existing Khata number, then it's a transfer
yes.
on the basis of a sale deed.
yes, my lord.
Only if they're seeking for a new Khata, then this proviso will come into operation.
But
One will come into
in
operation.
fact, my lord, they are prohibited even asking for a new Khata because if the layout is
They are
formed,
not asking for new Khata. The Khata was existing in the name of their vendor.
my lord, I will examine this, my lord.
It's already words the one, this honorable court, lordship kindly see annexure H, my lord.
ನಿಮಿಷ ಇದು ಅವ್ರು ಇದನ್ನ ತಂದಾಗ ಇದನ್ನ ಮೀಟ್ ಮಾಡ್ಬೇಕು ತಾನೆ ನೀವು?
ಇಲ್ಲ, ಇದರಲ್ಲಿ, my lord, only I'll examine this particular point, my lord. Because here what they say is constructed in violation of the provision of building laws or in any unauthorized layout or in a revenue land or building occupied without issuance of
This,
OC.
essentially for a new Khata number. This can't be, please also consider this.
Yes, my lord.
Before you came into the picture,
Yes, my lord.
the Gram Panchayat or somebody else or CMC or whatever,
Yes, my
they
lord.
had registered the Khata in his favor. Whatever they had done, you cannot undo it.
If it is merged and it's become part of a bigger, my lord,
You
then.
cannot sit in judgment now and say that you had wrongly registered the Khata, therefore
But that would also, my lord, violate so far as the other provision because in new.
all this will come in if 108, right? 106.
106, my lord.
Relates to a new Khata. 106 1B should also relate to the new Khata.
Okay, yeah, I understand.
Can't
I
be
will
for-
examine this point, my lord. May kindly be taken up next week.
Relist.
Date. 21st. Till number 48, Nandesh Gowdaji.
Lord, last occasion affidavit has been filed by the third respondent stating that, my lord, he has removed the, stating that he has removed the compound wall. My lord, entire projection, my lord, the Projection is to the extent of 3 feet at the first instance. The 3 feet is existence in the first floor as well as the second floor also. But while putting up of the wall, my lord, they have extended the projections towards my property to the extent of 5 feet. If he is removed, he ought to have removed that excess 2 feet, my lord. Except he has removed the wall, my lord. That projection has not been removed.
I will verify. Because if he.
ಅವರೇ ಫೋಟೋಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಲ್ಲಿ ನೋಡಿ ವಾಲ್ ತೆಗೆದಿದ್ದಾರೆ ಪ್ರೊಜೆಕ್ಷನ್ಸ್ ಏನಿದೆ ಆ ಪ್ರೊಜೆಕ್ಷನ್ಸ್ 2 ಅಡಿ ಅದನ್ನ ತೆಗೆದ್ರೆ ಆಯ್ತು ಇನ್ನೇನು ಬೇಡ ಟುವರ್ಡ್ಸ್ ಮೈ ಪ್ರಾಪರ್ಟಿ.
As per my instruction is that my lord, he has removed it.
ವಾಲ್ ಏನ್ ಸಜ್ಜೆ ಮೇಲಿದೆ ಅದನ್ನ ತೆಗೆದಿದ್ದಾರೆ ಆ 2 ಅಡಿ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಇದೆ ನೋಡಿ ಅದೊಂದು ತೆಗೆದ್ರೆ ಆಯ್ತು.
ಸಜ್ಜೆ ಹಳೇದ ಹೊಸದು?
ಹಳೇದು.
It is an old building.
Old building.
3 feet is the old. 2 feet extension.
Extension ನಾನು ತೆಗೆದಿದ್ದೀನಿ. Now extended whatever now renewed.
Construction and
I have
additional
been removed.
constructions has been made without there
ಇದು
being.
earlier ಆಗಿರೋದು building, ಹಳೆ building. We did not my lord.
If what he says is correct, 3 ಅಡಿ ಇರೋದು 5 ಅಡಿ ಮಾಡಿದ್ರೆ.
ಅಲ್ಲ ಈಗ ಮಾಡಿಲ್ಲ, ಆಲ್ರೆಡಿ ಇತ್ತು, ಅದ್ರ ಮೇಲೆ ಜಸ್ಟ್ ಪ್ರೊಜೆಕ್ಷನ್ ಮಾಡಿದ್ದೆ ಅಷ್ಟೇ. ಆ ಪ್ರೊಜೆಕ್ಟೆಡ್ ಏರಿಯಾ ಹಸ್ ಬಿನ್ ರಿಮೂವ್ಡ್.
I saying it was 3 feet, now you extend by 2 feet.
ಇಲ್ಲ ಈಗ ಮಾಡಿಲ್ಲ.
ಇಲ್ಲ.
Now it has not been made.
ಇಲ್ಲಿ ಫೋಟೋಸ್ ಕೊಡ್ತೀನಿ ನೋಡಿ.
But anyhow, my lord, if that is the case, my lord, I will take instruction from my
First
client.
floor 3 feet ಇದೆ, second floor. The same is extended towards 5 feet in the first floor.
Sir, you are sought only a first floor, now you are making second.
ಇಲ್ಲ ನಾನು second floor ಏನು ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲ, first floor ಅಷ್ಟೇ.
Unnecessary ನಮ್ಮ ಪಾರ್ಟಿಗೂ ತೊಂದರೆ.
ಅಲ್ಲಿ ನೋಡಿ ಅವ್ರು ವಾಲ್ ಕಟ್ಟಿದ್ದಾರೆ, ಸೆಕೆಂಡ್ ಫ್ಲೋರ್ ಸಜ್ಜೆ ನೋಡಿ 3 feet. 2 feet ಎಕ್ಸ್ಟೆನ್ಷನ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಮುಂದೆ.
ಈ ಕೆಳಗಡೆ ಇರೋದು ದೊಡ್ಡದಿದೆ ಅಲ್ವಾ? ಹಳೇದೇ?
ಹಳೇದು.
ಕೆಳಗಡೆ ಹಳೇದೇ ಅಲ್ವಾ?
ಹಳೇದು.
ಇಲ್ಲ, ಕೆಳಗಡೆದು 2 feet ಪ್ರೊಜೆಕ್ಷನ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ ನನ್ನ ಕಡೆ.
ಮುಂಚಿಂದಾನೇ ಇದೆಯಲ್ವಾ?
ಪ್ರೊಜೆಕ್ಷನ್ಸ್ ಕೊಟ್ಟು ವಾಲ್ ಪುಟ್ ಅಪ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ವಾಲ್ ತೆಗೆದಾಕಿದ್ರು, ಬಟ್ ಇದು ಈ ಕೆಳಗಡೆ ನೋಡ್ರಿ ಹಳೇದೇ ಅಲ್ವಾ?
ಹಳೇದೇ.
ಹೊಸ ಸಜ್ಜಾಲಯ ಇರೋ 3 ಅಡಿ 5 ಅಡಿ ಆಗಿಲ್ಲ, ಮುಂಚಿಂದ 5 ಅಡಿನೇ ಇದೆ.
Let him undertake, my lord, not to put up any.
ಅಲ್ಲ ನಾನು ಅದನ್ನ ರಿಮೂವ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀನಿ.
Yes, let him undertake, my lord, not to put up any construction or putting the, my lord, the fabrication over the that sajja 2 feet, my lord. ಇವಾಗ ಅದನ್ನ ತೆಗಿತಾರೆ ಮತ್ತೆ ಫ್ಯಾಬ್ರಿಕೇಶನ್ ಹಾಕೊಂತಾರೆ ಅಷ್ಟೇ.
Sajja has been there from the beginning for 5 feet.
3 feet is there, my lord. 3 feet first floor 3 feet.
Show me proof that it was 3 feet. Your photograph is against you.
ಇವಾಗ ಅದೇ ವಾಲು ಅವ್ರು ತೆಗ್ದಿರೋದವ್ರು.
ವಾಲ್ ತೆಗ್ದಿದ್ದಾರೆ, ಸಜ್ಜೆ 3 ಅಡಿ ಇತ್ತು, ಇವಾಗ ಎಕ್ಸ್ಟೆಂಡ್ ತೋರಿಸಿ ask him to remove the 2 feet extra.
My lord, if he is removed that wall, my lord, let him undertake not to put up any construction over that.
ನಾನು ಅದನ್ನೇ ಹಾಕ್ಬಿಟ್ಟಿದ್ದೀನಿ, ಅಫಿಡವಿಟ್ ನೊಳಗೆ ಹೇಳ್ಬಿಟ್ಟಿದ್ದೀನಿ. I have already removed ಅಂತ. Removed a question further undertaken.
ಅದನ್ನ ತೆಗೆದು ನೀವು ಗ್ಲಾಸ್ ರಿಲಿಂಗ್ಸ್ ಹಾಕೋದು?
ಇಲ್ಲ ಏನು ಮಾಡಲ್ಲ ಅಂತಾನೆ ಅದನ್ನ ಮಾಡಕ್ ಹೋದೆ, ಇವಾಗ ತೆಗೆದಿದ್ದು. ನಾವು ಹಿ ಹ್ಯಾಸ್ ಅಬ್ಜೆಕ್ಟೆಡ್, ಅದಕ್ಕೋಸ್ಕರ ರಿಮೂವ್ ಮಾಡಿದೆ. ಅಲ್ಲ ಆಕ್ಚುಲಿ
ಅಂಡರ್ಟೇಕಿಂಗ್ ಕೊಟ್ಟಿಲ್ಲ, ಅದೊಂದು ಅಂಡರ್ಟೇಕಿಂಗ್ ಕೊಟ್ಬಿಡ್ಲಿ.
ಅಫಿಡವಿಟ್ ಹಾಕ್ಬಿಟ್ಟಿದ್ದೀನಿ ಸರ್.
ಹೇಳಿಲ್ಲ, ಸೊ ಶಲ್ ರೆಕಾರ್ಡ್. ಅಪ್ಲೋಡ್ ಹೇಳಿಲ್ಲ.
ಅಲ್ಲಿ ಫಸ್ಟ್ ಫ್ಲೋರ್ ನಾನು ಯಾವ್ದು ಮಾಡ್ತಾ ಇಲ್ಲ, ಅಲ್ಲೇನು ಮತ್ತೆ ಪ್ರೊಜೆಕ್ಷನ್.
ಅದ್ಮೇಲೆ ಏನು ನೀವು ಗ್ರಿಲ್ ಏನು ಹಾಕಲ್ಲ ಅಂತ ಹೇಳಿಲ್ಲ ಇದು?
ಇಲ್ಲ ಹಾಕಲ್ಲ.
ಶಲ್ ರೆಕಾರ್ಡ್ ಇದ್ರಲ್ಲಿ ಬರ್ದಿಲ್ಲ.
ನಾಳೆಗೆ ಹಾಕಿದ್ರಾಯ್ತು. ಐ ವಿಲ್ ಫೈಲ್, ಯಾಕಂದ್ರೆ ಅನ್ನೆಸೆಸರಿ ಐ ಹ್ಯಾವ್ ಟು ಸೋಮವಾರ
17.
I will file affidavit in the it's not.
Film 49.
Filing the statement of objection. I have served the copy.
For respond number. Start account. Respond number 3.
3.
He is filed.
Lord, I appear for the respondent number 4, my lord. This writ petition, my lord, is not maintainable because the petitioner has not claiming any right over the property. He is claiming that it or what?
I'm ready.
Please.
TVRಗೆ
Respond number 3, madam.
Panchayat.
The prayer.
My lord, sorry.
That's the construction.
For the respondent not to put up any further construction.
Please,
Wash annexure G.
please.
What is annexure G?
License. It's a license which has been issued.
They can't grant him a license?
No, they can grant him a license. It is not the problem. Right now, he has also filed his objections. The point here is, my lords, the land which is in question is a government land which is named as Devrinamti Palu in the Kaneshumari, the 66. And he has got this land and he says he has obtained a sale deed and subsequently based on the sale deed, he has got his construction license. Then he has constructed, he is trying to put up construction. But as per his own sale deed, which is he produced today, in his own sale deed, it says Kanesh Shumari Hannondu number, anta he says. So it is Kanesh Shumari number 11, not 66. 66 is remaining as Devrinamti Palu. I do not have any objection to pertaining to 11. Let him take 11, but not 66. 66 belongs to the government land because it is the Devrinamti Palu.
Where are you putting up the construction?
He's putting up at 66.
My lord, the Munihanamappa has purchased 2 bits of land from 1953 and 1978. There are 2 sale deeds. It was a earlier Kaneshmari number, house list number 11. Man. The later from 1987, the Munihanamappa, the Khata has been standing in the name of Munihanamappa, saying that 66/86. My lord, 2006, after death of Munihanamappa, all the legal heirs of Munihanamappa has sold the scheduled property within the boundary. That boundary is also tallying. My lord, I have.
No. His case is that number 66, you're trying to put up a construction.
It is a Gramthana, my lord. It is not a survey number.
He's saying it is on number 66.
No.
Survey number. It is not a survey number. Khata number, Ginger number.
Junjur number. Junjur number 6.
According to you, it belongs to whom?
Government.
Government land.
Because now it exists that 66.
Indeed, I have produced the copy as annexure.
There is
A.
no such thing.
In annexure A, I have produced the copies, my lord.
ಯಾವ ವರ್ಷದ್ದು?
Typed copy of 2020, typed copy at 22 page number.
ಯಾವ ವರ್ಷದ್ದು ಅಂತಾನೂ ಹೇಳಲ್ಲ ಅದು.
1970 ಸ್ವಾಮಿ.
ಇಲ್ಲ ಲೇಟೆಸ್ಟ್ ತೋರಿಸಿ.
I have got the EC also.
ಇಲ್ಲ ಇದು ಯಾವ ವರ್ಷದ್ದು ಇದು ಕಾನೇಶ್ವರ ನಂಬರ್?
1970 ಸ್ವಾಮಿ, 1970.
Where do you get it?
Kanesh Shumari has not been changed since then. In that, it says Junjun number 66.
This is a typed copy, page 22.
Page 22 is the typed copy.
This you are not sure as to which year it belongs to.
No, it is there in the last page. It says signed and it is written as 1972.
Now thereafter, are there any further records?
No records. No, I've also got the EC also in the Panchayat also.
If the records are there.
Please.
Of this
Particular number, yes.
Janjuru number 66 being changed and Devra, when was, once it is there, it can't be removed, correct?
Indeed.
If it is removed or if it's given some other number, how do we verify that?
That is what my lords that.
You're relying upon almost a 60-year-old document.
My lords, right now what has happened, it has been 66. Subsequently, in his own sale deed.
You are saying it is 66 on the basis of a 60-year-old document.
Please.
Every 5 years, their numbers will change.
My lords, Kanesh Shumari does not change.
Whenever they revise the assessment.
Please, my lords.
43 page number, my lord, I
My
have.
lords, that has been changed and it has been made 66/86.
When?
Assessment was done.
When?
That I will secure those records, my lords.
My lord, it
The
is-
same fact of issue.
You should establish that.
Indeed, I will. my
Lord,
lords.
he has no claim over this. And please, my lord, he is obstructing the construction.
Suppose he is right and you're putting up a construction on the temple property.
It can't be, my lord, because
I don't know.
53,
ನೀವು ಒಪ್ಕೊಳ್ಳಲ್ಲ ಅವ್ರೇನ್ ಹೇಳ್ತಾರೆ ನೋಡೋಣ.
they have made the Khata, 1940.
Saying Khata is instead number 11.
My lords,
No, it is earlier, it was 11 in year 1950.
When you purchased it,
It is 66/86.
building license is granted to what?
66/86.
66/86 is where?
My lord, in 2006, 2007, the Khata was standing in the name of
Failure objections.
Munihanamappa.
Realist.
Please. When date?
First.
Not. First. Yes.
Number 50 is Zamir Pasha. Short adjournment, senior counsel is not available. Kindly have it on Wednesday.
Lord, one submission, madam. Because last time Lordship has directed to ascertain whether any smell regarding that. And without my knowledge, my lord, some of the residents have present because stating that to make some. And PD was also present today.
But the pollution control board has said There's no smell.
No, that's the reason, my lord. That's the only that sentence. That is the reason, because earlier to approaching the writ petition code, they have also approached the pollution control board, and pollution control specifically interested biofilter for further reduction of smell and hakidare.
Was suggested by him.
Huh.
It was volunteered by him.
Yes.
The pollution control board does not state that the business it is carrying on is emanating a foul smell.
No, that is the reason, my lord.
Show me from the report saying that the pollution control board found that there's a foul smell emanating.
Authority has proposed for installation of biofilter for further reduction of the
Correct.
smell.
That's why I also was under the confusion. Look at the above portion. The, in response to the notice in page number 5.
In response to the notice, the industry was inspected on 26/9/24. Based on the observation made during the inspection, odd smell and poor housekeeping, this issue notice to the industry on authority dated 14/10/24. In response to the notice, the industry authority has submitted the reply by letter dated 21/10/24, stating that properly maintain the good housekeeping, and also the industry authority has proposed for installation of biofilter for further reduction of the smell.
Because this is a voluntary act. Show me from this report.
Hello, my lord.
No, show me from this report.
There is no, I have read that notice, but apart from that, my lord.
Can I override the pollution control board?
ನಾನ್ ಹೇಳೋದು, apart from this regulation or any report from that, real fact is this. Real fact is this, that my lord, they are not in a position to night, my lord, heavy because of this fish, this one, no, the smell is very bad.
That's why I said you make an inspection after the evening to see whether that smell was.
Yeah,
there or
yeah,
not.
well, they have noticed that, my lord, they will not run the industry. That is the problem.
My lordship, I've asked whether inspection was done in the morning or evening. As per the photographs, the geotag photo, it was done around 6 o'clock in the evening, 5:47. That is the timing when the inspection was conducted, my lordship.
Now, can they make a surprise inspection and find out whether there's any foul smell emanating? Anyway, he wants time till Wednesday.
Because
So they won't do anything till Wednesday.
as per my instruction, when they visited the spot, it was okay and no smell was there. But I will just ask them.
That the residents also present people, but normally I have not instructed, my lord. That is,
Can I go by the residents or can I go by the pollution control?
no, I leave it, I leave it to the court, but I have made a submission with real facts before this court. There are some rules.
The pollution control board is saying a false.
No, not like that, my lord. Not like that.
I voluntarily implemented them into.
Yes, I know it.
They have said. it's
But
no
real
smell.
fact is this, my lord. That is the reason. Night time, my lord, they are running and.
Realist. Ask them to verify.
You are surprised. They asked for Wednesday, my lordship.
Realist.
28th. 28th. Number 51, Shri D. Ramesh.
Also sought for a direction to implement the, my lords, report submitted by the surveyor. My lords, there is an encroachment by the respondent Gram Panchayat.
ಯಾರ್ ಮಾಡ್ಬೇಕು?
My lords, report ಕೊಟ್ಟಿದ್ದಾರೆ. It has to be implemented by the Tahsildar. My lord, there is a letter written by the CEO and the Tahsildar to remove the encroachment. Even then, my lords, they are proceeding with the construction, my lords.
ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡಿದಾರ?
ಹೌದು.
ಯಾರವರು?
My lord, Chief Executive Officer, third respondent, my lord.
No, who is the person putting up construction?
My lord, fifth respondent, my lord.
Gram Panchayat.
Gram Panchayat.
Where is Pradeep? List.
21st.
Much of.
Number 52.
For the petitioner, my lord.
Kindly pass on.
Asura shall have it some other day.
Lord, there is some urgency. Construction has been stalled. They filed their objections also. Lordship may give me 2 minutes and just.
Number 53.
My lords, Sanjay. Matter pertains to releasing of sites, my lords. 60% developed sites, covered by my lord's judgment and.
Where's Yogesh?
Last occasion also did not approve.
I'll pass it over, that's all I can do.
Number 54.
Preparing for the petitioner. After this writ of mandamus is filed, by the petitioner that the Khata transfer is not mutated, though the multiple representations were given to the respondent number 3, that is the ARO Chamrajpet. And also an appeal also was referred in Sakala, though they had declined it, saying that insufficient documents. Again, we give a representation with all the relevant documents.
Lords, may I only draw my lordships kind of our documents and kottidra nanu kotre I'll forward it.
I have placed it on record, my lords. All the documents are there in the annexure A. That
Only two
representation is
sale
also
deeds
there.
are there. I'll only take my lordships 2 minutes. My lords. Only 2 sale deeds are there. My lords, if I may draw my lordships kind attention to the schedules of the two sale deeds, my lords. One is at ink page number 70, my lords.
ನಿಮ್ಗೆ ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್ ಬೇಕು ಹೇಳಿ ಅವ್ರು ಕೊಡ್ತಾರ.
My lords, the previous document is what we are asking ಅಷ್ಟೇ, my lords. ಇವಾಗ ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಸೇಲ್ ಡೀಡ್ ಅದಕ್ಕೆ ಹಿಂದಿನ ದಾಖಲಾತಿ ಬೇಕು ಅಷ್ಟೇ, my lords.
The partition, the relevant documents are also given. I'll give it, my lords. My lords, time bound, maybe fixed.
Let him find out. Give
ನಾನು
whatever
ಕೊಟ್ರೆ-
he wants.
Okay, date may be fixed, my lords. Wednesday.
21st.
Great.
Much obliged, great.
Court fees ಕಟ್ಟಿಲ್ಲ ನೀವು. Court fees.
No, I've made it, I've paid the court fee. my lords.
Silver meeting officer should be complete with them.
I've complied the office. No interim prayer is sought. It's a.
Till number 55, Sri Nishant Devi.
For the petitioner, my lords may kindly pass over.
Your lordships are directed at to file a statement of objections.
Given him a copy.
The copies, lordships.
Have it some other day. We list.
Any short date, my lords?
21st. 56 and 57
Right,
disposed. Seal number 58. Sri Prabhasabha Gante.
Appearing for the petition in this matter. Lord, the matter is pertaining to I'm the bank. There's been an auction notice issued by the BBMP wherein there's a tax dues which has been paid by the respondent. Lord, in the earlier occurrence, they told that we'll inquire for a joint auction to be made.
No, we are ready for joint auction. No date is refixed. So if they approach the BBMP, then
But in any
date
case,
may be fixed for.
in
the
any case,
joint
under 31B surface, we have the prior right over the property, but still since it there also have the dues, we are okay with the joint auction.
Joint ಅಂದ್ರೆ ಯಾರು ಮಾಡ್ತಾರ?
We can do the joint auction, my lord. We can take care of it.
Jointly that can be done. my lord.
The LIC Housing Finance Corporation, which had granted a loan to respondents 3 to 5, is before this court challenging the auction proposed to be conducted. BBMP challenging the notice of sale being listed of the property which they had financed, contending that the property can't be sold since they have a subsisting mortgage on the said property. They claim that the property, the borrowers had defaulted in the repayment of the loan. And hence they are in, you got recovery certificate?
Which one?
You got recovery certificate?
Yes, my lord. Because, no, we don't have a recovery certificate.
We initiate proceedings
The
surface.
surface proceedings has been initiated.
And they've initiated proceedings under the Surface Act. Recovery with the dues to it.
The property is in our possession, my lord. We are taking possession.
It is also stated that possession of the property has also been taken over by LIC Housing Finance Corporation. The BBMP also contends that in the property in question, property tax has not been paid and therefore they are also entitled for sale of the property, for recovery of the property taxes due to them. In my view, since both LIC Housing Finance as well as BBMP are essentially government undertakings, might be appropriate to permit LIC Housing Finance Corporation to sell the property by way of a public auction as per the Surface Act, and out of the proceeds that they receive, the property taxes due to the BBMP shall be paid, and only the remaining amount shall be appropriated by the Housing Finance Corporation. The reputation is accordingly disposed of, permitting LIC Housing Finance to auction the property as per the Surface Act. As a consequence, Annexure A cannot be sustained in the same disproportion.
Let it be joint, my lordship. As per my instruction there, we are ready for joint auction. So including us.
ಜಾಯಿಂಟ್ ಅಂದ್ರೆ ಯಾರು ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ಕೊಳ್ಳೋದು ಬಿಡ್ಯಾರ, ನೀವ್ ಮಾಡ್ತೀರಾ ಅವ್ರು ಮಾಡ್ತೀರಾ, ನೀವ್ ಬೇಡ ಅಂದ್ರೆ ಅವ್ರು ಮಾಡಕ್ಕಾಗಲ್ಲ.
Any bid which is on the higher side will be accepted by both my lords.
Joint
Lord, as per 31B, we have the right over the property.
or else you take the concurrence before you accept the bid.
Yes, ma'am.
The Electricity Finance Corporation shall
Before issuing the sale
correct
note,
of the BBMP before they accept and finalize the bid.
And inform BBMP about the date of auction and all. that.
Concurrence.
concurrence will mention.
Amend the cost rate.
Number 59.
Objection number 3 and 4 may be overruled, your lordship. Small marks ಇದೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಹೇಳ್ತಾರೆ ಇದು ಪ್ಯಾರಾಸ್ affidavit ಅಲ್ಲಿ ಒಂದು ಪ್ಯಾರಾ ಬರಿಬೇಕು, that's all the objection. I am seeking writ of mandamus to the respondent my lord to consider my application in terms of the party registered partition deed ಖಾತೆ ಮಾಡ್ಕೊಡಿ ಅಂತ ಕೇಳಿದ್ದೀನಿ. One of my brother has
ಯಾರು ಕೇಳ್ತೀವಿ?
corporation ಗೆ
Pran Kumar accepts notice for respondent 1 and 2. ಇವರ ಪ್ರಕಾಶ್ ಅಂತ ಇದ್ದಾರೆ.
ಅದೇ ಅವ್ರಿಗೆ ಅವ್ರ ಅಬ್ಜೆಕ್ಷನ್ ರೈಸ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಬ್ರದರ್ ಅವರು ಈಸ್ ಆಲ್ಸೋ ಪಾರ್ಟಿ ಟು ದಿ ರಿಜಿಸ್ಟರ್ಡ್ ಪಾರ್ಟಿಷನ್ ಡೀಡ್
Issue notice.
executed in 2017.
Issue notice to R3. Petition is permitted to take out notice on R3 personally.
Yes. Emergent notice my lord.
Personally.
ಅದನ್ನು ಮಾಡ್ತೀನಿ.
And someone's correct ಮಾಡ್ಕೊಂಡು.
ಅದನ್ನು ಮಾಡ್ತೀನಿ. Emergent notice my lord. Objection number 3 and 4 may be overruled.
ನೀವು ಮಾಡ್ಕೊಂಡ್ ಬನ್ನಿ ಆಮೇಲೆ.
Number 60, Shri Vijay Kumar.
This letter, my lord, I am challenging the endorsement issued by VBMP. Conversion land I purchased in 2024. My lord, I filed an application for transfer of Khata. VBMP issued annexure Khata. Go on before they obtain necessary permission under the town planning. My lord, the circular issued in 2024. I have produced the circular. It says base 43 annexure E, may kindly look at my lord. Circular dated 3/10/24.
Notice for respondents.
This circular.
My lords, I
Already
appear
fees
for the BBMP in this matter, please, my lords.
Yes. Ready na?
Ready, Swami. Idralli, Annexure D may be kindly be looked into, please, my lords. The official memorandum issued by the Deputy Commissioner, conversion order ali, there's a specific condition stating that only after the approvals obtained by the BDA, the sale has to be made by the vendor of the petitioner herein, please, my lords. Annexure D, please, my lords. ಸೀರಿಯಲ್ ನಂಬರ್ 3 ಅಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ. ಈ ಜಮೀನಿನಲ್ಲಿ ಉದ್ದೇಶಿಸಿರುವ ಬಡಾವಣೆ ನಕ್ಷೆ ಹಾಗೂ ಪರವಾನಗಿ ಇತ್ಯಾದಿಗಳನ್ನು ಬಿಡಿಎ ಪ್ರಾಧಿಕಾರ, ನಗರ ಪಾಲಿಕೆ ಇತ್ಯಾದಿರವರಿಂದ ಅನುಮೋದಿಸಿಕೊಂಡು ಆ ನಂತರ ಅನುಮೋದನೆಗೊಂಡ ನಕ್ಷೆಗೆ ಅನುಗುಣವಾಗಿ ಕಟ್ಟಡವನ್ನು ಕಟ್ಟುವುದು. ಸದರಿ ಜಮೀನಿನಲ್ಲಿ ಲೇಔಟ್ ಪ್ಲಾನಿಗೆ ಅನುಮೋದನೆ ಪಡೆಯದೆ ಪರಬಾರೆ ಮಾಡಬಾರದು ಅಂತ ಇದೆ ಸ್ವಾಮಿ.
No, I am not forming any layout. I am purchased for a construction of education institution. I purchased. But is the conversion itself is for purpose of education institution construction. I purchased the land, this land. I filed an application for transfer of Khata. They issued a endorsement stating that go on before they obtained necessary permission.
Who was the person who obtained the conversion?
My lord, it is my vendor, my lord.
Vendor, my lords.
Your lordship may kindly see the that is
No, but what she points out is ಆ ನಂತರ ಅನುಮೋದನೆಗೊಂಡ ನಕ್ಷೆಗೆ ಅನುಗುಣವಾಗಿ ಕಟ್ಟಡವನ್ನು ಕಟ್ಟುವುದು. ಸದರಿ
ಅದು
ಜಮೀನು
ಕಟ್ಟಡ ಕಟ್ಟೋಕೆ I am not putting up, I am seeking for only for transfer of Khata which I purchased. Subsequent second procedure is Khata ಕೊಟ್ಮೇಲೆ ನಾನು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬೇಕು, then they have to issue necessary license or other things. ಖಾತಾನೇ ಕೊಡ್ತಾ ಇಲ್ಲ ನಾನು ಸೇಲ್ ಡೀಡ್ ಆದ್ಮೇಲೆ. That is own circular against. Your lordship may kindly look at circular.
Suppose he undertakes that he will not form any layout as per condition number 3.
Please,
They
my
are
lords.
Not here.
Then you can you consider
Then
transferring the
condition number 1 will be applied, please, my lords.
Yes.
There is another condition. ಈ ಭೂಮಿಯ ಯಾವ ಉದ್ದೇಶಕ್ಕಾಗಿ ಪರಿವರ್ತನೆ ಆಗಿದೆಯೋ ಆ ಉದ್ದೇಶಕ್ಕೆ ಉಪಯೋಗಿಸಿಕೊಳ್ಳಲು ಸಮಕ್ಷ ಪ್ರಾಧಿಕಾರದಿಂದ ಅಂದರೆ ಅಭಿವೃದ್ಧಿ ಮಂಡಳಿ ಸೋನ್ಸೋ ಇತ್ಯಾದಿ ಮಂಜೂರಾತಿಯನ್ನು ಪಡೆಯದ ಹೊರತು ಈ ಆದೇಶವು ಅನುಭವದಾರನಿಗೆ
You will undertake to abide by the terms and imposed under the order of conversion.
Yes.
ಮೈ ಲಾರ್ಡ್ಸ್ ಇಲ್ಲಿ ಪರಬಾರೇನೆ ಮಾಡಬಾರದು ಅಂತ ಇದೆ ಸ್ವಾಮಿ. ಇದೆ ಕ್ಲಾಸ್
ಲೇಔಟ್ ಫಾರ್ಮ್ ಮಾಡಿದಿರಾನೆ ಸೈಟ್ಸ್ ಪರಬಾರೆ ಮಾಡಬಾರದು ಅಂತ.
ಪ್ಲೀಸ್
Is not forming a layout, is undertaking. That is not form a layout. He intends to use this premise, this property for establishing education school. He will undertake.
Based on these clauses, we have issued the endorsement vide annexure A, please, my lords.
Your understanding of those clauses are not correct.
Yes, please, my lords.
He says that he will maintain the property as it stands. He will use it only for the purpose of an education institution after securing the necessary approvals as provided under the conditions.
Yes.
Yes, please, my lords. He has even made a representations to the BDA also, please, my lords, of fourth respondent. That is also pending consideration.
They will
If,
not,
if they have, please, my
they
lords.
will not consider his application until the Khata is changed in his name.
That representation is also under challenge, please, my lords, before this honorable. In the writ petition.
They, my lord, a circular is there, page 45, 1 minute, my lord, page 45.
ಅವರು BDA ಅದನ್ನು challenge ಮಾಡ್ತಿದ್ದಾರೆ.
BDA challenge ಮಾಡಿಲ್ಲ, we given a representation,
representation
consider my
consider ಮಾಡಿ ಅಂತ
representation,
ಹೇಳ್ತಾರೆ sir.
mandamus issued.
ನೀವು ಖಾತಾ ಕೊಡ್ತೀರಾ ಫಸ್ಟ್ ಖಾತಾ ಕೊಟ್ರೆ then I'll consider direct BDA
Yes,
to
my lord.
consider his application keeping in mind the conditions imposed in the order of conversion.
We have issued endorsement in accordance with law, my lords. Our approval ಕೊಟ್ರೆ ನಾವು ಖಾತಾ ಕೊಡ್ತೀವಿ ಸ್ವಾಮಿ. That is.
ನೀವು ಖಾತಾ ಮಾಡ್ಕೊಟ್ರೆ ಅವ್ರು ಅಪ್ರೂವಲ್ ಕೊಡ್ತಾರೆ.
ಒಬ್ಬರ ಮೇಲೆ ಒಬ್ಬರು blame.
ಅದೇ ಪ್ರಾಬ್ಲಮ್ ಆಗೋದು, ಅದಕ್ಕೆ ಹೇಳಿದ್ದು. Can you impose that condition while transferring the khata that the conditions here will remain and he has also undertaken to abide by the conditions. Yes. So you transfer the khata subject to that condition. Then if he violates the undertaking, then you can cancel the khata.
I'll seek instructions with regard to this, my lord, sir.
Apart from that, my lord, one
Date
clause
may
is
be
there.
fixed in the next week.
Latest circular issued.
ನೀವು ಆರಾಮ ಕೆಲಸ ಮಾಡ್ಕೊಂಡು ನೋಡ್ಕೊಳ್ಳಿ, ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋ ಅವ್ರ ಹತ್ರ ಗೆಲ್ಲಕ್ಕಾಗಲ್ಲ ನೀವು.
Yes. Date. ಕೊಡ್ತಾರೆ 21st. If I may make a submission, my lord. Serial number 3 in Dharwad bench, my lord. I request a week's time, my lord. Senior counsel Srivaths has had a medical emergency, been engaged. It's not able to appear, my lord.
My lord, serial number 77. Morning, my colleague made a mention and your lordships directed us to inform Mr. Abdullah. It may be taken up on Monday. I have informed Mr. Abdullah. 77 to file counter.
I adjourn the matter.
Serial number 7.
Objects, I'll take it up, that is all.
Taken up on Monday because I have to.
Monday ಗೊತ್ತಿಲ್ಲ, 21st.
Serial number 70, my lord. Agency there because that DJ matter, my lord, wherein I am suffering.
DJ. ಏನಾಗಲ್ಲ ಬಿಡಿ ಅಷ್ಟರಲ್ಲಿ.
ಅಲ್ಲ ಅಲ್ಲಿ business.
You will have to take license, isn't it? That case.
No, that with regard to that only, I'll file counter affidavit. Serial number.
Next Friday ಬರ್ತೋಡ್ರಿ ಏನಾಗಲ್ಲ ಅನ್ಕೊಂಡು.
Serial number 70, my lord. I am for the petitioner. Along the LR's application aspects of it corrected one. Next week, I will file. The other side is also there.
The respondent.
Respondent is.
My lord, serial number 81, my lords. Serial number 81.
81.
81. Engaging senior counsels in this matter, my lord. So it can be called anytime next week, my lord.
ಅವ್ರಿಗೆ ಹೇಳಿದ್ದೀರಾ?
I'll inform, my lord.
What matter was heard?
Please, ಅದು Mara shelters ಅಂತ near the platform road, my lord. Batch petitions are there. ಅದು
regarding
2 acres of government land which has been encroached and property has been built up.
So the respondent.
The respondent, the last date, Mr. Shyam Prasad appeared, senior counsel. And respondent. Yeah.
Who's
Sorry,
for the
please,
petitioner?
you have to be here, that's it. Confusion.
Inform them.
All right.
I'll inform.
ಅವ್ರು ಬಂದು ಅಪೋಸ್ ಮಾಡಿದ್ರೆ?
Let it be on the list, my lords. I'll wait, my lords, till then. Please.
Serial number 60, my lord. I may be permitted to serve notice to Commissioner BDA panel council, my lord. In the just finished.
BDA party ಮಾಡಿದ್ದಾರೆ.
BDA no Commissioner party ಮಾಡಿಸಿ.
Number 58.
60, my lord. 60. Fourth respondent is the commissioner. Just finished with that matter.
The petition take a notice on the standing council for the BDA, that is K. Krishna.
Yes.
Serial number 3, my lords, instead of 19th, can we have it on 20th, my lords? I've informed the other side, my lords. Serial number 3, first list. 3.
Don't make a mention in the middle like.
My apologies to this court, my lords.
Serial number 86 ಮೇಲೆ ಇಲ್ಲಿ ಆರ್ ರವಿಶಂಕರ್ ಅವ್ರಿಗೆ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 3 ಗೆ ಟೇಕ್ ನೋಟಿಸ್ ಅಂತ ಇದೆ ಸ್ವಾಮಿ. ಅವರು ಹಿ ಇಸ್ ನಾಟ್ ಎ ಕೌನ್ಸಿಲ್ ಫಾರ್ R3 ಮೇಲೆ.
ಯಾರು ಮತ್ತೆ R3 ಯಾರು ಗೊತ್ತಾ?
ಪಂಚಾಯತ್ ಸರ್.
ಗೊತ್ತು ಪಂಚಾಯತ್.
ಬೈ ಹ್ಯಾಂಡ್ ಇಶ್ಯೂ ಮಾಡಿ.
ನೀವು ಯಾರಿಗೆ?
I am for petitioner.
They stated that Sri G. Ravishankar does not represent the third respondent. In view of the above, his name be deleted and petitioner is permitted to take out notice in R3 personal.
By hand ಮೇಲೆ.
Serial number 45, my lords. Interim order may be extended, my lords. And matter may be taken up on first week of March. Senior is not there.
Madam, continue. Serial number 60.
The date, sir.
60.
ಅದು 60.
Madam. R1 and R2 ಇದ್ದಾರೆ. R3. R4.
Date on, sir. R3 AG accept. R4 Krishna. R4. Court officer date ಹಂಗೆ ಅದು. ಅದು date sir.
ನನ್ಗೇನ್ ಗೊತ್ತಾ ಎಲ್ದಿ ಕೇಳಿದ್ರು ಫ್ರೈಡೆ.
Sir ಅದು 60 date. Sir, sir 60 ಅದು date ಒಂದು. 21st ನಮ್ದು 60. 21st.
60, 21st, sir?
ಸಿಸ್ಟಮ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ನಮ್ಮ ಮ್ಯಾಟ್ರಿಗೆ ಕ್ಲೈಂಟ್ ಆಗಿದ್ರೆ ಬೇರೆ, ಕ್ಲೈಂಟ್ ಇದ್ರೆ ನಾನು ಬೇರೆ ಹೇಳೋದು.
ಸೀರಿಯಲ್ ನಂಬರ್ 49 ಅಲ್ವಾ? 45 4th March. ಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್
ಸರ್
ಇರಿ ಒಂದು ನಿಮಿಷ. ಇಮಿಡಿಯೇಟ್ ತಗೊಂಡ್ರೆ 26 ಅರ್ಜೆಂಟ್ ಆಗಿದೆ ಮೇಡಮ್.
ನಿಮ್ ಕೊಲೀಗ್ ಇದ್ರು ಸಾಕು, ನೀವ್ ಇರ್ಬೇಕಂತೇನೆ.
ಸೀರಿಯಲ್ ನಂಬರ್ 49 ಇದೆಯಲ್ಲ?
52.
52 ಅಲ್ಲ 52 ಒಂದಿದೆ ನೋಡಿ. ಪಾಸ್ ಓವರ್ ಆಗಿದೆ 52. ಒಂಚೂರು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಇಟ್ಟಿದ್ದು ಒಂದು ಯಾವ ತರ ಮಂಡೇ ಟ್ಯೂಸ್ಡೇ
28. ಸರ್ 42 ಕೊಟ್ಟಿಲ್ಲಲ್ಲ ಸರ್. 42 ಡೇಟ್
ನಾನು ಅಪೋಸ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ.
ಇಮಿಡಿಯೇಟ್ಲಿ ತಗೋತಾರ ಮೇಡಮ್ ಅದು
21st.
ಸರ್ ಒಂದೇ ಒಂದು ಸರ್, ನೆಕ್ಸ್ಟ್ ಸೀರಿಯಲ್ ನಂಬರ್ 61 ಧಾರವಾಡ ಸರ್. ಅದ್ರಲ್ಲಿ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಏನ್ ರೇಸ್ ಆಗಿದೆ? 61 ನೆಕ್ಸ್ಟ್ ಫೈಲ್ ಏನ್? ಸಬ್ಮಿಷನ್ ಮಾಡಿ.
Copy of annexure. Letter copy of annexure to be filed as.
ಎಷ್ಟನೇ ನೆಕ್ಸ್ಟ್ ಸರ್? ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ಸ್.
Court officer, sir? Serial number 66 adjourn ಆಗಿದೆಯಾ ಸರ್? Court officer, sir?
Forward bench matter. Seal number 1, Sharad Malagoda Patil. Yes. Serial number 1.
A paper responded state, my lord.
Released. 21st. Seal number 2.
Lord, sir, appear for. My lord, I am for petitioner, my lord. The matter has been settled. Serial number 1, my lord, sir.
ಏನ್ ಸೆಟ್ಲ್ ಆಗಿದೆ?
Lords, may I hear?
Seal number 1.
Please, my lords, I appear for the petitioner in this case, my lords. Lords, it is against the husband, my lords. Accused number 1, my lords. Lords, one contention is that concerned, my lords. Last your lordships have heard that matter, my lords. Your lordships told my lords he's having one son, my lords, who has to take care. And my lords, allegation is concerned, my lords, they are all from 2018, my lords, there is not a single complaint or any matrimonial dispute against the husband and wife, my lords.
Husband, I will not interfere.
Yes, that is what your lordships told, my lords. My lords, I just, yes, my lords, I made submission the first instance only, my lords. My lords, I'll get the signature and I'll withdraw the petition, my lords. Since, my lords, the party has to come to withdraw the petition, my lords.
Released. 21st. Seal number 2.
Obliged, my lords.
My lords, I am for petitioner, my lords. The offence are punishable under 498A, my lord. The matter has been settled, my lord. Already we have filed a joint memo, my lords.
Where? Where have you filed?
I filed here only, my lords, in the narrowed bench, my lords. But it is not reflected in the cost item. Object judgment is not reflected. On 3-2 we have filed, my lord.
Stated that the joint memo is filed. Office to put up the same.
21st. Seal number 3 adjourned. Seal number 4, Sri Santosh Nandur. Released. Seal number 5. Sri Raghavendra Purohit.
My lord, I am appearing for a petitioner in this case, my lord.
Yes.
My lord, the allegation is, my lord, the 120B, 341, 353 and 149 of RPC, my lord. My lord, the petitioner was earlier a law student, my lord. Now he is advocate, my lord. The allegation is, my lord, the accused number 10 is alleged to conspire to throw the ink on the, my lord, the respond number 2, my lord.
University da.
Karnataka State Law University, my lord. Already, my lord, so far as accused number 10, my lord, your lordship has passed it, my lord.
Distance we will take notice. We will list on.
28. Kalburgi bench matter. Seal number 1, Sri R.J. Busare.
Busare.
Seal number 1. Kalburgi bench matter.
On last date of hearing, lordship has directed 4th respondent to file details of salary of the petitioner. Since advocate Vinayak Apte has given his not to post memo for another 1 week. So in his absence, he has asked me to take 1 more week.
Seal number 2, Sri S.G. Matt.
I am for the petitioner in connected writ petition 2.1.
Yes.
Then other than a daily wages.
How's son? Lord's assistant cooks working in Lord's BCM hostels. The submission was made on the last date of hearing, Lord's. Despite extracting work from these petitioners, salaries have not been paid regularly. Lords had directed learned government advocate to.
Madam, ಮಾಡ್ತೀರಾ ಇವತ್ತು ವಿಜಯ್ ಕುಮಾರ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು.
Lordship, ಇವರು ಮಟ್ ಅವರು he was prior amend ಮಾಡ್ತೀನಿ ಅಂತ submit ಮಾಡಿದ್ರಲ್ಲ. Since they want only the service security, not the regular registration.
ಅವ್ರೊಬ್ಬರದೇ ಆಯ್ತು ಮಿಕ್ಕಿದವ್ರದ್ದು.
ಅವ್ರದ್ದೇ ಜಾಸ್ತಿ ಇರೋದು, so I was expecting that he will file amendment petition. Okay.
Hello.
ಈಗ ಅಫಿಡವಿಟ್ ಏನು ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ದಾರೆ ಮೇಡಮ್ ಅದರಲ್ಲಿ ಅಂತ ಸರಿಯಾದ ರೀತಿಯಲ್ಲಿ ಅಂತಂದ್ರೆ ಇದು ಕಳಿಸಿಲ್ಲ ಪೆನ್ಷನರ್ಸ್ ಆಕ್ಚುಲಿ 145 ಜನ ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಬಿಜಾಪುರ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ನಲ್ಲಿ ಬಟ್ ಅವ್ರು ಸರಿಯಾದ ರೀತಿಯಲ್ಲಿ ಅಂತಂದ್ರೆ ಲಿಸ್ಟ್ ಕಳಿಸಿಲ್ಲ ಫಾರ್ ದಟ್ ಐ ಆಮ್ ಫೈಲಿಂಗ್ ದಿ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅಂಡ್ 10 more members ಅಂತಂದ್ರೆ ಐ ವಾಂಟ್ ಟು ಇಂಪ್ಲಿಟ್ ಇನ್ ದಿ ಪೆಟಿಷನ್ ಬೈ ಲಾರ್ಡ್ ಅಂಡ್ ಇದು ಸೇವಾ ಭದ್ರತೆಗಾಗಿ ಇಫ್ ದ ಗವರ್ಮೆಂಟ್ ಈಸ್ ರೆಡಿ ಟು ಕಾಂಪ್ರಮೈಸ್ ಫಾರ್ ದಿ ಸೇವಾ ಭದ್ರತೆಗಾದ್ರೆ ಒಂದ್ ವೇಳೆ ಬೆಟರ್ ರೆಫರ್ ಟು ದಿ ಲೋಕಲ್ ಲೆತ್ ಮೇಲ್ ಅವರು ಒಂದ್ ತಿಂಗಳಲ್ಲಿ ಕಾಂಪ್ರಮೈಸ್ ಆದ್ರಪ್ಪ ಅಂದ್ರೆ ಸೇವಾ ಭದ್ರತೆ ಆಯ್ತು ಅಂದ್ರೆ ದೆನ್ ಆರ್ ಅದರ್ವೈಸ್ ಐ ಆಮ್ ರೆಡಿ ಟು ಆರ್ಗ್ಯೂ ದ ಮ್ಯಾಟರ್ಸ್.
ರಾಜಿ ಮಾಡ್ಕೊಳ್ತೀರಾ?
Sir, I will get instructions from the authority.
One small submission, Lords. These petitioners, they have been serving from more than 15 to 16 years as assistant cooks, and they are almost at the fag end of their career. 55-56 ವರ್ಷ ಅವರಿಗೆ ವಯಸ್ಸಾಗಿದೆ. ಅವರು ಇದು ಆಗುತ್ತನ ಕಂಟಿನ್ಯೂ ಮಾಡಿದ್ರೆ ಅದನ್ನೊಂದು if they could consider the government.
Madam, if I pass an order of regularization, then you will be in trouble.
Yes, Lordship, that is a reasonable prayer. Since I have discussed with my AAG also and same communicated to the respondent authority.
28.
A day after, week after next, Lordship.
28.
Please.
Please refer to the local.
Number 3.
My lord.
Yes. Number 3.
3 and 4, Gaurish Kashampur appears, Lordship, since the petitioners are working in the CMC of the concerned.
Where is Gaurish?
He said some family urgency, he is not able to appear. He has asked, he is one of the colleagues.
List number 1, 2:30 PM matter. Seal number 92.
List ಆಗ್ಲಿಲ್ಲ sir.
My lord, I am appearing for the petitioner in this matter, my lord.
Your lordship kindly have it next month.
My lord, kindly have it on 24th or 28th, my lord.
ಅಲ್ಲ ಲಿಸ್ಟ್ ಆಗ್ಲಿ ಫಸ್ಟ್ ಅಂತ.
Tentatively listed on 18 ಅಂತ ತೋರಿಸ್ತಾ ಇದೆ ಸ್ವಾಮಿ, ಅದಕ್ಕೋಸ್ಕರ.
ಅಲ್ಲ ಟೆಂಟೇಟಿವ್ ಲಿಸ್ಟ್ ಆಗಲ್ಲ, ಹಾಗಾಗಿ 7 much okay.
So matters, list number 1. Seal number 17.
But we have requested PW department to not inspect the spot and give the fitness certificate. Lordship may have it on Monday. Till that point of time, Lordship may stay the proceedings. As far as 3 activities are concerned, we'll place the report based on which Lordship may modify the order.
Memos filed by the by Shri Pradeep, Council of Hearing for which the respondent.
Lord, I am for R2.
Second respondent, in which the communication dated 12/2/2025 by the PW department has been enclosed. In this communication, it is noticed that the PWD requires a certificate for the safe running of 3 activities, that is Giant Wheel, Tora and Columbus. Learned Counsel for the second respondent submits that he would request the PW to conduct a fresh inspection and make his submissions by next week. In the light of the fact that the PWD is doubting the safety of the 3 activities, the second respondent is restrained from carrying out for permitting the Giant Wheel, Tora and Columbus to be function. Till then, relist.
Current respondent. Not Monday, my lord, mention that on Monday, my lord.
ಯಾವತ್ತು ಹೇಳ್ತೀರಿ?
ಅಲ್ಲ Monday ನೇ ಕೊಡ್ತೀವಿ, otherwise my lord.
All right. ಏನ್ ಹೇಳ್ತಾರೆ ನೋಡಿ, ಸಪೋಸ್ PWD said is safe.
That is why we requested my lord PW
Up to you to see that they make it proper or improper. ಅಲ್ಲ ಅವ್ರ ಪ್ರೆಷರ್ ಆಗ್ತಾರೆ ಅದು ಪ್ರಾಪರ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿ, ಸೊ ನಿಮಗ್ ಬಿಟ್ಟಿದ್ದು.
Here you've got 2,000, 5,000 people visiting every day.
That is why we are also aware that public safety. That is why, my lord, I wanted to
You
take.
don't seem to be interested in public safety. You're only interested in the money that.
No,
the
no, no,
public
no,
can give
no.
you.
In fact, my lord, we have requested today, my lord, again, that, my lord, that is why, my lord, request.
How can he ever grant such a conditional permission? He only wants money. For money, he will grant any permission. You tell me, how can he permit that? Suppose something happens, will he take responsibility?
But I understand, but I understand.
I don't know. It's a dangerous thing that he's doing.
But in fact, my lord, the engineer's report is there, my lord, that can be, my lord, carried out on the basis of which, my lord, we have taken, my lord, all the, my
I'm
lord, the
telling you,
reports.
Till some tragedy happens, you won't wake up. And once tragedy happens, all that you'll do is you'll cover up. When you have a chance to rectify it, why don't you take advantage of it? I don't think the events will fall down if these three activities are not conducted. Do it properly. I don't know why.
Please. Lord, Monday, my lord, Monday. Lord, my request for, my lord, it may be in the fresh matter, fresh matter, my lord.
He mentioned Madi, mention Madi. 1:30, 2:30 hour mention Madi.
Please.
Third respondent is consent.
They will have access notice for R3.
My name may be shown for R2, my lord.
First print the name of Sri Pradeep was appearing for R2.
Lordship, my lord, my request for, my lord, hand delivery so that, my lord, he'll.
He is here, why it is required hand delivery? Delivery permit. Hand delivery permit.
Bill number 27.
For respondent number 8 to 27.
Prior to that, the BTP itself notified several RCC culvert among the area and demolition every culvert apart from this culvert. Thereafter, we have also made investigation on the public safety. Every time it is the fact remains that the RTC culvert is illegal and thereafter by obtaining during the pendency of the permission, they constructed new RCC culvert in the very same place. But the procedure adopted by the respondent 7 to 13 is that based on the annexure E along submitted along with the red petition ownership, that is the all of a sudden they entered into parties between in respect of easement right of way document. That easement right to way of document consists of 8,900 something square feet project. That 8,900 square feet includes the Rajkalver extent because that document came to be.
Please don't go beyond the culvert. You're only on the culvert.
Based on that, it's a part of the document of the restriction logic. So if that in between two survey numbers, that document came to be
Again, you're going away from the prayer in the writ petition. The prayer in the petition is confined only to the culvert.
Yes, you.
Nothing more. If you have any other grievance,
But it includes that study in between the private parties, including the Rajkalve extent in respect of 3 to 4 quintas is my main contention. I have also urged in the.
see the prayer.
I'm ready.
My lord, for a moment, this court had asked me to produce photographs.
My prayer is this, you should issue a writ of mandamus or any appropriate writ order direction corresponding number 1 to 5 to consider the representation dated 4/10/2023 and thereby direct the respondent to demolish the remove the constructed survey number.
So that is all. Confine your argument.
And 89/1.
Confine your arguments only regarding the illegal culvert that is constructed. You cannot argue on the proposed development that they are undertaking in their land.
I agree with Lordship, but that such illegal permission was granted during the pendency of the interim order and as well as the rate petition. But to a specific order has directed the respondent number 4 and 5 in this case on 15/12/2020 to comply with the specific directions of this orders. That order is not being complied by the BTP. That is the main. If this order is complied, every aspect in my case is coming to for example, Sir, a specific direction is directed to ADLR to conduct the spot inspection and give the report on or before February, Your Lordship. Such report is not being filed by the respondent. All of, on every date, he is extending time, seeking time. That thing has been happening here.
Anything else?
Please.
Jatra,
Yes, sir.
I'm dismissing your petition. No. The prayer in this writ petition is for issuance of a direction to respondents 1 to 5 to consider the representation dated 4/10/2023 and thereby further direct them to demolish/remove the illegal culvert constructed over number 87/1 and 89/1 of Woody Village, Kiarapuram. It is the case of the petitioner that the respondent
Respondent number 7 to 13, my lord.
have illegally constructed a culvert and that is required to be demolished. Learned counsel for the petitioner has himself filed an application for amendment of the writ petition. Amendment tan accurate.
ಹೌದು.
In which it is requested to set aside, which is requested to amend the writ petition and permit the petitioner to set aside the illegal sanction of new license/plan granted for the reconstruction of the RCC culvert under the scheme self-financing scheme as per the letter dated 23/2/2024. And a further prayer is also sought for to demolish the culvert. Once it is shown that the BBMP has itself granted permission to construct a culvert, and that too on the condition that the earlier culvert put up by the petitioner is demolished, the averment of the petitioner that the permission granted by the BBMP was illegal cannot be accepted. It cannot be in dispute that the BBMP is the owner of the drains, and if it feels that a culvert can be constructed by the adjoining owner at its own cost in the manner specified by it, the request of a person like the petitioner cannot be entertained, since the petitioner is neither a technical expert nor he has any direct interest in the matter. Therefore, the view that there is no justification to entertain this writ petition and also the prayer to amend the writ petition. Petition is therefore dismissed.
My lord, my photographs may be taken into consideration that I have demolished.
Bill number 29.
For the respondent, the last date, my lord, the lordships have directed me to file the list of the nodal officers. List is ready, my lord. It requires approval of that is orders from the chief commissioner. If my lords can accommodate me for a week's time, my lord, in the meantime, list is ready. I can show it to your lordships. For that also require the approval of house. Without chief commissioner's approval for everything, my lord, I'll have to take chief commissioner's approval. Adukku bekagate, since my lord, there is some inconvenience today. That is the reason I could not obtain the approval of. Your lordships have actually, in fact, last time, your lordships have written this. See, if required, CC's approval is required. Nodal officers na appoint opponde. Yakandre yenagate andre nodal officers na appoint madbekadre CC approval ide agalla. That's the reason. Next week, if my lords can have it, the Lord Council submits that the list of email addresses to whom orders can be communicated as ordered earlier is ready, but it is awaiting the formal signature of the chief commissioner. He seeks for 3 days time. So, who was present before the court in the last. She is now transferred. That's a problem. Merits ಬಗ್ಗೆ ನಾನು I'll make my submissions. Once I place this particular order on record and then I'll place. ಇದು ಸಂಬಂಧ ಇಲ್ಲ. Lord, insofar as merits is concerned, my lord. Which provision says that for granting a trade license? My lord, 308 may kindly be seen. basically what we have done is. Did you file the affidavit regarding the other bar 200 meters down the road? Please, bro. That other bar that was there. 200 meters, idukke. Lord, we will take action insofar as that. And we have verified it. Lord, basically the grievance of the third respondent was against this. If you have not issued notice to him, issued notice only to him, I will impose cost on the person. I can only say this much. There was a serious objection insofar as from the respondent number 3, my lord. You are not concerned with serious objections. You are concerned with zonal implementation of the zonal regulation. Yes. So only if somebody complains, you will implement it. Lord, I can, as of now, my lord, my situation is like this only. I don't have any answers insofar as these questions are concerned. As choose I can't say anything. I can only say this much, my lord. This will be the grievance of every citizen. If you selectively. No, it is not the grievance, my lord. What I say is this. My lord, the petitioner is before your lordship saying that I am intending to take some action against him. My lord, now the question now, my lord, whether he has violated the law or not is the question in this writ petition. That is where, my lord, I am only just pointing out to your lordship that there is violation. Equality before all laws can be thrown to the wind. No, it is not like that. We will take action if some mistake has taken place, my lord. We will definitely take action. That is where we have given instructions. That is why I said, Satyanand, I am prepared to support you if you are honest. Yes, we will take it, my lord. We will kategul bada. Alla marti now. Illa ant helta. File the affidavit of the zonal commission. No, I'll do one thing, my lord. That is where, my lord, this entire comprehensively. No, if you take a stand. Yes. The citizens will know as to what they should do, what they should not do. If you were to selectively choose, I like Satyanand's face, therefore I'll grant him permission. I don't like so-and-so's face, I will not grant him permission. I concede that, my lord. Absolutely no problem. You make your stand clear. Yes, we will do that. Adike onesati nange Chief Commissioner hatra I'll have to have a discussion with him insofar as these matters are concerned. Taking action against the entire premises wherever that particular shops are being done. Lord, without his consent, my lord, or without discussing with him, I can't take it. That adike salpa time bekagat nange. Used it. Insofar as this aspect, my lord, merits are concerned, Lord, definitely there is violation of law from their side. I have no doubt I have committed a mistake here in issuing a license. Lord, after that, I have rectified myself by issuing a notice saying that you please shift yourself. There is serious objections. That's the reason, my lord, I am before you. Correct stand because you are walking on a tightrope. I know that. If you slip, now this becomes difficult, my lord, insofar as all matters are concerned. Trade license zonal regulations nodaga building violations tu baratte ella building igu nan action tagolak shuru madbekagutte. That is where it has got a drastic consequences. When you touch this issue, you should be prepared of the consequences. You are going to open a Pandora's box. Elections are coming. Let us see what stand you will take. And I am also interested because this is wrong. I know. Whenever you wake up, you suddenly feel everybody should be awake. Whenever you sleep, everybody should be sleeping. I will not say anything insofar as that aspect is concerned. Used it. Lord, as and when the complaint is received, my lord, I have started taking. I have found out. Tuesday ginta on 2 weeks time kotre if my lords can accommodate me because I'll have to. You are asking him not to conduct his business. You know how much license fee he's paying? My lord, I can only say now he is conducting his business there only. Yeah, he has not stopped his business. Interim order there. He has not stopped his business. He is conducting his license without there being a trade license. My lord, he is doing his business. Used it. Only one that this action is moved. The base of the third respondent. Before filing an application to come on record, third respondent has told the property authority suppressed. No, first, I am more interested in Satyanand's client. Used it.
Number 37.
Another matter was also passed over. 28 was passed over. 2 matters were passed over. 28 and 29. No, 28, I think it was agenda. Please. Adರಲ್ಲಿ ನಾನು report ಹಾಕಬೇಕಾಯ್ತು. I'll permit me, my lord. I'll file it in the registry.
Sort of, my lord, 37 is concerned, my lord, is not covered, my lord. Challenging the notification of the impugn notification annexure R, my lord. I want to file objection on that point. Yes. No, it's not quashed, my lord, regarding the earlier petition, my lord, that petition is, my lord, but they're not challenging the notifications. Here, my lord, kindly see annexure R, my lord, they're challenging the notification, my lord.
Page
150.
Next, R, of that 4. Yes, Manas, the government has issued a notification saying that 90 feet road has to be formed. Plus existing 45 feet has to be enhanced to 90 feet. And I should relinquish the said property at the free of cost. And no development should be taken even.
On that regard, my lord, the government, my lord, directed to that BMRDA to regarding whether feasibility that is going on or not, my lord, because earlier 2007 notifications is there. Whether we are implement or that or not, my lord, Nadita, that is the reason, my lord, I want to file objection on that point, because we are not insisting anything regarding that, challenging the notification, my lord, I want to file objections.
Kindly refer to this judgment, Manas, whether the notification is answered.
I can't rename the right to file objections.
Only 1 minute. Manas, I have farmed a life twice, relinquished the property twice. Manas, paid the amount for development charges at twice. Manas, they are not now releasing the sites. Manas, are complete.
ಈ ರೋಡ್ ಜಾಗ ಬಿಟ್ ಮಾಡಕ್ಕಾಗಲ್ವಾ? ಎಷ್ಟಿದೆ ರಿಲೀಸ್ ಮಾಡಕ್ಕೆ ಇನ್ನು?
Regarding that, my lord, that regard, my lord, lordship, my lord, can pass an interim order to regarding the observation made, whether that portion of the road cannot be released. That the head.
How many sites are to be released?
My lord, we are not challenging any reason. We are not raising any sites regarding that, my lord. Because of, my lord, whether we have go into that notification or that notification, another question is there.
Now, what is the interim order that you want now?
Let them release my sites, my lords, in respect of this.
Whether the, Allah,
Wait, let us listen to him first.
25, my lords.
Lord, nice respectful submission is, my lord. Wherever the road is passing through the sites, my lord, they will remaining, my lord, we are not releasing. Other sites is concerned, my lord, lordship can pass an order.
25, first on 25, the sketch, approved sketch. Proposed road, which passes in the middle, bypass, bypass road.
13.92.
How? Yes, my lord. Well, this is 45 feet. Now it will be enhanced to 19 meters, my lord. It is 45 meters.
19.
90 meters as per the notification.
So the row of sites from 41 to 32 and 36 to 31. This block, they will not release.
Then let them release respect of that property. I will contest this matter.
Subject to petition of my final order of this commission, and we have considered.
It is the case of the petitioners that the layout plan that was approved in their favor indicated that there would be a proposed 24-meter road, bracket and bypass. But subsequently, a notification has been issued.
This road is also existent, now. It was acquired.
Will use model proposed on the Tana.
Now it has been acquired, compensation has been paid. Now this 45 meters road is want to be widened by 90 meters.
Councillor Priya submits that the proposed 24-meter road, that land in respect to this proposed 24-meter road has in fact been acquired and compensation is paid to the petitioners. So he submits that now there is a proposal to increase the width of the road to
90 meters.
90.
90 meters.
90 meters.
Free of cost.
And the authority is insisting that the 90-meter, that the area required for the widening should be relinquished free of cost. He submits that the petitioner is aggrieved of the said insistence and has presented this writ petition. And the planning authority is not releasing the sites until the petitioner agrees to relinquish the area that they desire. The council appearing for the planning authority submits that the authority has a right to insist on the lands being relinquished free of cost. He prays for time to file his objections. My view, the planning authority cannot withhold the release of the sites, at least insofar as those sites which would not be affected by the proposed widening of the road. The planning authority is therefore directed to release the sites except those sites which would fall within the purview of the proposed widening of the road. road. ಎಷ್ಟು ಪರ್ಸೆಂಟ್ ಏನಿಲ್ವಾ 60%, 40%?
Now what are the, there is a notification. On layout, if I complete the layout, they will release the entire 100%. Earlier there was notifications, my lord,
there are
first stage was 30%.
two-
Second stage was
two method is there, my lord.
40%. Now let them release the my lords, I have completed it.
ಇಲ್ಲ ನಿಮ್ ವರ್ಕ್ ಆರ್ಡರ್ ಏನಂತ ಹೇಳಿ ಎಷ್ಟು ರಿಲೀಸ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿ.
ಅದನ್ನ work ಮಾಡಲಿಲ್ಲ. Entire.
ಎಲ್ಲಿ ವರ್ಕ್ ಆರ್ಡರ್ ಇಲ್ಲಿ
Kindly refer to that.
14 ಅಲ್ವಾ ಸ್ಟ್ಯಾಚ್ಯೂಟರಿ
ಇಲ್ಲ ಇವಾಗ ಮೆಥಡ್ ಮಾಡಿದ್ದಾರೆ my lord. If my lord they want to entire layout, then my lord go for section 72. Otherwise my lord section 17C ಅಂತ ಇದೆ ಮಾಡಿದ್ವಿ.
Sorry, 128, 122 my lord.
ಅವ್ರು ಹಾಕೋದಲ್ಲ, ಅವ್ರು ಅಪ್ಲಿಕೇಶನ್ ಕೊಡ್ಬೇಕು ಮೆಥಡ್ ಅಪ್ ಅಂತ ಹಂಗ ಹೇಳೋದಲ್ಲ. Kindly see my lord section 17(2)C. Otherwise, my lord, they will develop the land entire layouts.
40-60 ಅಂತಾನೆ.
ಅಲ್ಲ ಇದು ಅವರು ಹೇಳಬೇಕು ನಮ್ಗೆ. If my lord they give an application under section 17(2)C, say that my lord they given 60% ಅಂತ, then we will consider in respect of section 17C is concerned. Otherwise, ಖಾಲಿ application ಕೂಡ ಅವರು entire layout approve ಮಾಡಬೇಕು. Because my lord, lordship my lord kindly say that circular my lord, there are so many developers has not developed the layout. ಹಂಗೆ ಮಾಡ್ಬಿಟ್ಟು ಹೋಗಿದ್ದಾರೆ. That is the reason lordship aware of that earlier matter.
ಇವಾಗ this order will affect you in any way?
It did not affect regarding that my lord, that site is concerned not affect my lord, because he have not given application under section 17(2)C. Entire layout approve ಮಾಡ್ತೀವಿ ಅಂತಾನೆ ತಗೊಂಡಿದ್ದಾರೆ ಅವರು.
ಬಟ್ ಇಲ್ಲಿ ಹೆಂಗ್ ತಗೊಂಡಿದ್ದಾರೆ? 17(2)C ಅಂತ ಇದೆ page 122.
Please.
Yes,
So 40-60 only.
Please put 60. 40 ಅಲ್ಲಿ ಬರುತ್ತೆ, 40% ಅಲ್ಲಿ ಬರುತ್ತೆ.
Now it has been fully completed.
That is the reason my lordship aware of that.
If it's fully completed, you will have to go inform them, isn't it? First.
Please.
Inspection ಆಗಿದೆಯಾ?
Inspection ಆಗೋದು ಗೊತ್ತಿಲ್ಲ ನನಗೆ, because I will take inspection on that point. My one submission. He is otherwise eligible ಅಂತ ತಾವೊಂದು entry model ಹೇಳಿದ್ರು. Even
ಯಾರು ಹೊಸದು ಹುಡುಕ್ತೀರಾ, ಅದಕ್ಕೆ ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳಿ ನೀವು.
Please. Regarding, I have it on my lord Wednesday my lord.
It is noticed that the approval accorded was under section 17(2)C, which contemplates release of sites in two stages. 40% on approval of original plan and 60% on completion of the layout.
Please.
It is the case of the petitioner that the development has been complete and he has also informed the same to the planning authority. If that be so, the planning authority shall take into consideration the completion and thereby permit the release in accordance with section 17(2)C. That is for the remaining 60%.
Please my lord. Regarding my lord, subject to result of the final orders.
Except the aforementioned sites and
Please.
except the aforementioned sites and that point is this order shall be subject to the ultimate result of this writ.
Please.
Exercise vigilance.
Let them give me application on that regard.
ಯಾಕ್ ಕೊಡ್ಬೇಕು? They said they have improved.
Regarding that my completion certificate ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಗೊತ್ತಿಲ್ಲ.
If the petitioners have furnished a completion certificate, the above said exercise should be undertaken and completed within a period of 1 month.
Please.
And the date of receipt of copy of this order.
Please.
Number 52.
Page number? 40. Yes.
Where they issued me a notice to stop the construction. This notice is not the ground that I violated the license plan or I violated any terms of grant of license. They say that a third party claims rights over the said property.
Therefore, you are required to publish the date. Now in this, if the lordship may kindly take page 19, that is a typed copy of section 8.
As per the direction of the Honorable Court, upheld the objection along with the survey report, my lordship.
What is the objection that they have now filed?
I'll just show that page 19, if the lordship may kindly take.
Page
19, typed copy of section. Please so and so. ಕಟ್ಟಡ ನಿರ್ಮಾಣ ಮಾಡಲು ಪರವಾನಗಿ ಕೋರಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದು ಅದರಂತೆ ತಮಗೆ ನಿಮ್ಮ ಕಟ್ಟಡ ನಿರ್ಮಾಣ ಮಾಡಲು ಕಟ್ಟಡ ಪರವಾನಗಿ ನೀಡಲಾಗಿರುತ್ತದೆ. ತದನಂತರ ದಾದಾಪೀರ್ ಸಾಬ್ ಬಿನ್ ಸೋನ್ಸೋ ತಾವು ಕಟ್ಟಡ ನಿರ್ಮಿಸಿರುವ ನಿವೇಶನವು ದಾದಾಪೀರ್ ಸಾಬ್ ಅವರ ಸರ್ವೆ ನಂಬರ್ 144/2 ರಲ್ಲಿ ಒಳಗೊಂಡಿದೆ. ಅಪರಾಧಿ ಸದರಿ ನಿವೇಶನವನ್ನು ಭೂಮಾಪನ ಇಲಾಖೆಯಿಂದ ಸರ್ವೆ ಮಾಡಲು ತಾವು ನಿರ್ಮಾಣ ಮಾಡುತ್ತಿರುವ ಕಟ್ಟಡವು ಸೋನ್ಸೋ ಅವರ ಸರ್ವೆ ನಂಬರ್ 144/2 ಜಾಗಕ್ಕೆ ಒಳಪಟ್ಟಿದೆ. ತಮ್ಮ ಕಟ್ಟಡ ಪರವಾನಗಿ ತಡೆ ಇಲ್ಲ. Your lordship may kindly take annexure R1 which they have filed. This is the RTC, page number 8 of the objections. That's filed pertaining to the land owned by the said Dadapir. That your lordship will find is not in respect of 144/2, it is just 144. Then annexure R2, lordship will find Haddubossiಗೆ ಅರ್ಜಿ ಅದರಲ್ಲಿ ಬಾಜುದಾರರ ಹೆಸರಲ್ಲಿ ಎಲ್ಲೂ ನನ್ನ ಹೆಸರು ಬರಲ್ಲ. On page number 10, the lordship will again find survey number 144, only 140. Now the request letter given by this Dadapir, your lordship will find on page 16, that is annexure R6. Here also it says ನನಗೆ ಸೇರಿದ survey number 144. He does not mention anything about 144 part. But all is agreed by that.
What is your objections in the?
I object kindly, sir. First of all, questioning the notice issued by the Panchayat Minister. First, they are not replied notice, one point. Next, second point is, this alternative remedies, 269 appeal is there. Second point, third point is, my lord, the complaint filed by the one Dadapir, they not made the party in this petition, my lord. 3 points. Kindly see the annexure R3, my lord. ಅಲ್ಲ R5 ಪೇಜ್ ನಂಬರ್ 15 ಸರ್ವೆ ಸ್ಕೆಚ್ ಅಲ್ಲಿ ತಾಲೂಕ್ ಸರ್ವೆ ಮಾಡಿದ್ರಲ್ಲಿ ಈ ಬಣ್ಣದಿಂದ ಕಂಡ್ಲಿ ಸ್ವಲ್ಪ ಕಾಣಿಸ್ತಾ ಇಲ್ಲ ಮನುಷ್ಯ ಕೆಳಗಡೆ ಈ ಬಣ್ಣದಿಂದ ಕೂಡಿರೋ ಜಾಗದಲ್ಲಿ 3 ಕುಂಟೆಯನ್ನು ಒತ್ತುವರಿ ಮಾಡಲಾಗಿದೆ ಅಂತ ಇದೆ ಮನುಷ್ಯ. ಆ 3 ಕುಂಟೆ ಅವರು ಆಕ್ಚುಲಿ ಸರ್ವೆ ಸ್ಕೆಚ್ ಮಾಡಿ ಒತ್ತುವರಿ ಮಾಡಿದ್ರೆ ಅಂತ ಅಲಾಂಗ್ ವಿತ್ ಅಬ್ಜೆಕ್ಷನ್ ನನಗೆ ಕೊಟ್ಟಿದ್ರಿಂದ ಸೊ ನಾನೇ ಮಾಡಿದೆ ನಿಮ್ಮ ಜಾಗನ ನೀವು ಯಾವ್ದೋ ಒಂದು ಐಡೆಂಟಿಫಿಕೇಶನ್
ಇದನ್ನ ಅವ್ರು ಕೊಟ್ಬಿಟ್ಟು ನೀವು ಈ ತರ ಹಿಂಗ್ ಬಂದಿದೆ ನೋಡಿ, ಈ ತರ ಡಾಕ್ಯುಮೆಂಟ್ ಇದೆ, ಇದಕ್ಕೆ ನೀವು ಉತ್ತರ ಕೊಡಿ ಅಂತ ಫಸ್ಟ್ ಕೇಳ್ಬಿಟ್ಟು ಆಮೇಲೆ ಹೇಳ್ಬೇಕಾ, ಇಲ್ಲ ನಿಮ್ಮಷ್ಟು ನೀವೇ ಯೂನಿಲೇಟರ್ ಡಿಸೈಡ್ ಮಾಡ್ಬಿಟ್ಟು ಈ ಸರ್ವೆಯಲ್ಲಿ ಅವ್ರ ಪಾರ್ಟಿ ಆಗಿದ್ರಾ?
ಸರ್ವೇಲ್ ಪಾರ್ಟಿ ಅಲ್ಲ ನಾನು
ಈ ಸರ್ವೆಲ್ ಅವ್ರ ಪಾರ್ಟಿ ಆಗಿರೋದನ್ನ ನೀವು ಯಾವ ಭರವಸೆ ಮೇಲೆ ಇದು ಸರಿ ಇದೆ ಅಂತ ಮಾಡಿದ್ರೆ?
ಅಲ್ಲ ಸರಿ ಅಂತ ಹೇಳಿಲ್ಲ ಕೈಂಡ್ಲಿ ನಾನು ನೋಟಿಸ್ ಕೈಂಡ್ಲಿ ರೀಡ್ ಮಾಡಿ.
ಹೌ ಕ್ಯಾನ್ ಯು ಇಶ್ಯೂ ಅ ನೋಟಿಸ್?
ಅಲ್ಲ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದೇನು ಅಂತಂದ್ರೆ ಈ ಸರ್ವೆ ಮಾಡಿ ತಾಲೂಕ್ ಸರ್ವೇರ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಆಕ್ಚುಲಿ ಅವ್ರದ್ದು ಅಂತ ಹೇಳ್ತಿದ್ರೆ, ಸೊ ಹಂಗಾಗಿ ನೀವು ಅದನ್ನ
ತಾಲೂಕ್ ಸರ್ವೆ ಏನಕ್ಕೆ ಸರ್ವೆ ಮಾಡದ?
ಕಂಪ್ಲೇಂಟ್ ಫೈಲ್ ಬೈ ಒಂದು ದಾದಾಪೀರ್
ದಾದಾಪೀರ್ ಮಾಡಿದೇನು ಕಂಪ್ಲೇಂಟ್ ಅಂತ ನೀವು ಚೆಕ್ ಮಾಡ್ಬೇಕು ತಾನೆ, ಇವನ್ ಮೇಲೆ ಏನಾದ್ರು ಇದೆಯಾ, ಇವನ್ ಪಾರ್ಟಿ ಆಗಿ?
ಅಲ್ಲ ಅದಕ್ಕೆ ಅಲ್ಲ ಕೈಂಡ್ಲಿ ಸಿ ಕೈಂಡ್ಲಿ ಪರ್ಮಿಟೆಡ್ ರೀಡ್ ದಿ ನೋಟಿಸ್ ಮೇಲೆ. ಆ ನೋಟಿಸ್ ಅಲ್ಲಿ ಏನಂತ ಹೇಳಿದ್ವಿ ಕೈಂಡ್ಲಿ ಸಿ ಮಧ್ಯದಲ್ಲಿ ದಾದಾಪೀರ್ ರವರ ಸರ್ವೆ ನಂಬರ್ 144/2 ಜಾಗಕ್ಕೆ ಒಳಪಟ್ಟಿರುವುದರಿಂದ ತಮ್ಮ ಕಟ್ಟಡ ನಿರ್ಮಾಣ ಪರವಾನಗಿಯನ್ನು ತಡೆಹಿಡಿಯಲಾಗಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ತಮಗೆ ಈ ನೋಟಿಸ್ ತಲುಪಿದ ಕೂಡಲೇ ತಮ್ಮ ಕಟ್ಟಡದ ನಿರ್ಮಾಣ ಕಾಮಗಾರಿಯನ್ನು ಸ್ಥಗಿತಗೊಳಿಸಿ ತಮ್ಮ ಸ್ವತ್ತಿಗೆ ಸಂಬಂಧಿಸಿದ ತಮ್ಮ ಜಾಗವನ್ನು ನಿಖರವಾಗಿ ಗುರುತಿಸಿಕೊಂಡು ಕಟ್ಟಡ ನಿರ್ಮಾಣ ಐಡೆಂಟಿಫಿಕೇಶನ್ ಮಾಡ್ಕೊಂಡು ಮಾಡಿ.
ನೀವು ಪ್ಲಾನ್ ಅಪ್ರೂವ್ ಮಾಡಿದಾಗ ಒಂದು ಇನ್ಸ್ಪೆಕ್ಷನ್ ಮಾಡುತ್ತಾನೆ ಅಪ್ರೂವ್ ಮಾಡೋದು ಅಲ್ವಾ?
ಇನ್ನೊಂದೇನು ಅಂತ ಅಂದ್ರೆ
ಏನ್ ಹೇಳ್ಬೇಕಿತ್ತು, ನನ್ನಪ್ಪ ನಿಮ್ಗೆ ಏನೋ ತಕರಾರಿದ್ರೆ ಸಿವಿಲ್ ಕೋರ್ಟ್ಗೆ ಹೋಗು, ನಾವಿದ್ ಇದ್ಯಾತ ಮಾಡಕ್ಕಲ್ಲ ಅಂತ ಹೇಳ್ಬೇಕಿತ್ತಾನೆ ನೀವು.
ಅಲ್ಲ ಈಗ ಇದು ನೋಡಿ ಅಲ್ಲ ಈ ನೋಟಿಸ್ಗೆ ರಿಪ್ಲೈ ಮಾಡಿದ್ರೆ ಅಲ್ಲಿ ಪಾಸ್ ಆರ್ಡರ್ ಮೇಲೆ ಅಷ್ಟು
ಏನು ಹೋಲ್ಡಿಂಗ್ ಯು ಆರ್ ದ ನೌ ಸಿವಿಲ್ ಕೋರ್ಟ್, ಯು ವಿಲ್ ಡಿಟರ್ಮಿನ್ ವೆದರ್ ದೇರ್ ಇಸ್ ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ಆರ್ ನಾಟ್.
ಅಲ್ಲ ಈ ಸರ್ವೆ ಸ್ಕೆಚ್ ಪ್ರಕಾರ 3 ಕುಂಟೆ ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ಅಂತ ಅವ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ.
ಇಸ್ ದಿ ಅಲ್ಟಿಮೇಟ್ ಡಾಕ್ಯುಮೆಂಟ್ ಫಾರ್ ಯು. ಎಸ್. ವೈ ಡು ಯು ಟೇಕ್ ದಿಸ್ ರೆಸ್ಪಾನ್ಸಿಬಿಲಿಟಿ? ಯು ಕುಡ್ ಆಸ್ಕ್ ದೆಮ್ ಟು ಗೋ ಟು ದಿ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಂಡ್ ದೆನ್ ಟೇಕ್ ಎ ಡಿಸಿಷನ್. So you are now enforcing the rights of citizens as a civil.
And also it actually both ಸರ್ವೆ ನಂಬರ್ ಬರುತ್ತೆ, ಆಕ್ಚುಲಿ ಸರ್ವೆ ನಂಬರ್ ಬರುತ್ತೆ, ನಮಗೆ ಮಾಡಕ ಅಧಿಕಾರ ಇಲ್ಲ, ಬಾರ್ಡರ್ ಬರುತ್ತೆ ಅಂತ ರಿಕ್ವೆಸ್ಟ್ ಕೊಟ್ಟಿರೋದು ಅವ್ರು ಮಾಡಿದಾರೆ ಅಷ್ಟೇ.
ನೀವು ಒಂದು ಸರ್ವೆ ಆರ್ಡರ್ ಮಾಡಿ ಅವ್ರನ್ನೂ ಪಾರ್ಟಿ ಮಾಡಿ ಅದಕ್ಕೆ ರಿಪೋರ್ಟ್ ತಗೊಂಡು ಆಮೇಲೆ ಹಿಂಗಿರೋದ್ರಿಂದ ನಾನು ವಿಡ್ರಾ ಮಾಡ್ತೀನಿ, ಒಪ್ಕೊಳ್ತೀನಿ. ಅವ್ರು ಬಂದು ಹೇಳಿದ್ರು ಅದರಿಂದ ನಾನು ಮಾಡ್ತೀನಿ ಅಂದ್ರೆ ಏನ್ ಅರ್ಥ? If you withdraw this notice, I will keep quiet, or else
ಅಲ್ಲ ಇದರಲ್ಲಿ ಆ ನೋಟಿಸ್ ರಿಪ್ಲೈ ಕೊಳ್ಳಿ ಪಾಸ್ ನೆಸರಿ ಆರ್ಡರ್ ಮಾಡಿ ಯಾಕಂದ್ರೆ ಅದನ್ನ ಆರ್ಡರ್
ಏನಂತ ಮಾಡ್ತೀರಾ?
ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಡು ಏನಾಗುತ್ತೆ ಅಲ್ಲಿ ಕಾಂಪ್ಲಿಕೇಶನ್ ಆಗಿದೆ ಅದಕ್ಕೋಸ್ಕರ ಆ ನೋಟಿಸ್ ರಿಪ್ಲೈ ಮಾಡಲಿ ಶೋಕಾಸ್ ನೋಟಿಸ್ ಅಂತ ರಿಪ್ಲೈ ಮಾಡಲಿ ಪಾಸ್.
You advise the other peer that if his property is being encroached, his remedy lies elsewhere, and we have granted approval for a specific property, not in respect of 144/2. If I record a finding that the documents that you have furnished relates to only section number 144 and not 144/2, then your entire notice is banned.
ಎಸ್ ಬಟ್ ಅಲ್ಲಿ ಏನಾಗಿದೆ ನಮ್ಮ PDO ನಾನು ಪರ್ಸನಲ್ ಆಗಿ ಏನಂತ ಹೇಳಿದ್ರು, ಸ್ಪಾಟಿಗೆ ಹೋದಾಗ ಇವ್ರು ಕಟ್ತಕ್ಕಂತ ಏನ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ನಡೀತಾ ಇದಾರೆ ಆ ಜಾಗ ದಾದಾಪುರದೆ ಅಂತ ಅಲ್ಲಿ ಸ್ಪಾಟ್ ಇನ್ಸ್ಪೆಕ್ಷನ್ ಕೂಡ ಮಾಡಿದ್ದಾರೆ.
So PDO now is
ಅಲ್ಲಲ್ಲ
principal district judge of that area. ಯಾಕಿದೆ
ಅವ್ರು ಹೇಳ್ತಿದ್ದಾರೆ ಲಕ್ಷ್ಮಿ ಯಾಕಂದ್ರೆ ಅವ್ರ ಜಾಗದಲ್ಲಿ ಇವ್ರು ಕಟ್ತಾ ಇದಾರೆ ಅಂತ. ನಾನು ಅದೇನು ಡಿಸೈಡ್ ಐ ಕಾಂಟ್ ಡಿಸೈಡ್ ಇಟ್.
Dated 22/1. The notice predates the survey. Next R5.
ಇದೆಲ್ಲ ರೆಕಾರ್ಡ್ ಮಾಡ್ಲಾ? ಮಾಡಿದ್ರೆ ಮಾಡ್ತೀನಿ, ಮಾಡ್ಬಿಟ್ಟು PDO ಮೇಲೆ ಒಂದು 5 ಲಕ್ಷ ಹಾಕೊಂಡ್ರೆ ಹಾಕ್ತೀನಿ, ನನ್ಗೇನು. ಅಟ್ಲೀಸ್ಟ್ ನಿಮ್ಗೊಂದು ಫೀಸ್ ಬರುತ್ತೆ, ಒಂದು ಅಪೀಲ್ ಹಾಕಿ ಎಲ್ಲ ಹಾಕಿ. ಅಲ್ಲ what should I do then?
ಅಲ್ಲ ಬಟ್ ಇಲ್ಲಿ ಏನಾಗಿದೆ ಲಕ್ಷ್ಮಿ, ಇಲ್ಲಿ ಸರ್ವೆ ಬಂದ್ ರಿಪೋರ್ಟ್ ಬೇಸಿಸ್ ಮೇಲೆ PDO ಮಾಡಿದ್ದಾರೆ ಬಿಟ್ಟು PDO ವಾಲಂಟರಿ
is pointing out that even before the survey was conducted, is issued the notice. So the survey is also got up document now. Locally, if the PDO says something, will the surveyor go against him? I will record that statement if this is correct.
ಸಿವಿಲ್ ಕೋರ್ಟ್ಗೆ ಹೋಗಿ ಅಂತ
ಯಾಕಿದು
ಸಿವಿಲ್ ಕೋರ್ಟ್ ಹೋಗಿ ಇಬ್ರು ಸೇರಿ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಹೋಗಿ ಅಂತ.
The petition is directed against the notice dated 16/1/2025, by which the petitioner has been informed that the approval granted him, the license granted him to construct a building has been withheld since the Panchayat had received a complaint from one Dada Pir Sahab stating that the petitioner was constructing in his survey number, in his land bearing survey number 144/2. The Panchayat has entered appearance and filed objections, contending that there were documents indicating that the construction was in survey number 144/2, and reliance is sought to be placed on a survey sketch prepared by the surveyor to contend that a portion of survey number 144/2 is being encroached. In my view, the approach adopted by the Gram Panchayat is wholly incorrect. If the Panchayat had received a complaint that the petitioner was constructing the structure in a particular land which belonged to the complainant, the appropriate remedy, the appropriate response of the Panchayat ought to have been to inform that person to approach the competent civil court in case his property sought to be encroached. On the basis of a complaint, obviously the Panchayat cannot determine whether there is an encroachment or not, especially when the building license was granted to the land of the petitioner on the premise that it belongs to him. I am therefore of the view that the impugned notice annexure A cannot be sustained, and the same is accordingly quashed. The Panchayat shall inform the complainant that he ought to avail of the appropriate remedy if his land has been encroached upon, and that they had granted the license on the basis of the documents submitted by the petitioner and on the basis of an inspection conducted by it. Writ petition is accordingly allowed.
Number 53, Shri Sanjay.
Or advise ಮಾಡಿದ್ದೇವೆ just don't.
Yes, ma'am.
I'll wait for 1 or 2 cases. ಇದೇ ತರ ರಿಪೀಟ್ ಆಯ್ತು ಅಂದ್ರೆ
ಅಲ್ಲ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಹೋಗಿ ಅಡ್ವೈಸ್
ಅವ್ರ ಪೋಸ್ಟಿಂಗ್ ಎಷ್ಟು ಕಾಸು ಕೊಟ್ಟಿದ್ರು ಅವ್ರ ಕಾಸ್ಟೇ ಕೊಟ್ಬಿಡಕ್ಕಾಗತ್ತೆ. ಅವ್ರಿಗೆ ಹೇಳ್ಬಿಡಿ ಫಸ್ಟ್.
ಮುಂಚೆನೆ ಅಡ್ವೈಸ್ ಮಾಡಿದೆ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಹೋಗ್ಬೋದಲ್ಲ ಅಂತ ಹೇಳಿದೆ ಅವ್ರಿಗೆ. ಬಟ್ ಅವ್ರು ಹೇಳ್ತಾರೆ ಅಲ್ಲಿ ಪೊಲಿಟಿಕಲ್ ರೈಲ್ವಲ್ ಆಗ್ಬಿಟ್ಟು ಏನ್ ಮಾಡ್ತಾರೆ ನೀವು ಅವ್ರಿಗೆ ಅಲ್ಲಿ
ಇವಾಗ ಇದೊಂದು ಆರ್ಡರ್ ಬೇರೆ ಆಗುತ್ತೆ 5 ಲಕ್ಷ 3 ಲಕ್ಷ. ಸೊ ಹುಷಾರ್ಗಾರ ಕೇಳಿ ಅವ್ರು.
53.
Where's Yogesh? He was here.
Document I like.
ನಾನು ಅವ್ರು ಇಲ್ದಿದ್ರೆ ನೀವ್ ಏನ್ ಮಾಡಿದ್ರು ಅಷ್ಟೇ ತಾನೆ.
Already what they have done. Based on what
ಅವ್ರು ಕರ್ಕೊಂಡ್ ಬನ್ನಿ. I think he is in some other court. Get him at 4:30 or I'll have to some other day.
And then criminal case later, because they're not able to deliver the property to subsequent.
Pass it.
Seal number 61, please. Samir Sharma.
What are you challenging?
The OC that I'm challenging is a condition A, page 22.
You are seeking for quashing of bylaw 12 and 13.
So far as the model bylaws are concerned, because my position, the Gram Panchayat has no power to issue an OC because the parent act, which is the Transcribing Act, provides for no such power at all.
The power to regulate the buildings does not include the power to occupy.
That is only so far as erection of buildings is concerned. Now, so far as erection of buildings is concerned, it's a particular provision. And then subsequently under section 315 also there is a provision only so far as erection of buildings is concerned. Now, pursuant to section 64, in 1984 there was the erection of building rules that were enacted. Now, those rules which are produced in the petition also pertain only in so far as erection of building, granting building license is concerned. Now, those rules would repeat in 2015 when these model bylaws were brought into force. What was not there in the 1994 rules, they have introduced the model bylaws now, which is to issue an OC, issue a completion certificate, all of those things. Therefore,
No, if they have the power to grant permission to erect buildings. Suppose you don't construct the buildings in accordance with that particular license that is granted. Yet you can go and occupy because they have no power. Express power complaint under section 64. Is that your argument?
Section 64, the ambit is very clear. Even under the 1994 rules, if I just point out the argument.
No, I don't want the 94 rules. Let us read section 64.
Please. Not conduct of. It is in the Gram Swaraj and Panchayat Raj Act.
Section 64.
64, regulation of erection of building. Subject to such rules as may be prescribed, no person shall erect any building or alter or add to any existing building, or erect advertisement, hoarding, or set up mobile towers atop or alongside or in any vacant space within the premises, or reconstruct any building without the written permission of the Gram Panchayat. The permission may be granted on the basis of the and so forth. Then your Lordship may kindly see subsection 2, if the Gram Panchayat does not within 60 days from the receipt of application determine whether such permission should be given or not, and communicate its intention to the applicant, such permission should be deemed to have been given and the applicant may proceed. That's a deeming provision. Subsection 3, whenever any building is erected, added or reconstructed without any permission or in any manner contrary to the rules, under subsection 1 or any condition before the permission granted, Gram Panchayat may, whether any action is taken or not against such person under section 298, direct the building alteration or addition be stopped. So therefore, this answers your Lordship's question. Whatever, if it is not in compliance, this provision takes care of it.
64 says subject to the rules prescribed.
If those rules, your Lordship may now see, are produced in the petition, Lordship may kindly come to Annex D, page 68.
So these are the rules that are now in force.
Yeah, I'll just explain. This was the stand to until 20. 68, your Lordship may kindly see. Whereas the draft of Karnataka Procedural Gram Panchayat control over the election of 1984, notification forms for petition, inviting objection forms. Now, Lordship may turn to page 69. Now, therefore, in exercise of powers conferred in subsection 1 of 64, and so related section 311 of the said Act, Government of Karnataka hereby make the following rules. Lordship may see these rules contain only eight provisions. Everything pertains only so far as grant of permission is concerned.
So they can't improve upon that?
There is sufficiently. What is not permitted in the parent act?
Is it barred under the parent act? The substantive provision simply says that as per the rules prescribed, the rules are left to the discretion of the delegated legislative.
My respect, so far as delegated legislation is concerned, certain substantive rights are created by virtue of grant or non-grant of the OC admittedly because, for example, if the OC is before time or after time is in 2017, the decision can be made whether DERA applies or not. So there are certain substantive aspects or implications that flow from it. Now, I have written to the Honorable Supreme Court which says what the parent act does not allow you to do substantive.
You're right. The parent act does it not, does it bar the panchayat from saying no OC is required? Does it say that the panchayat cannot issue an OC? That is too extreme.
There is no word called an occupancy certificate mentioning.
It doesn't have to be. It comes within the power to regulate the construction of buildings. Regulation also includes, after the building is complete, permitting you to occupy.
Not the Gram Panchayat. I have no difficulty. In fact, if I may say candidly, in fact, like self-vote, I am challenging the OC in the apartment in which I live. But what I'm saying is, the Gram Panchayat has no power to do so under the main parent statute as well as the delegated legislation. In fact, this power may lie elsewhere. In fact, the respondent number 3, for example, is Bayappa. They can consider doing something, and I'll show judgment to the lordship wherein it says when substantive rights are not created by virtue of the parent statute, such substantive rights cannot be delegated and created in the delegated.
There is nothing delegated. The act simply says panchayat has the power to regulate buildings in accordance with the rules that are prescribed. The rules prescribe the manner in which they should consider your application, the manner in which they verify whether the building is constructed in accordance with the permission granted, and thereafter permit you to occupy.
Can I take your section 315 for a moment? The power of Gram Panchayat to make bylaw. It is culled out with some level of specificity as to what they can and they cannot do. Lordship may kindly come to 315 clause 1 subclause P.
Three one five
315 clause 1 subclause P. P for Portuguese.
Yes.
Regulating the erection or use of buildings or private or public subject to rules. That is all.
Regulating includes.
It cannot, this broad definition cannot be able to include this.
I will disagree with you.
In fact, I just point, I appreciate what is following. Can I now take the model bylaws from you? Because if what stands repealed is replaced by something else, then what replaces something that is repealed also must cover the same.
How?
Because they are tracing their power from the same provisions.
Not necessarily. They can always improve upon the rules. Suppose they find there's a defect in the earlier rules. Are you saying that once a rule is framed forever, for eternity, they should be the same rules? They can't learn from experience?
They can elaborate. My respectful submission, they can't go
No,
beyond.
this argument will apply only if I accept your first argument that the substantive provision does not allow the question of that time against you. Today, I'll take a call right now. I don't think you can. As to what manner the rule should prescribe building regulation can't really be the subject matter of challenge. They are the experts. They decide as to how they want to regulate a building. Unless there's something, some competence issue, I don't think you can challenge it at all. Suppose they say it should be X amount, X meters. You come back and say that substantive provision does not say X meters, therefore it is bad.
I understand. The statute has categorically provided what the Gram Panchayat can do, cannot do. For example, let us take for a moment the collection of taxes. Section 191 of the Gram Panchayat specifically says the Gram Panchayat can collect taxes. Pursuant thereto, Khata is issued and taxes assessed and I pay taxes and that is fine. Now, in so far as OC is concerned, my respectful submission on this pass this on. What the parents did is not substantively correct. Now, my respectful submission, in fact,
You are I didn't see this. You are challenging the occupancy certificate granted to respondent number 2.
granted by respondent number 2.
No, granted by
Karnataka Gram
to some other authority.
by virtue of them being the developers.
And on occupancy certificate of the year 2015, you are questioning.
Why I have come before and just before adverting that I just take a logic and logic kindly come to para 18. Sorry, to para 18 page 23. Para 18 page 23. It is but obvious that grant or non-grant of occupancy certificate creates substantial.
Where are you reading? Page?
Page 53 of the petition.
Who are you
And your
in that developer? And if the OC goes, then you can't stay there.
My primary grievance was the fact that the OC that was granted, there was no inspection that took place. There was nothing needful that was done by the Karnataka Gram Panchayat as was initially required by the 2015 bylaws. Now, evidently speaking, as on date, there are various amenities in the project that are not complete. So then I wondered as to how an occupancy certificate could have been granted when various things in the project are not in the modified development plan. Then, of course, I have not.
Basically, you want to use this writ petition to get those things done.
I want to say that my respectful submission.
That's the real truth, isn't it?
Evidently speaking, various amenities are not complied with. They are not in compliance with the modified development. In fact, document 20C, the OC was granted in 2015. The builders procure a modified development plan 2020. The cart is before the horse. That is one aspect that the Lordship may kindly consider. My respectful submission is there is a judgment of the Honorable Madras Court which says that if the amenities are deemed to be complete, they must be complete in all respects. My submission is car parks are not done, civic spaces are not provided. There is a maintenance building they say they will provide for the occupants, but it's instead used for.
So you are basically admitting that your occupation is illegal.
I am not admitting that the occupation is illegal. What I'm
So if the OC was incorrectly given,
therefore my consequence is if the OC goes, then a proper OC ought to be granted by the Karnataka Gram Panchayat by conducting an inspection, because that is what the law mandates. In fact.
so suppose the Panchayat says you have not followed this. So your occupation till now.
Paying property tax. Tata is in mind. It's a domino effect, I understand. But if I were to not convince your Lordship insofar as the model building bylaws are concerned, at least insofar as the OC is concerned, a direction will be passed to the Karnataka Gram Panchayat to conduct an inspection, see if the project is complete in all respects or not. That has not been done immediately. In fact, if the Lordship to see.
See, if the Panchayat now, after 10 years, were to say that this has not been done, at this point of time, what is it that can be done?
The builders ought to set right what is.
So therefore, the petition is basically filed to ensure that they discharge their obligations that they had promised you. Why don't you go to the consumer forum?
Compensation is concerned. Now that is monetary compensation. My grievance insofar as the faulty OC is that tomorrow the saleability of my plot will come into question because the prospective purchaser will say, who has given this OC? Is it valid or not? And in order to address.
You should have asked that question when you purchase the property, isn't it? You should have asked that question when you purchase the property.
And I purchased, in fact, I made my petition amendments to say, my sale was in the year 2017. It took me time to understand what is happening. In 2020, the modified development.
Gave attempt, or you should have been careful, isn't it?
I understand. But at the same time.
There is some other reason behind this.
I'm being as candid as possible. In fact, I have stated in my petition as to what are the grievances and what are the lack of amenities that is there. And in addition to this, the OC that is granted, if I were to not convince your lordship insofar as the validity of the model building bylaw is concerned, I would restrict my prayer only insofar as the OC is concerned. Let the OC be set aside, let the direction be passed with the respondent number 2 to conduct an inspection. An inspection is not an effect as per schedule 5, which I am seeking forward at the lordship hand. That says that competent officer from the Gram Panchayat must inspect the property. He must see whether it is in compliance with the modified development plan or the plan set. They take a call. That has not been done here. So therefore, at least so far as that is concerned, some limited reprieve I'm seeking at the lordship.
Now, after 10 years,
No, in fact,
now this is the first case that I'm seeing that like you're a purchaser of a property on the basis of this OC.
Yes.
And you're now filing a writ petition for quashing of that very OC.
washing of the OC
And if they don't approve it, your purchase would per se be, you can't occupy it. You will have purchased a building which can't be occupied.
In fact, if you look at provisions of the RERA, it is the onus on the builder to obtain.
Now, this is much before RERA, right?
Now, again, if this OC goes, RERA becomes applicable because.
Hence. You know, you want to twist their arm using this petition.
In fact, I have certain rights, they are not being given. Grant or non-grant of the OC substantially affects me.
You think if I issue notice, they'll settle your dispute?
There is no compensation that should be given, but
No,
at least,
your grievances, are they solvable? Or are
They are
they just an ego clash between you and the developer? What is the amenities that you want to be?
lordship may kindly come to page 9.
These are all rich people's problems, right? So I think there's a better way of solving this.
Page number 9. Paragraph number 10, I have denoted the summary of the said deficiencies and shortcomings detailed RSCL. The R parts which they author provided are not taken. Provision of parts is denoted in the said plan which pertains to specified spaces. They are only partially protected.
ನೀವಿದ್ದೀರಾ ದೇವರಾಜ್ ಇದ್ರಲ್ಲಿ?
ಪಂಚಾಯತ್ ಆಕ್ಚುಲಿ 2017 ನಲ್ಲಿ ಪರ್ಚೇಸ್ ಮಾಡಿರ್ಬೇಕು 2015 ಕೇಳ್ತಾ ಆಕ್ಚುಲಿ 17 ನಲ್ಲಿ ಪರ್ಚೇಸ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ವಿಲ್ಲಾಗಳು ನೋಡಿ ಎಲ್ಲ ಇದನ್ನ ವೆರಿಫೈ ಮಾಡ್ಬೋದಾಗಿತ್ತಲ್ಲ.
In fact, if you are also to see para 11, the petitioner and like-minded residents of the project began giving further consideration.
ವಿತೌಟ್ ಪ್ರಾವಿಷನ್ ಒಂದ್ಸತಿ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿದ್ರೆ ಪ್ರಾವಿಷನ್ ಇಲ್ಲ, ಒಂದ್ಸತಿ ಓಸಿ ಕೊಟ್ಟಾದ್ಮೇಲೆ.
ಇಲ್ಲ ಇವ್ರ ನಿಜವಾದ ಏನಾದ್ರು ಪ್ರಾಬ್ಲಮ್ ಇದೆಯಾ? ಇವ್ರು ಏನಾದ್ರು ನೋಟಿಸ್ ಮಾಡಿದ್ರೆ ಅವರು ಇವ್ರು ಕೆಲಸ ಮಾಡ್ಕೊಡ್ತಾರೆ ಅಂತ ಒಂದೇ ನಂಗೆ ಇರೋದು. I'm convinced that this is a case for dismissal. I'm convinced it's a case for dismissal. The only thing that is running in my mind is whether there are real grievances of yours which can be solved if I issue notice to them. That is all.
Parties will have to take action on respondent to and make them part. Notice code, they may take cognizance of it.
But that we giving you that lever to.
That may not be the case. In fact, I may be convinced through the interest how my first prayer also survives, but not inclined today. Check my sentence, only so far as OCs.
No, that second prayer, I'll simply say that it's belated. Challenge after 10 years.
Now, with regard to that, I just want to as to why I have come to my made petition amendment as to why. Particular DC section, para 11. It is submitted that the above being the case, the petitioner and other like-minded residents in the project began to make further consideration in the project. She reports short-term leadership, decided to the aforementioned plan. Further of the same, the petitioner began unearthing various aspects in relation to the project. It became apparent that the include those who were issued well before the aforesaid plan was issued. It is submitted that upon having come to the law of the same, the petitioner began further examining the significant correctness of the provisions. Now, you are not to please see page 27. I have stated the fact that the modified development plan comes in 2020. Now, the actual grievance I have is modified development plan says you have to do A, but what they have actually given me is B. So therefore, there's no complaint with the modified development plan.
No, but the modified plan is after you purchase the property, isn't it?
What is the?
No, the modified plan does not affect the purchase of yours.
It does not affect the purchase.
So what is the modification granted?
So far as the modified development plan.
Maybe there was some other piece of property there and they are permitted to use that.
No. what had happened was initially the plan had come in 2007, that I am not privy to the lordship directly. 2007, the original plan comes. OC is granted in 2015. Sale deed is granted is executed in 2017. 2020, they make modifications. Now, my grievance.
What is the modification that was made?
Various provisions which are stated over here, car parks, civic amenities, maintenance building, which never found mentioned in the earlier plan, they find mentioned now. But in reality, when they find mentioned in the 2020 plan, that is not given, that is not actuated on the ground. I think my grievance. So therefore, the construction.
Are you trying to implement the modified plan or I don't understand this. You're questioning the OC given pursuant to the first plan.
My respectful submission.
There's a modified plan in the year 2020. Now, haven't they given an OC for that modified plan? Maybe they have not finished the work yet.
Your Lordship, they themselves claim in the improved OC that there are 226 villas. As on date, there is 206 villas. The builder has formed an association and has exited. Builder is nowhere in the picture at this point. So therefore,
They no sought for modification.
the builder themselves, in 2020, Lordship kindly see the modified development plan have produced at next year F.
Produce those two plans, let us see.
The original plan.
The original plan and the modified plan.
That is at next year F.
What is the difference according to you?
That I will just highlight, I am not highlighted in my petition. I just highlight it.
Monday.
Number 62, Sri Muniappa.
What is the answer?
Yes, my lordship. Even state has to say because BBMP police are troubling.
Kaveri as a. Survey la ಮಾಡಿದ್ದಾರೆ ಅದು.
Recently survey was going on.
Accept notice for respond number 1 and 2. Power Kumar 1, 2, 4. ಇವರು ಒಪ್ಪೆ ಆಗ್ತಿಲ್ವಾ R5 ಯಾರದು ಪವನ್ ಕುಮಾರ್ accepts notice for R3. Issue notice to R5 and R6. ಏನ್ ಎಂಟ್ರಿ ಮಾಡಿ ರಿಲಿಸ್ಟ್ ಆನ್ ಗೆಟ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ರಾವ್
ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ದಾರೆ
ರಿಲಿಸ್ಟ್ ಕೊಡಿ ಇನ್ನೊಂದು ಕಾಪಿ
ಗವರ್ಮೆಂಟ್ಗೆ ಕಾಪಿ ಕೊಡಿ
ಕೊಡಿ ಇನ್ನೊಂದು ಕಾಪಿ ಕೊಡಿ ಅವ್ರಿಗೆ
ಕಾಪಿ ಇಲ್ಲ ಫೈಲ್ ಇಲ್ಲ 27
ಅವ್ರು ಕೇಳ್ಬಿಟ್ಟು ಮಾಡ್ತೀನಿ
ಕಾಪಿ ಕೊಡಿ ಸರ್ ಮಂಡೇ ನಾ ಮಾಡಿ
ಅವ್ರು ಕೇಳ್ಬಿಟ್ಟು ಮಾಡ್ತೀನಿ.
Number 63, Sri Naveen Jain.
ಆಗುತ್ತೆ ಮಾಡಿ ಯೂಸ್ಟ್
ಕಾಪಿ ಕೊಡಿ.
Respondent gave it. Page 28, Lordship, the public auction tender was invited. Respect of the shops belongs to the municipality. Your Lordship may come to page 29, Your Lordship. Page 29, the last Lordship, Vandane Mahadi antide, shops number 1 to 17, the bid amount is 3,100 rupees, Your Lordship. Security deposit is 1,03,000. Also, I have participated in the tender, Your Lordship. We are the successful bidders. Lordship may come to page 33. 3,500 ge madidare. Page 33. Yes. Lordship, bid amount is 3,100. So we have successful bidders for 3,500, Your Lordship. Lordship, the municipality wrote a letter to the DC, page 34, Your Lordship. Last paragraph ಅಲ್ಲಿ ಮುಂದುವರೆದು ಈ ಕೆಳಕಂಡ ಅಂಗಡಿ ಮಳಿಗೆಗಳು ಕಳೆದ ಹರಾಜಿನ ಅಂತಿಮ ಬಿಡ್ಡಿನ ಮೊತ್ತಕ್ಕಿಂತ ಕಡಿಮೆ ಬಿಡ್ ಮಾಡುವುದರಿಂದ ಪುರಸಭೆಗೆ ಆರ್ಥಿಕ ಆದಾಯ ನಷ್ಟ ಉಂಟಾಗಿರುವುದರಿಂದ ಈ ಬಗ್ಗೆ ಏಕರೂಪಕ್ಕೆ ಒಂದೇ ಮೊತ್ತಕ್ಕೆ ಅಂತಿಮ ಬಿಡ್ಡು ಮಾಡುವುದರಿಂದ ಅಂಗಡಿ ಮಳಿಗೆಗಳ ಹರಾಜು ಬಿಡ್ಡನ್ನು ರದ್ದುಪಡಿಸಿ ಮಳಿಗೆಗಳ ಕಾಯ್ದೆಯ ಪ್ರಕಾರ ಸದರಿ ಮಳಿಗೆ ಮರು ಹರಾಜು ನೀಡುವ ಅನುಮತಿ ತಮ್ಮಲ್ಲಿ ಕೋರಿದೆ. Lordship, again, the deputy commissioner has given a permission, measure E, page 40, Your Lordship.
To re-auction.
For reaction, not only, Lordship, it is reaction only in respect of the shops, Lordship, belongs to the petitioners, not in respect of the entire Lordship, the entire procedure.
First floor ಮಾತ್ರ.
First floor matter, first floor, their reasoning is, Madam, first floor, it is only meant for Madam, the advocates. All the petitioners are advocates. ಅದು 3,100 ಫಿಕ್ಸ್ ಮಾಡಿದ್ದಾರೆ, 3,500 ನಾವು ಹೋಗಿದ್ದೀವಿ. ಕೆಳಗಡೆ ಕಮರ್ಷಿಯಲ್ ಶಾಪ್ಸ್ 30, 40, 50 ಸಾವಿರಕ್ಕೆ ಹೋಗಿದೆ. ಇವ್ರು ಹೇಳೋದು ಅಡ್ವೊಕೇಟ್ ಶಾಪ್ಸ್ನು ಅಷ್ಟಕ್ಕೆ ಮಾಡ್ಬೇಕು ಅಂತೇಳಿ ಇವ್ರು.
ಅಲ್ಲ ನಿಮ್ ಕಂಡ್ರೆ ಭಯ ಅಂತ, ಅಲ್ಲಿ ಕೊಟ್ರೆ ನೀವು
ಖಾಲಿ ಮಾಡ್ಬೇಕು ಅಂತ ಅಲ್ಲಿಂದ ಇರಬಾರ್ದು ಅಂತ.
ಅಲ್ಲಿ ಅಲ್ಲ, ಅದು ಇವನ್ ಸಬ್ಲೀಸ್ಗೆ ಕೂಡ ಕೊಟ್ಟಿದ್ದಾರೆ ಅವರು ಫಾರ್ ನೇಮ್ ಸೆಕ್ ಓನ್ಲಿ. ಪ್ರೀವಿಯಸ್ ಇಯರ್ಸ್ ರೆಂಟ್ 4,700. ಇದು ಅದಕ್ಕಿಂತ ಕಮ್ಮಿ ಮಾಡಿ 4-5 ಶಾಪ್ಸಿಗೆ 3,500 ಎಲ್ಲ ಶಾಪ್ಸಿಗೆ ಅವರೇ ಒಂದು ಫಿಕ್ಸ್ ಮಾಡಿ 4,700 ರೆಂಟ್ ಲಾಸ್ಟ್ ರೆಂಟ್. ಸೊ ಇವಾಗ ಬಹಳ ಕಡಿಮೆ
ಫಿಕ್ಸ್ ಮಾಡಿರೋದೇ 3,000.
ಕಡಿಮೆ ದರದಲ್ಲಿ ಅಲ್ಲ,
ಅವ್ರು ಫಿಕ್ಸ್ ಮಾಡಿರೋ
ಉಳಿದ ಶಾಪ್ಗಳು ಇವನ್ ಸೆಕೆಂಡ್ ಫ್ಲೋರ್ ನಾವು 21-2ಗೆ ರೀ ಟೆಂಡರ್ ಕರೆದಿದ್ದೀವಿ.
ಎಷ್ಟು ಬೇಕು ನಿಮ್ಗೆ? ವಾಟ್ ಇಸ್ ಯುವರ್ ಎಕ್ಸ್ಪೆಕ್ಟೇಷನ್?
ಅಟ್ ಲೀಸ್ಟ್ ಮೋರ್ ದೆನ್ 5,000 ಒಂದು
5,000 ಮೇಲೆ
5,000 ಅಂದ್ರೆ
ಅಲ್ಲ, ಇವನ್ ಮೂರು
ಅವ್ರು ಕೇಳ್ತಾರದು 20,000 ಚಿಲ್ಲರೆ ಕೇಳ್ತಾರೆ.
20,000 ಅಲ್ಲ, ಅವರಿಗೆ ಕೆಲವೆಲ್ಲ 10,000.
5,000 ಅಂದ್ರೆ ಐ ವಿಲ್ ಸೆಕ್ಯೂರ್.
ಅಲ್ಲ, ಅವ್ರನ್ನ ಕೇಳ್ಬಿಟ್ಟು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೊಂಡ್ರೆ ಐ ವಿಲ್ ಕನ್ಸಲ್ಟ್.
ಮಂಡೇ ಈಗ ಏನಂದ್ರೆ
ಲಾಯರ್ಗಳು ನೀವು ಸ್ವಲ್ಪ ಬಿ
ಅಲ್ಲ, ನನ್ನ ಇದರಿಂದ ಹೇಳಿ ನಾನು ಐ ವಿಲ್ ಆಸ್ಕ್ ಸೆಕೆಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್
ಮಂಡೇ
ಟ್ಯೂಸ್ಡೇ.
For hearing on case number 64.
Scared the appellant, my lord. Please, my lord, I want 2 weeks time, my lord. In this case, my lord, what happened that impleading application and the family members created forgery document based on that, my lord. By yesterday, I got your document, my lord.
I adjourned it.
Please, 2 weeks time may be granted, please, my lord.
Number 65.
Hearing for the petitioner in this case. No, the respondent one had executed a lease deed in my favor for a period of 10 years, my lord. Swimming pool real lease deed.
Yes.
And at the expiry of the lease deed, he issued a notice for repayment, my lord. Lord, at the time of the expiry, the COVID had started. And moreover, in the entire lease period, 2 years of the entire lease period was taken away by him for construction. By the respondent.
I heard it once.
Yes.
Yes, my lord, you had heard it once.
I have filed a memo for memo of calculation, my lords. In that, we have given concession for both repair as well as COVID-19 period. Concession, I have filed it on 2nd February 2023, my lords. 2nd February 2024, my lords. 24, my lords. Page 2, my lords.
You not paid anything from, you not paid for 27-28?
My lords, lease was for the period of 10 years, my lords. From 31/7. From 1/8/2010 to 31/7/2020, my lords. My lords, he has not paid from 2017 onwards, my lords. He says that there was a repair work was going on. So,
17-18.
Yes, my lord. The repair, for 2 years, I was not able to use the pool.
17, 18 and 19, huh?
yes, my lord.
Yes, my lord.
1/8/2017.
18, there was repair work.
Yes, my
Yes, my
lords. For the, my lords, 1/8/2017 to 31/7/2018 was he was supposed to, it was his 7th installment, my lords, and he was supposed to pay 1,16,89,926. In this period, my lords, there are 4 months demand we have 4 months we have demanded, my lords. 4 months he has worked. 8 months it was not working.
From 1/8/16 to 31/7. That is the 7th year.
Yes, my lords. In remarks,
8/12/2017 to 27/2/2019. That is where the repair works were going on.
This 7th year that issue, 7ನೇ ವರ್ಷ. You have said to be paid as per agreement 16 lakhs 9,454. You said contractor has not paid anything.
Yes,
So
my
the
lord.
entire amount is not paid for 17-18,
No, my lords, has not paid.
16-17.
Yes, my lords. 17-18, my lords.
17-18 it was, repair was.
Repair work was going on, my
It
lords.
doesn't have to pay that.
Yes, my lords.
Then-
Again, 18-19 also repair works were going.
18-19, 7 months he has worked, my lords. For total demand was for 5 months, my lords. Other period he has not worked. The repair work was going on. Only that period amount we are asking, my lords.
And later was COVID, my lord.
In COVID period, we have given concession, my lords.
But you have not paid even for 13th year, 2020 to 23, you have not paid.
It was supposed to end at in the year 2020, my lords. 10 year has over, my lords. He has not paid. He has filed his writ petition and taken interim order. By virtue of interim order, still he is working, my lords. It was extended to another 3 years, my lords. He was supposed to hand over the swimming pool
It
to
was 2
corporation.
years. My lord, since the repair work was for 2 years, for that reason I had extended, my lord. I wasn't able to work then, that is
But
the
if you
reason.
don't
I've
pay
been
the
used.
rents for 17-18 before the COVID, what is your justification?
My lord, I have paid at the time of interim order, till now I have paid 35 lakhs.
No, you're doing like as if you're doing us a favor.
17.
No, my lord.
18, there was no problem for you. It was, the swimming pool was
16,
functional.
My lord, from 2014 onwards, the swimming pool was not functioning properly. In fact,
What do you mean not properly?
few of the filtration unit was not working properly. I had reported to them. It was not working properly. Later is when mayor came for an inspection, then they started repairing the swimming pool. That is when the repair happened, and then I started working.
How much is total amount, do you know?
My lords, as per this, my lords, balance amount to be paid by the contractor is 61,88,839. He is supposed to pay. My
How much
lords.
has he paid pursuant to the interim order now?
35 lakhs.
My lords,
35 lakhs.
Have you taken that into consideration?
yes, my lords. Whatever he has paid, we have taken that for consideration. Balance amount only.
No, after he filed the writ petition, have you taken that into consideration?
Yes, my lord. He has, by virtue of interim order, he has paid around 20 lakhs, my lords. And that amount we have taken for consideration, and only balance amount we have.
Where have you shown that he has, you've taken that into consideration?
My lords, total amount to be paid as per 10 years, my lords, 1 crore
No,
63
he
lakh.
filed the petition when?
2021.
21.
No, that 35 lakhs which I have paid is not taken into consideration, my lord. In the memo of calculation, at the time of interim order that had to be granted, I paid 20 lakhs. That is not considered.
There is 120 lakhs here.
My lords, that we have shown at page 3, my lords, 1/8/2021 to 31/7/2022, 12ನೇ ವರ್ಷ.
Yeah, 20 lakhs ತೋರಿಸಿದೆ.
10 lakh.
20.
Contract paid 20 lakhs.
You've taken that
The
into
interim,
consideration.
yes, my lords.
And after that, again, I have paid in 2024, my lord, in July,
How much?
15 lakhs.
So 70 minus 15 is roughly, you still owe them a lot of money.
Yes, my lord. No, they have not considered my advance also, 12 lakhs in the beginning.
So are you prepared to vacate now?
My lord, I need some time to vacate, my lord.
You-
I've already made the preparation for the summer, once that is completed, I'll vacate.
My lord,
Clear the arrears, then I'll consider.
Fine, my lord, I'll have it cleared.
My lords, no, my
Some
lords,
time may
as
be
per the-
given, my lord.
Please first get your arrears, then let us see.
My lord, if I have to see the balance also, my lord, I understand there is some amount which I have to pay. I will pay. I'm not,
Clear the arrears, agree to pay the balance. If you want, let's say 6 months. If you're prepared to pay the 6 months in advance, I'll consider granting you some time. Or else I'll dismiss the petition.
my lord, it may be posted in next week, my lord. I'll take instructions and I'll let you know
my
when I
lords,
can.
what
pay.
happened, my lord? This agreement was only for the period of 10 years, my lords.
Madam,
He has to
ಸುಮ್ನೆ
vacate
ಕೂತಿದ್ರೆ
and,
ಕಾಸು ಬೇಡವಾ?
my lords,
ಕಾಸು ಬರ್ಲಿ ಸುಮ್ಮನೆ ಆಮೇಲೆ ನೋಡೋಣ.
oblige, my lords.
If you don't clear the arrears, you will not get any order.
No, my lord, I'll clear the arrears, sir. Clear the-
Next day,
18th.
18th. and I request for 20th, my lords.
Why do you want time? Let us see what he will say.
I have more matters.
My lord, also one submission, my lord. The counsel for the respondent may submit as to what is the amount that I'm supposed to pay. Completely.
Given the
No,
memo,
as per the memo of calculation, I'll be deducting 15 lakhs again.
Once
Which
verify
total amount for as per interim order was 20 lakhs, my lords.
He says he paid a further sum of
I
15
paid
lakhs.
again 15 lakhs.
Get instructions as to what is exact amount.
Obliged, my lords. May I request for 20th, my lords.
Your choice.
20th. Silver 66.
Petitioner, rejoinder ಹಾಕಿದ್ದೀವಿ. My lord, sorry, ಹಾಕ್ತಾ ಇದೀವ. My lord, we are filing a rejoinder. What happened was they sent, my lord, the objection through email, I believe. We didn't notice it. Only last week we noticed it and, my lord. Copy, we have served it on the junior, my lord.
I have received the copy today, my lords.
Yes. Ready na?
Maybe next week, my lords.
Please.
21st.
Huh?
21st.
21st.
My lords, 19th, may I request for 19th, please, my lords?
19th.
19th or 25th, please, my lords.
Fifth hour, 19th, ಇನ್ನೊಂದು ಎರಡು ಪಾರ್ಟ್ ಥರ್ಡ್ ಇದೆ. I don't want to, my lord. 25th ಅಂತ ಏನೋ ಹೇಳಿದ್ರು ಅವರು.
25th.
Interim order to be extended.
Obliged, please.
Silver 67. Shri K. Sridhar.
Filing statement of objection. Kodi, copy.
And for respondent number 4, my lord.
ನೋಡ್ಬೇಕಾ?
ನೋಡ್ಬೇಕು. ಏನಂದ್ರೆ ಇದು notification issued, treating a village as a urban land.
Objections are filed by the fourth respondent.
Date ಕೊಡಿ.
The respondents 1 to 3. The list.
21st.
21st.
Silver 68.
Kindly have it on Monday, my lord.
The list.
Interim order may be extended. Obliged.
Silver 69. Shri Prakash MS.
Lord, I appear for the respondent.
2-4.
Petition.
Lord, on the last date, your lordships had directed me to intimate the concerned engineers. And petitioner, my lord, was directed to implead all those engineers also before your lordships. Lord, accordingly, my lord, I have already intimated the concerned engineers. I can produce this particular report also.
Finish ಮಾಡಿದ್ದೀರಾ?
ಮಾಡಿದ್ದೀನಿ.
There's no clearance on their behalf?
ಯಾರು ಬಂದಂಗಿಲ್ಲ ಅಂತ ಅನ್ಕೊಳ್ತೀನಿ. ಲಾಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ ಬಂದಿದ್ರು, ಏನೋ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಆಯ್ತು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಹೊರಟೋಗಿದ್ದಾರೆ. ಆಮೇಲೆ ಪ್ರಾಬಬ್ಲಿ ದೇ ಆರ್ ನಾಟ್ ಅವೇರ್ ಆಫ್ ಇಟ್. ಲೆಟ್ ದಿಸ್ ಅಪ್ಲಿಕೇಶನ್ ಬಿ ಅಲೌಡ್. ಲೆಟ್ ದೆಮ್ ಬಿ ಇಂಪ್ಲೀಡೆಡ್ ಅಂಡ್ ನೋಟಿಸ್ ಬಿ ಆರ್ಡರ್ ಟು ದೆಮ್.
ಇಂಪ್ಲೀಡಿಂಗ್ ಹಾಕಿದ್ದಾರೆ.
ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಅವರೇ ಹಾಕೊಂಡಿದ್ದಾರೆ ಪೆಟಿಷನರ್.
ನಾನು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದು ಅದು ADL
I think
Application ಅವರೇ.
I had ordered their impleadment.
ಅದು ಗೊತ್ತಿಲ್ಲ, ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಅಂತ ಬಂದಂಗಿದೆ.
My lords, suo motu, this honorable court has directed to implead them as parties.
ಐಟಮ್ ನಂಬರ್ 3 ಅಲ್ಲಿ IA 4 of 24 ಫಾರ್ ಇಂಪ್ಲೀಡಿಂಗ್ ಅಂತ ಬಂದಿತ್ತು. ಕಾಪಿ ಏನು ನನ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅಲ್ಲ, ಕಾಸ್ಟ್ ಅಮೆಂಡ್ ಮಾಡಿದ್ದೀರಾ?
ಸರ್
ಕಾಸ್ಟ್ ಅಮೆಂಡ್ ಮಾಡಿದ್ದೀರಾ?
ಅಮೆಂಡ್ ಮಾಡಿದ್ದೀನಿ. ಅಮೆಂಡ್ ಮಾಡಿ ಲಾಸ್ಟ್ ಡೇಟ್ ಬಿಫೋರ್ ಲಾಸ್ಟ್ ಡೇಟ್. Same before the court.
Lord may have the order dated 30th January.
Will you inform them to be present?
I had informed them, that is what, my lord, I have produced the documents also. And they were present on the last date of hearing. But since they took an adjournment, my lord, WhatsApp ಅಲ್ಲೂ ಕಳಿಸಿದ್ದೀನಿ, ಇದರಲ್ಲಿ ಮಾತಾಡಿದ್ದೀನಿ, ಪೋಸ್ಟ್ ಅಲ್ಲೂ ಕಳಿಸಿದ್ದೀನಿ.
The acknowledgement really?
Acknowledgement I'll have to told. I'll produce it in the next day.
United Council BVMP is directed to inform respondent 7 to 10 to be present before the court on.
My lord, as far as we are concerned,
Yes.
my lord, the report clearly shows, my lord, that there is hardly any deviation.
There is?
There is absolutely no deviation, front, back and right. On the left, my lord, it shows there is a deviation of 0.35 meters and total average violation is 8.75%.
Deviation ilva?
It's a B Khata property.
That's correct, that.
100% deviation is the one what we take. One. Secondly, my lord, what had happened was, there was a direction to me to take action against the respondents herein, 5 and 6. Accordingly, my lord, provisional notice and show cause notices were issued. Confirmatory orders were issued. All these things were challenged before your lordships. Lord, this court, my lord, has on the ground that ZC is the person who, zonal commissioner is the person who is authorized to take action and that the notices have been quashed by this court. Once it has been quashed, ಅದು ಮುಂಚೆ ಸ್ಟೇ ಆಗಕ್ಕಿಂತ ಮುಂಚೆ ಈ ಆರ್ಡರ್ ಆಗೋಗಿತ್ತು.
What is he challenging here?
Now, my lord, the neighbor is before your lordship saying that this is an illegal construction. In the meantime, my lord, they have put up construction of this.
Lord, if your
They
lordship
have
sees,
completed the construction.
He does not have a plan.
No plan. It's
Khata.
a B Khata property. They have not applied for any plan. 100% is the deviation what we say.
Yes, Rajesh.
if your lordship sees the order dated 16/1/2025, your lordships had said, learned senior counsel appearing for respondent 5 and 6 submits that the petitioner would ensure that the building has been constructed by him would be brought within the permissible limits as required under the bylaws insofar as setbacks are concerned. Now, my lord, the report dated 29/1/2025, Lord, in page number 2, my lord, shows,
What about the other things?
Lord, the other things is that, my lord, it is a B Khata property, my lord, so they are
Apart
not.
from B Khata.
No, my lord, there is.
FIR, height coverage, everything is all right?
Yes, my lord. Yes, my lord. My lord, your lordship will see their own report. Average violation is 8.75%. 0.8.75%.
Report dated 30th January.
Third, yes, my lord. 29th, it says on
What
it.
is the date? What is the date of
29th
the?
January.
My lord, may I request your lordships to kindly see
29th.
2111 order, 2111 memo filed by me along with the photographs.
Correct, that is after there are.
2111,
No, where is it?
annexure 1.
Setbacks violation ಸರಿ ಮಾಡಿದಾರೆ ಅಂತ ಏನು ಹೇಳಿದಾರಲ್ಲ.
Lord, we have demolished the property. Lord, we have demolished the compound wall and other things, my lord, and brought it.
What is the date that you said just now?
Lord, 16/1/2025 order. Your lordship's order dated
No,
16.
I saw that. Where have they conducted a spot inspection regarding that?
Lord, this is the 29/1/2025.
I don't see anything on 29/1. There's one memo filed on 30th.
Lord, it says report, submission of engineers list, my lord.
ಏನಿದೆಯಾ? I don't have it on my.
My lord, along with the list of engineers, at the back of the page,
31/2025, I filed the list of engineers before your lordships.
the back of that
Prior to that, 21/11/2020.
Yes, along with this, you have given a report regarding
No,
the.
no, no.
Lord,
Where do you get that?
Lord, back of this page, Lord, this is the engineer list. Behind this page, my lord, there is setback report.
I only have the list of
Engineers here.
It says
Oh,
annexure 2.
no, I don't have annexure to it.
But
There's
this
just
is
one.
what they have given me, my lord. Lord, then on next date, I'll be present there. I will show this to your lordship. It is signed by the assistant executive engineer.
May I submit your lordships? 21/11/2024,
ಆದ್ಮೇಲೆ when you file the memo on 30th of January and furnish the list of the engineers on date 29/1, it says behind this.
ಅಲ್ಲಿ ಏನಾಗಿತ್ತು ಅಂದ್ರೆ 31 ಅಲ್ಲಿ ತಮ್ಮ ಡೈರೆಕ್ಷನ್ ಇದ್ದಿದ್ದು ನನಗೆ ಮೆಮೋ ಇಂಜಿನಿಯರ್ಸ್ ಲಿಸ್ಟ್ ಕೊಡಿ ಅಂತ. ಅಕಾರ್ಡಿಂಗ್ಲಿ ದಟ್ ಲಿಸ್ಟ್ ಇಸ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್.
ನೀವು ಹೇಳಿ ಕೇಳಿಸ್ಕೊಳ್ಳಿಲ್ಲ. ಅವ್ರು ಕೊಟ್ಟಿರೋ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ ಇದ್ರ ಹಿಂದ್ಗಡೆ ಯು ಹ್ಯಾವ್ ಸಬ್ಮಿಟೆಡ್ ರಿಪೋರ್ಟ್.
ಇಲ್ಲ, ಆ ತರ ಕೊಟ್ಟಂಗಿಲ್ಲ. ನನ್ನ ಹತ್ರ ಇಲ್ಲ ಆ ರಿಪೋರ್ಟ್. ನನ್ನ ಫೈಲ್ ಅಲ್ಲಿ ಇಲ್ಲ.
ನನ್ನ ಫೈಲ್
ಅವ್ರ ಹತ್ರ ಇದೆಯಂತೆ. ಅದಕ್ಕೆ ನಿಮ್ಮ ಹತ್ರ ಇಲ್ಲ, ನನ್ನ ಹತ್ರ ಇಲ್ಲ, ಅವ್ರ ಹತ್ರ ಇದೆ.
ನನ್ನ ಹತ್ರನೇ ಆ ಫೈಲ್ ಇಲ್ಲ.
ಶೋಯಿಂಗ್ ಇಟ್.
ಎನಿವೇಸ್ ಎಲ್ಲಿಂದ ಅವರೆಲ್ಲಿಂದ ತರಿಸ್ಕೊಟ್ರು.
Signed. Lord, it is signed by.
ನನ್ನ ಹತ್ರನೇ ಇಲ್ಲ, ನಾನೇ ಹಿಡ್ಕೊಂಡಿಲ್ಲ.
No. I'll be present with this.
ನಾನು ಫಸ್ಟ್ 21ನೇ ತಾರೀಕು ತಮ್ಮ ಮುಂದೆ ಒಂದು ಮೆಮೋ ಹಾಕ್ದೆ. ಆ ಮೆಮೋ ರೆಕಾರ್ಡ್ ಮೇಲೆ ತಗೊಂಡು ತಾವು
ಪ್ರೆಸೆಂಟ್ and ask them to verify whether the building that he has put up
yes
is in accordance with the building bylaws first.
ಆಯ್ತು. ಅಲ್ಲ, ಕವರೇಜ್ ಜಾಸ್ತಿ ಇದೆ ಅಂತ, that is what is the report which is already filed.
But
building bylaws ಬಗ್ಗೆ
he has now removed something.
It's only what he has done is the compound wall in the frontage he has pulled it back. ಅಷ್ಟೇ ಮಾಡಿರೋದು.
Ask him to verify.
ಆಯ್ತು.
Relist. And ask him to be present.
ಆಯ್ತು. I'll intimate the concerned engineers.
24. Seal number 70 urgent, 71 urgent. Seal number 72, Sri Syed Akbar Pasha. 21, respondent, Belage Mesh.
Wait, 10th on there.
Ramesh Kumar.
City has informed you and he asked for 10.
Not informed, it is a question of demolition of the building which your lordship can give a short date, at least Wednesday.
21st.
21st couple.
Friday. Seal number 72, Sri Syed Akbar Pasha.
Khata was not standing in favor of the petitioners, but that has been by order of Lord Annexure
opposing you?
H. Please note.
Who's opposing you?
Lord, it's my brothers, the respondent number 3 and 4. Not their their names also been incorporated, Lord.
I'll file your call for them.
This image accepts notice for respondents 1 and 2.
1 and 2.
Relist.
25th. 73 disposed, seal number 74, Sri Anu Paranelli.
No, that way for the petitioner.
Relist.
My lords, the matter may be taken up next week, my lords.
21st.
Interim order may be used.
Seal number 75, Sri B Ramesh.
My lords, last occasion, I found a judgment, my lords. It says that, my lords, once the master plan is changed, my lords, my lords, what your lordships a preamble while reading last occasion, my lords. My lords, this honorable court has held. Or subsequent plan has to be gone into.
What are the facts of this case?
My lords, here, my lords, as on KHB had formed a layout. My lords, sites were industrial layout, sites were distributed. My lords, one site has been allotted to the first petitioner, one plot. My lords, subsequently, my lords, the CDP of 2050 says that it's an industrial, residential converted to residential, my lords. Now, my lords, I made an application for sanction of the plan. BBMP has rejected my plan on the ground that it falls under industrial. My lords, it is an industrial site. Here plans cannot.
Remember telling him that if it is automatically.
Yes, my lords. That is the,
have to follow
yes,
this.
my lords. That is the judgment.
Sir, my instructions, sir, my admitted the layout is the approved and it was layout is a industrial layout. As on today, it is the sites are industrial sites. Okay. Therefore, my lord, so even if it is the master plan, it is shown as a residential zone. But the layout is and the site is industrial site remains as it is. The zonal regulations also, my lord, in the 3.16 says, my lord, if the layout plan is approved by the state government or BD or the other authority, that prevail over the master plans, what is shown. Now,
They will not say it will prevail. It will be a non-conforming zone.
Yes.
That's what 3.16 says. But if the the master plan itself is modified and this is made as residential.
Panel, it shows as a zonal the residential zone. But the fact that my lord, the industrial layout will not.
So then they don't have to seek for change of land use at all.
Well, my instructions are my that once if it is the industrial layout.
It was always an industrial layout site, but the moment it is made residential, without asking for your change of land use, they can use it for residential purpose.
Well, once if it is industrial site, they have to.
Now, Kanunal.
Well, the 3.16 itself says, well, even the master plan.
3.16 basically says, suppose in a master plan, you are earmarked it, let's say for agricultural zone. But the government has granted permission to set up some in a commercial activity. Then that permission will override your reservation. That is all it says. Nothing more than that.
Oh, that says, my lord, even if it is, we have sanctioned for the earlier, my lord, then it is comes the master plan. It earlier is prevailing.
No.
That is the my instruction.
Bifurcation is a different aspect. His argument is something different.
That is the division bench judgment, my lords, where
In view of that, my lord, the Vinayak House Building Cooperative Society, the Supreme Court said, my lord, they once it
My lord,
layout is approved, that cannot be
Correct.
changed.
In Vinayaka layout case, there is no problem.
my lords, that judgment is also
For
referred, my lords.
a particular purpose in the layout plan approved,
Yes.
you can't grant change of land use.
Yes.
Here, that is not the case. It was reserved for earlier earmarked for industrial purposes.
Yes.
Now by virtue of your zonal the revision of a master plan, it is now residential. So as on from that particular date, he can use it for residential purpose without checking for change of land use.
My instruction, as per this, my lord.
My lords, division bench also interpreted, my lords, Vinayaka. My lords, this is a single judge of this honorable coordinate bench, my lords.
You don't copy that.
Both Vinayaka has been, my lords,
What is your prayer in the writ petition?
my lords, to approve the plan, layout plan. Approve the plan, my lords, for putting up a construction by setting aside the
What
endorsement.
is annexure N?
My lords, annexure N. Endorsement, my lords, issued by the respondent corporation. my lord.
It was an industrial plot. Annexure K ಆದ್ಮೇಲೆ ಏನು?
My lords, cage 115, my lords.
Which is the regulation which requires your permission to bifurcate the plot?
Section 14. Bifurcation, there is a separate. There is in the zonal regulations, my lord, there is a provision for.
Zonal regulation.
Yes, ma'am.
1.397.
Regulation?
Chapter 6, my lord, Zonal regulation, chapter 6 in this book. That 6.2 Roman 3 million. Chapter 6 of the zonal regulation.
Page number ಯಾವುದು?
Page 709 ಬರ್ತದೆ ಈ book ಅಲ್ಲಿ. 6.2.
6.2 ಅಲ್ವಾ?
6.2 Roman 3 ಮೇಲೆ.
It's only conditions required. There's no bar. It says, in the case of all bifurcation, whether corner side or intermediate side, front side setback for the resulting side abutting the road shall be the same as that of the original side. So if a side is bifurcated, the front portion, even though it is a smaller dimension, the setback is for the larger entire plot.
Setback
That is one condition.
But here the
Second one is,
one submission, even if they themselves bifurcate the sides, that amounts to modification of the layout plan, approval layout plan. Because in the approval layout plan, we have mentioned the dimension of the each plots. If it is they themselves bifurcated, it amounts to
therefore, bifurcation, they talk about subclause 3, second portion. The plot or site which is a part of the subdivision plan or layout of scheme duly approved by the authority. May be
duly
further-
approved by the authority.
Yes, that is the housing board. May be further bifurcated with prior permission of authority. And the subdivided plot shall not be less than the prescribed size.
Yes.
That is all.
Yes. Here,
There's the prescribed size of 20, 30 or
here this industrial plot.
no, whatever it is, the resultant bifurcated plot cannot be less than the prescribed size. That is all.
Yes. But
Then the
here
third one is bifurcated plot shall not be less than 50 square meters. Bifurcated plot shall have a minimum of 3 meter access. The bifurcated plot shall have a minimum of 6 meter frontage. So even if there's a bigger plot, industrial plot, if they divide this, the setback abutting the road for that bifurcated plot will be the same. And the bifurcated plot shall not be less than 50 square meters.
Yes.
That is all.
Bifurcation, my lord, the only the duly approved by the authority.
So you'll have to approve it, that is all, provided these conditions are met.
These conditions are met one and they have to make the modification of the layout plan. for the
Exactly.
approval. Otherwise, it
This
may-
is a layout approved by the housing board.
No, the layout plan is on behalf of the housing board, it was approved by the BD.
Therefore, in those cases, the 6.2 subclause 3 will come into operation.
Yes.
The subclause, the third bullet point,
Yeah.
second bullet point, a plot or
Plot.
site.
Which shall part of the subdivision plan, subdivision plan or layout or scheme duly approved by the authority may be further bifurcated with the prior
all.
permission of the authority.
So they can always ask for ratification of the bifurcation.
Why not? They have not sought the permission. They themselves bifurcated and sold the subplots to some other person.
So if you refuse the permission now, what is the effect? There'll be 6 co-owners, so 1 plot.
Yes, they
You
have
don't recognize the bifurcation. So all 6 of them will have a sale deed. They can't utilize the property individual.
No, that individual plot, your lordship corrected, they divided. It is the industrial plot allotted to particular person. He, without the permission of the authority, he cannot themselves bifurcate it.
No, that's all right. Now, therefore, I'll direct you to consider their request for bifurcation according to the sale deed, if it's permissible. If it's not permissible, you will not permit it. That is all. Change land is ಬರಲ್ಲ ಮನೇಶ್. ನೀವ್ ಹೇಳಿದ್ರೆ ಅದು ಕರೆಕ್ಟ್ ಅಲ್ಲ ಅಂತ ಹೇಳ್ತಿರೋದು ನಾನು. That's why I asked him. It was an industrial, it was an area reserved for industrial use. But as per the present RMP, according to the present usage.
Is residential.
Zonal regulation, it is in the industry.
That is all.
Residential.
Usage.
Suppose tomorrow, the property that of yours is now classified as commercial, thereby permitting it for commercial use. You are staying in the house. You have an option. You can continue to use it as house. The regulations won't bar it. If you want to change the use, you can use it for the commercial activity also, without seeking for change of land use. That is what will be the situation now. When it was allotted, it was earmarked for industrial use. It was an industrial site also. But because of the revision of the master plan, they are permitted to be used for residential purpose. So either they can run the industry as before, or in the alternative, they can always shift and use it for a residential purpose. Here the question is they have bifurcated the plot. For that, they have not taken the approval. So they'll have to now consider the request for approval. Industrial side that portion I'll declare as illegal. But for bifurcation, since it has been done without the permission, they will consider whether the bifurcation can be made if so requested by them. I will say that that is not permissible. That's the
Layout, I will say it will not change.
if you had maintained as an industrial zone, then it is different.
Master plan and limit zone, he can seek the change of land for residential. Otherwise, there is a bar in the industrial layout for changing of the industrial site to the.
You are absolutely right. The problem is you amended the RMP.
Oh, the RMPL is the residential zonal, then he can seek for change of land use easily. Otherwise, there is a industrial site and residential or the commercial change of land is totally part of the state government and remove the act or the provision.
I'm not questioning you on that at all. When you change the reservation, is ended the benefit.
Zonal area was changed.
Then what is the purpose of changing the use?
But the industrial layout, it remain as it is.
You should not have revised the master plan then. You should have said, no, I'll continue this. Then until they took the change of land use, they could not use for residential purpose. Now that you permitted, then use it.
Change of plan is my permission, change of plan.
From the second master plan to the third master plan, you took a decision wherever there is a 40 feet road, you allowed across the road commercial use. That was not the original intent. Even in residential areas where they had that 40 feet road or 60 feet road, you permitted commercial activity. So if I had a house on that particular road, I became entitled to use it for a commercial purpose without approaching you for change of land use. Can you say that, no, I allotted you only for a resident purpose. You can't use it for commercial activity? That will be the situation as far as he is concerned. Bifurcation, I'll ask him to go and approach you and he will follow this 6.2 subclause 3 and pass an order.
Yes.
Number 76.
Appear for the petitioner.
Who sought for vacating?
The private respondents, my lord, they filed vacating. On the previous occasion, my lord, the BDA council said that they'll be filing their objections.
The list.
Your lordship, last time thought the direction to BDA to what is the status of their change of land use. My lord, the respondent, private respondent, they filed the application for change of land use. They belatedly they have deposited the cost of the paper publication. Now the objections are called for in the public from the general public. 3 objections are they filed the general public. The matter was placed before the committee, my lord, for consideration of the objection. That stage it was pending.
Objections
ಅಲ್ಲ ಅವರ ಹಾಕಿದ್ದ ನಮ್ದು ಅಲ್ಲಿ ಅಷ್ಟೇ ಬರೀ ಚೇಂಜ್ ಆಫ್ ಲ್ಯಾಂಡ್ ಯೂಸ್ ಮಾತ್ರ ಉಳಿದದ್ದು ಬಿಟ್ವೀನ್ ದ ಪಿಟಿಷನರ್ ಅಂಡ್ ದ ಪ್ರೈವೇಟ್ ರೆಸ್ಪಾಂಡ್.
Whatever it is you.
Yes, ma'am. Yes.
24. 77 adjourned. Seal number
Yeah.
78.
I'm the petitioner in this case, my lord. I filed the application for modifying the interim order, my lord. Earlier interim order, my lord. Early order granted interim order, my lord, maintain status quo, my lord. The respondent has issued the building license plan, my lord, to construct a building into the suit scheduled property, my lord. Thereafter, the petitioner approached the respondent to issue the additional modification plan, my lord. They have issued, my lord, after 2 months, they have withdrawn my modification plan, my lord. They are stating that I have violated the plan. They are stating that, my lord. Now,
This court said maintain status quo.
please, my lord. Now,
You want to construct.
no, my lord. I want to construct only interior work, my lord. Interior construction, my lord.
It is the same as in section.
Only interior construction, my lord.
You are forcing me to implead the engineers and then go against them. What is he challenging? Confirmation or the order and appeal? On what ground? Does he have a case for remand?
And ಮಾಡಬಹುದು my lords.
ಏನ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿಲ್ವಾ ಅವರು?
Objections ಹಾಕಿದ್ದಾರೆ. Objections ಹಾಕಿದ್ದಾರೆ. ಅಲ್ಲಿ my lords, what happened? The appeal took almost about a year to conclude. So ಮನೆ ಹಾಳಾಗ್ತಿದೆ ಅಂತ.
2 year in the construction stop ಆಗಿದೆ, my lord. 2 year in the.
What is the deviation? There is a provisional order.
Annexure L, my lord. Page number
ಪೂರ್ತಿ ಮುಗಿಸ್ಬಿಟ್ಟಿದ್ದಾರೆ. 2 ಫ್ಲೋರ್ ಮೇಲ್ಗಡೆನಾ?
ಇಲ್ಲ.
One floor.
1 floor ಮಾತ್ರ. Additional alteration plan ತಗೊಂಡು ಕಟ್ಟಿರೋದು.
My lords, it so happened, my lords, ground plus 3 ಕಟ್ಟಬೇಕಾಗಿತ್ತು, ಕಟ್ಟಿದ್ರು. Setbacks was violated. When we issued 248-12, my lords, he had already applied for a modified plan seeking for construction of an additional floor. That came to be allowed, my lords. So based on that, he went ahead with the construction. 248-123, then 356 came to be issued. He went before the Honorable Commissioner, my lords. That took about a year. So this got stalled. In the interregnum, my lords, he had constructed the 4th floor by taking some loans. So ಅದು ಇವಾಗ ಸ್ಟಾಲ್ ಆಗ್ಬಿಟ್ಟಿದೆ. ವಾಟರ್ ಪ್ರೂಫಿಂಗ್ ಮಾಡ್ಕೋತೀನಿ ಅಂತ is his and he lost before the commissioner also, my lords.
But the 4th floor is in accordance with the modified plan.
Modified plan ಇದೆ, my lords. But 248-123 is with regarding to the setback areas, not with respect to the additional floor. Additional floor ಗೆ modified plan ತಗೊಂಡ್ರು, my lords, which was issued by us, rightfully or wrongfully it was issued. But when there is 248-12 proceedings, my lords, the modified plan should not have been issued. But it so happened that he had already made an application earlier, before the 248-12 could be issued. The modified plan also came to be issued, 248 also came to be issued.
Simultaneous.
ಅಂದ್ರೆ with a lap, the 2-3 weeks gap ಅಲ್ಲೇ ಬಂತು, my lords. ಅವರು 248-123 ಚಾಲೆಂಜ್ ಮಾಡ್ಕೊಂಡಿದ್ರು. He went ahead with the construction of the
modified plan.
Modified plan.
Modified plan was withdrawn when?
After about 8 months.
Which he made part of the construction.
He had already ಇದು outer construction ಮುಗಿಸ್ಬಿಟ್ಟಿದ್ರು. Blasting ಮುಗಿಸ್ಬೇಕು ಅಂದ್ಬಿಟ್ಟು ಇವಾಗ ಅವ್ರ ಯಾಕ.
But how about setback violation? Which year is that construction? Is it within that 50% or?
Annexure L ಅಲ್ಲಿ ಇದೆ, my lords. ಇದರಲ್ಲಿ
When was the first plan granted to you? When was the first plan?
First plan, my lord, 2021, my lord.
21.
And the additional issued in 14/12/2022, my lord.
ಎಷ್ಟಿದೆ setback violation? Where is the provisional order?
That's the appeal order is at Annexure L, ink page number 57.
Provisional order.
Provisional order ಅವರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತಂಗಿದ್ದಾರೆ, my lords.
Every provisional order.
I will produce, my lord.
So even if I were to say that the construction made before you withdrew the modified plan is a valid construction, that setback violation will still remain.
Setbacks ಉಳ್ಕೊಂಡ್ಬಿಡುತ್ತೆ, my lords.
ಎಷ್ಟು ತುಂಬಾ ಜಾಸ್ತಿ ಇದೆಯಾ ಅದು ಎಷ್ಟಿದೆ?
ಅದು my lords, 248-1 ನಾನು ತರ್ಸ್ಕೊತೀನಿ, my lords. Tomorrow, day after tomorrow, ಸೋಮವಾರಕ್ಕೆ ಹಾಕೊಂಡ್ರು ತರ್ಸ್ಕೊತೀನಿ.
List.
Till date, my lord, construction, my lord, interior construction, my lord.
Trying to find a solution to you, but I don't know. You don't even know what is the setback violation. What is the extent?
ಇಲ್ಲಿ ನಾನು ಮೆಟೀರಿಯಲ್ ಹಾಕೊಂಡಿದ್ದೀನಿ, ಅದೆಲ್ಲ ವೇಸ್ಟ್ ಆಗ್ತಾ ಇದೆ. ಮತ್ತೆ ಚಿಕ್ಕ ಮಕ್ಕಳೆಲ್ಲ ಮೇಲೆ ಹೋಗ್ತಾ ಇದಾರೆ ಟೆರಸ್ ಮೇಲೆ. ಅದು
ಹೊಡೆದಾಕ್ಬಿಡಿ ಹಂಗಾರೆ, ಸುಮ್ಮನೆ ಬೇಡ ಅದು.
issued a plan, my lord.
Ground plus 3 ಕಟ್ಟಿದ್ರು.
No, I am trying to protect you, saying that the 4th floor can it be saved. But the problem is, even if I save the 4th floor for you, the setback violation, how will you get over that?
ಅವರೇ ಸ್ಪಾಟ್ ವಿಸಿಟ್ ಮಾಡಿದ್ದಾರೆ, ಎನ್ಕ್ವೈರಿ ಮಾಡಿದ್ದಾರೆ, ದೆನ್ ದೇ ಹ್ಯಾವ್ ಇಶ್ಯೂಡ್ ದ ಅಡಿಷನಲ್ ಆಲ್ಟರೇಷನ್ ಪ್ಲಾನ್ ಮಿಲಾಡ್.
ಅದೇ ತಪ್ಪು ಮಾಡಿದ್ದಾರೆ ಅಂತ ಅವ್ರು ಹೇಳ್ತಿರೋದು. Because of their mistake, I can say fourth floor will be valid, but subject to you rectifying the setback violation.
My lords, it is there in page 62, my lords, the violation report.
How can I condone the setback violation?
Average about 50% ಬರುತ್ತೆ.
But regularize ಮಾಡಕ್ ಆಗಲ್ಲ.
ಅದೇ my lords, we'll have to wait for the
Like this is 2021 ಅಂತೀರಾ?
2021, my lords.
How can you regularize?
ಅದೇ 25%, 50%, that is also pending, my lords. So ಅದು ಬರ್ಬೇಕು. That's at ink page number 62, last but one paragraph, my lords. ಮುಂಭಾಗ 87%, ಹಿಂಭಾಗ 23%, ಎಡಭಾಗ 45% ಮತ್ತು ಬಲಭಾಗ 60%. 60.
I don't think it can be rectified.
Setbacks ಮಾತ್ರ violation, but with respect to the plan ಇದೆ, my lords, with all respect, due respect, my lords, 4 floors plan ಇದೆ, but setbacks ಬಿಟ್ಟಿಲ್ಲ.
Is it possible for you to rectify that setback problem? If you can do it, then I'll consider protecting the 4th floor. But without the setback violation, I can't do much.
Subject to result of writ petition ಮಿಲಾಡ್ construction, interior construction only ಮಿಲಾಡ್.
Realist.
On the subject to result of.
Major problem solve ಮಾಡಿದ್ರೆ ನೀವು ಅದ್ ಬಿಟ್ಬಿಟ್ಟು ಚಿಕ್ಕ ಚಿಕ್ಕ ತಿರ್ಕೊಂಡು ಒದ್ದಾಡ್ತಿದ್ದೀರಾ ನೀವು. What will happen if I dismiss the writ petition? 4th floor 3 ಎಲ್ಲಾನು ಹೋಗ್ಬಿಡುತ್ತೆ. Concentrate on the whole building rather than on the 4th floor.
Mode matter. Serial number 1, Shri Narsim Raju.
Eviction notice was issued by the PBMP. And facts is Milan. In 2012, I purchased the property.
What is annexure A?
Annexure A Milan issued by the BBMP. Eviction notice. But it is my property. There was a Milan unauthorized construction. I removed it. Undertaken before this honorable court also. And even that was verified by the BBMP. Please. Annexure A. ನ್ಯಾಯಾಲಯದ ಆದೇಶದ ಉಲ್ಲಂಘಿಸಿ ನಿರ್ಮಾಣ ಮಾಡಿರುವ ಶೆಡ್ ಅನ್ನು ತೆರವುಗೊಳಿಸಿ ಖಾಲಿ ಮಾಡುವ ಬಗ್ಗೆ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಆದೇಶ ಸಂಖ್ಯೆ ಸೋನ್ಸು.
ಯಾವ್ದು ಉಚ್ಚ ನ್ಯಾಯ ಆದೇಶ?
It is annexure. Page 57 annexure K. 59 not para downal. Page 59 in the down. I made an undertaken before the honorable court to remove the structure. That I removed. But in last para, in terms of the order passed by the affidavit filed by the petitioner, subsequent inspection made by the property have been taken place on the direction of this court. Finally, it is submitted that except the washroom of the property till other temporary structures are removed, which was endorsed by the land council for the paying for the BBMP. It is needless to observe that the petition shall be bound by the affidavit dated 24/3/2022 and subsequent memo filed by this court. The respondent corporation is liberty to initiate such action only if the petitioner found to be deviating from the affidavit undertaken filed by the so and so. As per the affidavit, my lord,
You only undertook to remove the structure, isn't it?
structure estimate, my lord. That's only undertaken. It is my property.
Eviction notice ಏನು?
I'm awaiting instruction, but if my lordship is para page 59, the second para. The petitioner is directed to vacate the premises on or before 1/3/2022.
Okay.
Page 59 only.
Read the entire order in terms of the order itself.
In terms of the order dated 13/12/2021 and 17/12/2021, the petitioner has filed an affidavit that he is running the business in the temporary structure, business of storing and dealing in metal sheets in the property, which according to him is a temporary structure and not a permanent structure. He has undertaken that he would remove the temporary structure within 3 months from 22/12/2021, but has ingenuously stated that
It is only to remove the structure.
Unauthorized construction, remove it.
But when I am awaiting instruction, but the second para is, when I am unable to understand why they have written the petitioner is directed to vacate the premises.
Page 48, my affidavit
On or
kindly see.
before obtaining of license or plan, the second para.
ನೀವು ಅದನ್ನ ಈ ರಿಟ್ ಪಿಟಿಷನ್ ಮಾಡಿಫಿಕೇಶನ್ ಹಾಕೊಂಡ್ರೆ ವಾಸಿ ಅಂತ ಕಾಣ್ಸುತ್ತೆ.
That I will not kindly see page 48.
Maybe this is
48 ಅಲ್ಲಿ. But that orders have been complied. Removed it.
Vacate ante, why did you use the word?
ಅಲ್ಲ ಮಿಸ್ಟೇಕ್ ಯೂಸ್ ಮಾಡಿದ. ಕೈಂಡ್ಲಿ ಸಿ ಮೈ ಅಫಿಡವಿಟ್.
That is maybe coming.
48 ಅಲ್ಲಿ ಅಫಿಡವಿಟ್ ಕೈಂಡ್ಲಿ ಸಿ ನಂದಿರೋದು. ನಾನು ರಿಮೂವ್ ಮಾಡ್ತೀನಿ ಅಂತ ಅಂಡರ್ಟೇಕನ್ BBMP ಇನ್ಸ್ಪೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ, ರಿಮೂವ್ ಮಾಡಿದಂತ ರಿಪೋರ್ಟ್ ಹಾಕಿದ್ದಾರೆ. ಅಲ್ಲಿ ಒಂದು ವರ್ಡ್ ಮಿಸ್ಟೇಕ್ ಅನ್ನ ಯೂಸ್ ಆಗಿದೆ, ಅದನ್ನ ಯೂಸ್
Kindly have it
ಮಾಡ್ಕೊಂಡು
on
issued
Monday,
eviction
my lord.
notice.
Kindly have it on Monday, I will take
Ask them not to do anything. Consider making an application that dispose of writ petition.
That certainly not, that is certainly not, but my undertaking is only to remove the structure. That I removed it.
Can I say that order is bad in this writ petition?
No, that is not.
Then
But
consider,
not, they misunderstood that. That was done, everything I have done.
and you want me to interpret that order in this
No,
writ petition? Monday.
till then not done.
In Madala.
I will.
Cell number 2.
Some,
So long as he is there,
because not some instigation is there, not.
so long as he is there, I'm safe.
Some instigation kind, some
Tell
judicial,
them you want me to pass an order.
some judicial order, not because some instigation is there. Otherwise, 22 dispose of the petition, now they have issued notice.
Let us go till Monday.
Please.
Cell number 2 for orders. Sri Sadhana.
Give it again.
Hand delivery.
Give it.
Give it illa. Give it.
Your Lordship,
Give it has been served.
this is second round of litigation. Earlier there was defect.
Something about
ಏನಿಲ್ಲ.
activities.
I've called for the records, WhatsApp ಅಲ್ಲಿ ತರಿಸಿದೀನಿ ಎಲ್ಲ. Letter ಕೊಟ್ಟಿರೋ.
What are you challenging?
Coming.
Not that. Hand delivery.
The previous council is.
ಮಾಡ್ತೀನಿ ಬಿಡಿ.
Please.
Kindly come to annexure A, my lord, what I've challenged before this honorable court. The annexure A is the impugned notice which is issued to me under 3 subclause 2 of the relevant rules, my lord. That is the Karnataka Gram Swaraj and Panchayat Raj against Adhyaksha and Upadhyaksha for no confidence motion. This notice, my lord, is issued convening a meeting for no confidence on 24/1/2025. And yesterday, by way of affixture, they have stuck it over my to be constructed building, my lord. So in gross violation of 3 subclause 2 of the relevant rules, my lord.
The AC got the notice dated 24/1/2025.
Please, my lord. So 15
Yes,
days
issued-
clear, 15 days clear notice has to be issued.
15 days from 30th of January 2025.
31st, sir, from the date I received the notice,
No.
my lord. Kindly,
I've already taken the view.
no,
that
kindly,
it
my
is
lord, your lordship judgment in running page number 27. Similarly,
No, there.
the lordship only has issued this order, my lord.
No, there 15 days there was lapse.
Earlier, similar notice came to,
15 days will start from the date of the notice.
No,
Of
my
the
lord.
Action Commission, not from the date of service.
no, my lord, if,
Other matters I have held, that not from the date of.
no, my lord, if I am not at all issued the notice, my lord, then if I have not received, what has also happened? They issued the notice
Okay,
through
answer
RP.
this question. Within 30 days, the AC has to convene a meeting.
No, from the date, the notice has been served upon.
From
my
the
lord.
date he receives the requisition.
Yes,
3(1) says 30 days,
please, my lord.
correct?
Yes.
So a smart member like you will avoid notice for 16 days.
No, my lord, I have not avoided.
No, smart, I'm giving you an hypothetical case. A smart member like you will not receive the notice for 16 days.
Please.
The moment 16 days is over, he can't convene the meeting because 15 days is over.
My lord, in
He
this,
has an out limit of 30 days. That is the overriding limitation.
that is true, my lord, and for that, my lord, another couple of judgments were also there, I have to be served, my lord. Now, the democratic process cannot be come in the way. Now, your own lordship's judgment, my lord, at running page number 30, they send me an RPID, my lord, with 5 blank sheets. And thereafter, they put one fixture, that too on the to be constructed house, not at my regular residence. And they say that on 21/2/2025, they want to convene this no confidence motion.
They have no confidence, they have no confidence.
No, that is true, my lord. Now 10 members also held captive. They have not come before the Gram Panchayat. Allah, and only
Why
one.
can't this writ petition, Sadhana do anything about that?
Allah, no, my lord.
I have
15
taken a
days.
specific view that 15 days notice is from the date of notice of the Assistant Commissioner, not the date of service of notice on the members.
Please, my lord, in the previous writ petition also similar modus operandi was used by the Gram Panchayat, my lord, as well as the members. Now, my lord, I am a lady. I have done sufficient work in the Gram Panchayat. The only idea is to see that out of 20 members, my lord, 10 members, if they don't come, confidence motion. The rest of the 4 or 5 members come within 30 minutes and say, I do not have confidence. This is the modus. They're trying to oust me, my lord. One opportunity may be given to me, my lord, because 15 days is not completed. This is my submission, my lord.
That 15 days argument won't hold. What have you said about that captivity business?
There's no.
Is there anything in the writ petition?
Yeah, I've stated, my lord.
Where?
Lordship may see form 1 which I produced.
ಅದೇನೋ captivity, I'm interested in that.
ಇಲ್ಲೆಲ್ಲ ಸೈನ್ ಇದೆ ಫೋನ್.
ನೋಡೋಣ.
Paragraph number 7. The said notice is a no confidence meeting convened on 21/2/2025 at 11 AM allegedly that the losing candidate of the elections of 2023 for the president post of the said Gram Panchayat being animically disposed of towards the petitioner herein has whisked away about 10 members of the said Gram Panchayat and kept them in illegal detention and custody for extraneous
Present on Monday or on Tuesday. No time ಇದೆಯಲ್ಲ.
Monday.
Panchayat, they're not in captivity, that this ground goes.
Tuesday.
Well, I'll take up a view even on that 15 days, but now, though there is 30 days time limit.
I am bound by my decision. I can't go beyond that decision.
No, my lord, your previous decision only, my lord, the
Previous decision was, in that case, for 15 days clear notice was not there
Yeah.
from the date of from the date of AC's notice. That's why I quashed that proceedings.
I will produce the previous notice also.
Tuesday or
Tuesday.
produce ಮಾಡಿ. Ask them to fill an affidavit saying that they're not in captivity.
The meanwhile, my lord, interim protection may be granted for the
But
notice.
21st is the.
Allah, now, my lord, the only idea is to see that I am ousted, my lord. See, this is the second round of.
They have moved the motion only for that to throw you out.
That's true, my lord.
Then what?
All that I'm seeking is that, my lord, let them not go ahead with the notice, my lord.
How? If they have no confidence in you and.
I am seeking it only till Tuesday, my lord, if the.
ಏನ Tuesday meeting ಆಗಲ್ವಲ್ಲ ಅಷ್ಟೊತ್ತಿಗೆ.
Meeting ಆಗಲ್ಲ. Now, my lord, in Tuesday, if I'm able to prove that, they're in illegal detention, my lord. Otherwise.
That's why.
Provisions ಎಲ್ಲೂ ಇಲ್ಲ ಅದು.
That
Let
is-
him give a complaint.
Because you're making the submission, asking him to keep present all the 10 members in captivity. Let us see if they come and say, no, we don't have confidence before me. I'll record that, then. ಇಲ್ಲ ನಿಮ್ ಕಾನ್ಫಿಡೆನ್ಸ್ ಇಲ್ಲ ಬಿಡಿ, ಯಾಕೆ ಸುಮ್ಮನೆ ತಲೆ ಕೆಡಿಸ್ಕೊಳ್ತೀರಾ? Nothing that you can do about it. This is democracy at work, isn't it? What else can we do?
That is true, my lord, but now, my lord, my humble submission would be, even this no confidence motion, my lord, it should be through the democratic process. Now, they come and, Allah,
A meeting is convened. There you will.
if your lordship holds that a fixture can be placed without following order, irrespective of the fact that it's a special enactment, my lord. Now, they just come and stick up a notice on my house and they say that you have been intimated.
Smart member, if he avoids notice for 15 days, he can frustrate this entire proceedings.
My lord, honestly, my lord, whatever has happened, I've brought it before the honorable court.
Nobody, the way practically it works is, they know they're moving a motion of confidence. The members think that by not receiving the notice, they can avoid the meeting. That is not the intent.
Absolutely not, my lord.
The rule only says the assistant commissioner is to give you a notice. It does not say they should be served. He'll give you a notice, whether you attend or not, it's your choice. Suppose it is served and yet you don't choose to appear. It's your choice. There's nothing can be done to, they can't force you to come.
No, I'm not on the part of attending the meeting, my lord. I'm on the part only about the clear 15 days rule, my lord. That's all.
That I have clearly already held, so I'll follow that and dismiss the petition. That is the only argument that you have.
But one Gita versus state of Karnataka is there, my lord.
Today, consider, I also considered other decisions that were furnished. Whatever you wanted to do it on Tuesday.
Tuesday, I'll give that, my lord. But till then, my lord, some kind of a protection for me.
That is a protection. They will get those 10 members. That is all. Tuesday.
One seal number 80 for further consideration. To Arun BM.
My lord, the needful has been done, my lord. This, my lord, pertains to, if your lordships may kindly recollect.
My lords, I appear for the petitioner. Yesterday evening, I received that notice. Your lordship's orders are complied with.
Lord, may this place of record, my lord. 18. Serial number 80, my lord. If I may be permitted to refresh your lordships. It was regarding that Khata, my lord, wherein there was some. That fraud. You were saying fraud. Yes. What have you done now? My lord, it is cancelled. Yes, it has been cancelled. Now, if at all they apply through that Sakala portal, my lord, the way in which they desire the Khata to be reflected, my lord, is. In around.
ಮಾಡಿದ್ದಾರೆ ಅದ್ರ ಮುಂಚೆ ತಮ್ಮ ಆರ್ಡರ್ ಆದ ತಕ್ಷಣ ಮೇಹಾಲ್ ಅಲ್ಲಿ ಟ್ರೈ ಮಾಡಿದ್ರು, ಮೇಹಾಲ್ ಅಲ್ಲಿ ಇಂಜೆಕ್ಷನ್ ಹಾಕಿದ್ರು, ಆಮೇಲೆ ತಮ್ಮ ಆರ್ಡರ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ ತಕ್ಷಣ ದ ಲರ್ನರ್ ಜಡ್ಜ್ ವೆಕೇಟೆಡ್ ದ ಇಂಟ್ರಿ ಆರ್ಡರ್, ದೆನ್ ಕಾರ್ಪೊರೇಷನ್ ಡಿಡ್ ಇಟ್.
Now, what do you want to do?
Okay, I'll withdraw the I'll kindly have it on Monday, my lords. I'll withdraw the petition.
Lord, instead of withdrawal, my lord, it may be disposed of. No, ಏನ್ ಮಾಡ್ತೀವಿ?
Please, my lord. I'm sorry.
My lord, the presence of the officers may not be required on, but let him come on Monday.
For hearing B group, seal number 81, Srimati Jatra Jayanarayan.
Lords, 81 is that batch matter, my lords.
Your Lordship, I
Lords, may
request the
have it,
matter.
next week, someday. This pertains
week,
to
Your
that
Lordship.
Moontree Mall, my lords, where encroachment of 2 acres is there. On a direction of this honorable court, my lords, we have inquired, we have conducted the inquiry. Detailed report is there, please, my lords, where 2 acres is encroached.
Interim order may be kindly be extended.
Yes. Can my lords give a date, my lords, someday? 19.
Date ಕೊಡ್ತೀನಿ ನೀವು ಟೈಮ್ ಕೇಳ್ತೀರಾ ನೀವು?
ಇಲ್ಲ, ನಾನ್ ಟೈಮ್ ಕೇಳಿಲ್ಲ, ನಾನು ರೆಡಿ ಇದೀನಿ.
Your
ಇವತ್ತು 4:45 ಹೆವಿ ಮ್ಯಾಟರ್ ಅದು, ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ ಮಾಡ್ಬಿಡ್ತೀನಿ.
ನಾನು ಕೂತ್ಕೊಳ್ತೀನಿ, ನಿಮ್ಗೆ ಬೇಕು ಅಂದ್ರೆ
ಇವತ್ತು
ಕೂತ್ಕೊಳ್ತೀನಿ. List.
19. So very well.
Seal number 82, Sri P. N. Rajeshwara.
Monday. Appear for the respondent. My lord, Monday, my lord. Yeah.
19.
Monday.
19.
Please.
Seal number 83, Sri D. L. Murthy.
I am for the petition in this matter, my lord.
It is ready, my lord. I'll serve it and will file it. I'll serve him. Monday or Tuesday.
Tuesday, my lord.
19th.
Wednesday.
20th, my lord.
20th.
Oblige, my lord.
Seal number 84, Sri Prakash. Please.
Every next week, my lords.
Seal number 85, Sri Umesh Emman.
Let's 16/1/2025. BK Manjunath was directed to take notice, but his name is not printed in the cause list.
ಮಹೇಶ್ ಅವರು
Illa Mahesh, he is not appearing for. There was an order passed by this honorable court on 16/1 to print the name of BK Manjunath. ಅವರು ಕಾಪಿನೂ ಸರ್ವ್ ಮಾಡಿದ್ದೀನಿ ನಾನು.
ಇಲ್ಲ, ನಾನು ಆರ್ಡರ್ ಮಾಡಿರೋದು ಸಿನ್ಸ್ ಎಸ್ ಮಹೇಶ್ ಇಸ್ ಅಪಿಯರಿಂಗ್ ಫಾರ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1, ರಿಜಿಸ್ಟರ್ ಟು ಡಿಲೀಟ್ ದ ನೇಮ್ ಆಫ್ ಮಂಜುನಾಥ್ ಅಂತ ಹಾಕಿ.
ಇಲ್ಲ, ಅದು ಉಲ್ಟಾ ಆಗ್ಬೇಕಾಗಿತ್ತು.
It is stated that by inadvertence on 7/2/2025, it is stated that Sri BK Manjunath does not appear for the respondent. In that way the matter. ಇವ್ರು ಇಲ್ಲ ಅಂತಾರೆ.
ಇಲ್ಲ, ಅವರೇ ಹೇಳಿದ್ರು ಫೋನ್ ಮಾಡಿ ನಾನು.
ನಾನು ಏನು ಆರ್ಡರ್ ಮಾಡಿದ್ದೀನಿ ನೋಡಿ. That will matter. It is also stated that BK Manjunath actually appears for R1. That will matter. The name of S. Mahesh be deleted and the name of BK Manjunath be printed in the cause list.
Tuesday, a small matter. It is only for issuance of e-Khata. Panchayat Khata, I am already holding it. They are refusing to issue e-Khata.
ಸರ್, ಇಲ್ಲಿ ಖಾತಾ ಅಂದ್ರೆ ಯಾರು ಏನು ಕೊಡಲ್ಲ ಇಲ್ಲಿ. ಖಾತಾ ಅಂದ್ರೆ they think that that's the best bonus.
Anytime subject to your lordship's convenience. 20th.
Seal number 86 adjourned. Seal number 87, Aishwarya Agde.
Lord, I have sought for a mandamus, my lord. Lord, petitioners.
Mandamus for what?
For entering, my lord, the name of the petitioner in e-Khata, my lord. Grant was made, my lord, as per Annexure D, ink page 35.
Consider ಮಾಡ್ತೀರಾ?
ಇಲ್ಲ, ನೋಡಿ, will pass. As per law and
ಒಂದು ಎರಡು ಫ್ಯಾಕ್ಟರ್ ಒಂದು ತೋರ್ಸಿ. Page 35, my lord. RTC entry. Page 35, my lord, is the order of regularization.
Yes.
Passed by the committee. Gangadharappa, page 35.
Gangadharappa.
12/4, 2 acre 20 guntas. Then, my lord, annexure is the, my lord, grant certificate. Page 40. Page 42, my lord, in the name of Gangadharappa bin Hanumantappa, Hendati Gangamma. My lord, thereafter, my lord, mutation entry was made in the name of the husband of the petitioner, annexure F, ink page 45. RTC ಅಲ್ಲಿ 98 ಅಲ್ಲಿ, my lord, page 46.
Then what happened?
Annexure G. Then he died on, my lord, 12/1/2001. In the meanwhile, my lord, the page 55, this area is included in the municipal limits, page 55, Gundapura village. As per on 11/7/2017. Now, my lord, I have given representation. E Khata dalli ನನ್ನ ಹೆಸರು after the death of my.
You want your name in the RTC first?
RTC ಅಷ್ಟೇ. E Khata. without insisting, my lord, the e-notification is, it's a prospective in nature.
ಅಲ್ಲ ಇದಕ್ಕೋದಕ್ಕೂ ಏನ್ ಸಂಬಂಧ? ಇದಕ್ಕೋದಕ್ಕೂ ಏನ್ ಸಂಬಂಧ?
ಅದಕ್ಕೆ ಅದು ಮಾಡ್ತಾ ಇಲ್ಲ. ತಹಶೀಲ್ದಾರ್ ಹ್ಯಾಸ್ ಇನ್ಫ್ಯಾಕ್ಟ್ ರೆಕಮೆಂಡೆಡ್ AC ಅವರು ಮಾಡ್ಬೇಕು.
ಸಭೆ ಅದರಲ್ಲಿ ನೋಟಿಸ್ ಇಶ್ಯೂ ಆಗಿಲ್ಲ ಆಕ್ಚುಲಿ ನಮ್ಗೆ ಸರ್ಕಾರಕ್ಕೆ.
What he says is, there's a notification of bringing this area within the municipal limits.
ಹೌದು ಸರ್.
So therefore, Revenue Department is saying, they'll have no jurisdiction to change the entries in the RTC.
No, because it's come to the ಇದು ಕಾರ್ಪೊರೇಷನ್ ಲಿಮಿಟ್ಸ್ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
ಇಲ್ಲ, ಮುನ್ಸಿಪಲ್ ಲಿಮಿಟ್ಸ್.
Husband did in 2001.
ಹೌದು.
As on that date, she was entitled to get her name changed.
Leave it your lordship.
The prayer in this writ petition is to direct the respondents to enter the name of the petitioner copy in the revenue records in respect to number 12/4, measuring 2 acres 20 guntas. It is a case of the petitioner that the land in question was granted to her husband, and as per the grant certificate, a copy of which is produced as annexary. Senior counsel points out that in the said grant certificate, the name of the petitioner's husband as well as the petitioner's name is entered. And subsequent to this order of grant certificate, the revenue entries were also mutated by annexure F, and her husband's name was reflected in the RTC. It is submitted that the husband of the petitioner passed away
On 12/1/2001.
2001. And despite requests made in this regard, the name of the petitioner was not mutated, though she was
ಮಕ್ಕಳಿದ್ದಾರೆ, ಬಟ್ ಹೆಂಡತಿ ಹೆಸರಿನಲ್ಲೇ ಗ್ರಾಂಟ್ ಆಗಿದೆ.
wife of the Khatedar. Then senior counsel submits that the revenue authorities are refusing to entertain the application.
ಈ ಖಾತಾ.
The premise that the area in question has now brought within the limits of the ಯಾವ municipal council ಇದೆ?
ಅನೇಕಲ್, ಗೌರಿಬಿದನೂರು.
Before the Gauribidnur City Municipal Council, and therefore not be permissible for them to entertain a claim for change of entries in the RTC. Next one. So long as the revenue entry stood in the name of the husband of the petitioner, obviously on his death, the revenue authorities are bound to enter the name of the legal heir of the Khatedar. Since the petitioner is the wife of the Khatedar, the revenue authorities would have to necessarily consider a request for mutating her name in the place of her husband. The reason, if any, that the area comes within the limits of the newly constituted Gauribidnur City Municipal Council cannot be a reason for refusing to entertain the claim of the petitioner. The respondents are therefore directed to
Assistant Commissioner is the authority
of the petitioner for getting her name entered in the revenue records.
ಈ ಖಾತಾ
Case of her husband M. Gangadhar. ಈ ಖಾತಾ ಕೊಡೋದು ಇವರಲ್ವಾ ಮುನ್ಸಿಪಲ್
ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಲ್ಯಾಂಡ್ ರೆವೆನ್ಯೂ, ಇದು ಅಗ್ರಿಕಲ್ಚರ್ ಲ್ಯಾಂಡ್ ಆಗಿದ್ರಿಂದ ಸ್ಟಿಲ್ ಮನೋಡ್ ರೆವೆನ್ಯೂ ಅಥಾರಿಟೀಸ್ ಓನ್ಲಿ ಹ್ಯಾವ್ ಟು.
That is the regular revenue entries.
ಹೌದು.
ಈ ಖಾತೆ is only by the
ಮುನ್ಸಿಪಲ್ ಕೌನ್ಸಿಲ್.
ಈ ಖಾತಾ ಅದನ್ನ ಕಂಪ್ಯೂಟರ್ ಎಂಟ್ರಿಯಲ್ಲಿ ಬರ್ತದೆ.
ಅದು ಮುನ್ಸಿಪಲ್ ಕೌನ್ಸಿಲ್ ಕೊಡ್ಬೇಕು.
ಇಲ್ಲ, ರೆವಿನ್ಯೂ ಲ್ಯಾಂಡಿಗೆ ಕಂಪ್ಯೂಟರ್ ಎಂಟ್ರಿ.
computer
RTC entry.
He said exception undertaken complete within a period of 2 months from date of receipt of copy of this order.
Number 88, Sri Radhanandan BS.
That parallel RTC's case, my lord.
In case,
the ಎರಡು RTC ಬಂದಿತ್ತು, there was assistant commissioner was directed, now it is set right. Now there is no impediment for the planning authority to issue the
ATM.
ಮೂರನೇ ದಿನ ಸ್ವಾಮಿ ಬಂದಿಲ್ಲ ಅವರು.
ನಾನು ಅವ್ರು ನೋಡ್ಕೊಳಕ್ಕಾಗಲ್ಲ, ನಿಮ್ ಜವಾಬ್ದಾರಿ. If you want an order, get him. List.
ಅಲ್ಲ,
he is supposed to come for another case. I think he is also waiting.
I'll also wait some. I'll wait.
Call him. Get him or else he will not come.
He is on his legs in 28 minutes.
ಆಯ್ತಲ್ಲ 5 ಗಂಟೆ ಆಯ್ತಲ್ಲ, ask him.
Cell number 89, please. Vishesh Kiriram.
For the respondents, my lord.
The matter, my lords, where previously assessment has been made.
Kindly place some short accommodation for statement of objection, my lord.
ನೀವ್ ಯಾರಿಗೆ?
My lord, for the respondent number 1 and 2, my lord. My lord, we have not got the information as of now, my lord. Kindly a week's time may be granted for this.
What is the prayer?
Lords, a assessment notice, my lords, has been issued by the ARO, my lords. Lords, kindly see, this is the issue in controversy. The assessment starts from 2008.
Let them get instructions or else I'll have to impose some condition if you want an interim order.
Lords, I'll just point out, the assessment has already been done, I've paid. This is all I wanted to point.
Order, realist.
No precipitative. Let there be no precipitative action. That's all I had to.
ನೋಡೋಣ ಏನ್ ಮಾಡಲ್ಲ ಬನ್ರಿ. ನೀವ್ ಇದ್ದಾಗ ಮಾಡಕ್ ಬಿಡ್ತೀರ ನೀವು.
Cell number
There is
90.
some express direction, not otherwise.
Let us see, wait.
Cell number
Is
90.
there a date fixed, not so that?
27.
ನೋಡಿ, one submission. Sorry, ನೋಡಿ, ಈ ಖಾತಲ್ computerized entry.
RTC ಅಂದ್ರೆ ಒಂದೇ ಬಿಡಿ, ಇವಾಗ ಇರೋದೇ ಒಂದು RTC.
ನೋಡಿ, assistant commissioner is the authority who has to do it.
No, the Tahsildar has to do it.
Presentation given to the.
Please, oblige.
Number 90.
Preparing for the respondent.
Short accommodation. Short accommodation.
In prayer.
ರಿಪೋರ್ಟ್ ಹಾಕ್ಬೇಕಿತ್ತು, ರಿಪೋರ್ಟ್ ಫೈಲ್ ಆಗಿದೆ
Report
7/2/2024 ಗೆ. Based on this report, there is a 35% violation ಇದೆ ಈಗಲೂ
35.
ಕೂಡ. ಅದಕ್ಕೆ ಮುಂಚೆ 100% ಇತ್ತೆಲ್ಲ ಸೆಟ್ ಬ್ಯಾಕ್ ಅವ್ರು ಏನೋ ಮಾಡ್ಕೊಂಡಿದಾರಂತೆ ನಮ್ಮ ಇಂಜಿನಿಯರ್ ಮಾಜರಿಗೆ.
Inspection of the year
2013, my lords.
is ended for regularization, isn't it?
Please, my lords.
35% ಇದೆ 2012.
Where is the report?
There's the property in the year of 2006, my lords.
ಫೈಲ್ ಮಾಡಿ
What is the extent of the property?
30-40, my lords.
30-40 1,200. ಅದಕ್ಕಿಂತ ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಇದೆ ಅಂತೆ, 1,250 ಏನೋ ಇದೆ.
This
ಲಾಸ್ಟ್
petition is
ಪೇಜ್
filed challenging.
ಇಲ್ಲ, page number
Order of
2024 minutes is a schedule is my
challenging-
cell read.
Challenging the order passed, by challenging the order of the appellate authority by which an order of confirmation passed under section 248(3) has been upheld. The provisional order was passed on the premise
on 21/2024, annexure G, page 32.
Two.
premise that there was violations to the extent of 100% in respect of setbacks pertaining to the front, rear, and right side of the plot, and 60% to the extent of the left-hand side of the property. It is also alleged that there was 24.18% deviation in respect of FAR and 75% in respect of the coverage. This court, in the pendency of this writ petition, directed an inspection to be conducted. Accordingly, ಏನಾದ್ರು ಹೇಳಿದ್ರೆ ಹೊಡೆದಾಕ್ತೀನಿ ಅಂತ ಅವರು.
ಹಾ, ಅಲ್ಲ ಈ ರಿಪೋರ್ಟ್ ಮೇಲೆ ಏನು ಹೇಳಲಿಲ್ಲ, ಬಟ್ since it was pending before this court, we have not passed any report. We have said what is the deviation is just now. Commissioner order ಆದ್ಮೇಲೆ 356 notice one issue ಆಗಿರ್ಲಿಲ್ಲ. By the time this court has granted an interim order.
This court passed an interim order on 20th of January 2025, taking note of the submission of the counsel of the petitioner that without conducting a spot inspection, findings had been recorded by the authorities regarding setback portions. This court accordingly directed the BBMP to conduct a joint inspection on 28/1/2025. The presence of the petitioner submitted a report. The joint inspection was conducted according to the said order. The report has been filed, in which it is stated that the average violation is only to the extent of 35.84%. It is therefore clear that the violations pointed in the provisional order and the violations now recorded are vastly different from each other. It is also stated that the construction in question was of the year 2013,
Plan ಕೊಟ್ಟಿರೋ 12 ಅಲ್ಲಿ.
was of the year 2012-13. The counsel for the petitioner submits that he would be entitled to seek for regularization since the premises in question is a residential premises and the percentage of deviation pointed out was less than 50%. if the apex court holds the provision which permits regularization. So in that view of the matter, the impugned orders would not be sustainable. Firstly, because there's a vast difference between the provisional order and the report that is now produced regarding the extent of violation. Secondly, since the petitioner may have the right to seek for regularization if the apex court upholds the provision for regularization, that right of the petitioner to seek for regularization cannot be frustrated. So the impugned orders are therefore quashed. So in the event the apex court upholds the provision regarding regularization, petitioner will be entitled to seek for regularization. If however the petitioner fails to secure the regularization, either because the apex court nullifies the provision or the authorities find that the violations cannot be regularized, fresh proceedings can be initiated by the BBMP. WP is accordingly.
For 91. Appearing for the petitioner.
Appearing for the respondent, my lord. Kindly place some short time, my lord.
Lord, we have filed a writ petition seeking exemption of property tax. They have demand on 3 grounds. Firstly, we are an education institution not liable to be taxed.
You have an interim order.
Interim orders. Date? Date?
Passed over matter.
Date mention.
That's, seems like that he's held up in 28 months. Monday, my lords. The reason being, my lords, now there are multiple complaints filed against me.
Monday.
Monday, orders list. Orders list.
ಬರುತ್ತೆ 4:15 ಯೋಗೇಶ್ ಬರ್ಬೇಕಲ್ಲ ನಾನು
Sir, serial number 91, you have date, sir? Sir? Sir, serial number. Sir, 91.
ಸಾಹೇಬ್ರು ಹೇಳಿದ್ರೆ ಮಾತ್ರ 4:30.
Sir, serial number.
ಅಲ್ಲ 4:30ಗೆ ಅವ್ರು ಬರೋದು ಒಂದಿದೆ ಇರುತ್ತೆ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಮೆನ್ಷನ್ ಮಾಡಿ ತಗೊಂತ 4:30.
Sir, serial number 91 date. Sir. Sir, 91 date.
91 ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆ ಅಲ್ವಾ 25. ನಿಮ್ದು ಅಡ್ರೆಸ್ ಅಲ್ಲೇ ಇರೋದಲ್ಲ ಅದ್ರ ಹಂಗೆ ಬರುತ್ತೆ ರೀಲಿಸ್ಟ್ ಹಂಗೆ ಬರುತ್ತೆ. ನಿಮ್ದು ಬಿ ಗ್ರೂಪ್ ಇದೆ ಇಲ್ಲ ನಿಮ್ದು ಬಿ ಗ್ರೂಪ್ ನಿಮ್ದು ಅಡ್ರೆಸ್ ಅಲ್ಲೇ.
Sir, serial number 89.
27.
27. And sir, serial number 56, did both the parties appear, sir?
So dismissal was withdrawn.
Allah, both parties appear.
No, in morning itself, they filed a memo for withdrawal.
Find the memo for the bid. Okay.
Sir.
ಮಧ್ಯಾಹ್ನದ ಮೇಲೆಲ್ಲ ರಾಹುಲ್ ಹಾಕ್ಬಿಡಿ ಇವತ್ತಾ ಯಾರು ನಿಂತಿರ್ತೀರ ಅವ್ರು ಹಾಕ್ತಾರೆ. ಓಕೆ ಅವ್ರದ್ದೇ ಹಾಕ್ಬಿಟ್ರಿ ಅವ್ರ ಓಕೆ ಸರ್ ಥ್ಯಾಂಕ್ 88 ಸೋಮವಾರ ಅಲ್ಲ ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ
ಮಾಡಿ ಕಳಿಸಿ.
ಒಂದೇ ನಿಮಿಷ. ಅದೇ 53 and 88 ಅಂದು ಎಂಟ್ರಿ ಮಾಡಿರ್ತೀವಿ ಅದು 53 ಆಮೇಲೆ 88 ನಾವು ಬರ್ಕೊತೀವಿ ಅದೊಂದು ಇಲ್ಲ ಇಲ್ಲ ಬೇಡ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಹೋಗ್ಲಿ ಬಿಡಿ ಅದು ಇಲ್ಲ ಬಿಸಿಲ್ ಮಾಡಿ ಅಂತ ಹೇಳಿ ಮಾಡಿ ಅಂತ
91 ಅಂದ್ರೆ ಬರೆಯಬೇಕಲ್ವಾ?
ಇಲ್ಲ ಇದೊಂದು ಇದು ಡೇಟಾ ಕೊಟ್ಬಿಡಿ ಅವ್ರು ಮತ್ತೆ ಬಂದು ಮಾಡ್ತಾರೆ ಇಷ್ಟು ಕೊಡ್ತೀನಿ
91